Good morning, good morning, good morning, amazing Law Nerd. We are getting well into March. It's March 12th. It's day 13 of the Kouri Richins trial, Utah versus Kouri Richins. We may be on the state's last witness, but we left off yesterday with a bit of a cliffhanger of an evidentiary issue because the defense was getting into a line of questioning with the investigating officer, who I call IO or lead investigator or case agent or in charge but not in charge, whatever you want to call them, O'Driscoll. And the defense was getting into a line of questioning at the end of court yesterday that seemed to insinuate that maybe Eric Richins was the one sending the GIFs, the GIFs, the memes, the I'm so rich of it all. And that was an odd insinuation that immediately rendered an objection and a sidebar and then the end of the day. So what is going to happen with all of that this morning? I imagine, well, we didn't see them put anything on the record yesterday, so I imagine we'll have to see them putting that on the record today. And then we should be getting back into the rest of O'Driscoll's testimony. And then I think we will see the defense making their motion to dismiss at the end of the state's case, which is what happens at the end of the state's case on every case, unless somebody represents themselves and doesn't know they're supposed to do it. And then into the defense case, and the defense said they had multiple witnesses in the wings. So will the state rest today? Will they have a colloquy with Kouri Richins today about whether or not she will testify? Will the defense begin their witnesses that are not Kouri Richins? Or is today the day that the defense is like, yeah, first and only witness, our client, which I would be very surprised because I think they have some other witnesses and some experts and things. So what do we think is going to happen? What do we think? I don't know. We're going to have to go to court and find out. So Law Nerds, I'm a little congested. The weather got me at the end of the day yesterday. And so it's just, if you're like, Emily, yep, it just is. It got me. It got me yesterday, but it'll be all good. So if I sound like it got me, well, it's because it's true. Let's roll the intro. Let's get to court. How you guys doing? It's been a long trial, but cheers. We're here. We're Law Nerds. We're ready to rock. Let's just go to court. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the Law Nerds in the chat. They're here for the facts, not and let's get to court. So when we get to court this morning, the jury was given a 8:30 a.m. local call time. So we're just going to see when the court brings the jury. I will do my best to not forget to get our air miles when the jury comes in. I've decided that flying when the jury comes in is our best bet. That seems to be a good way to work, and it seems to work well for me, and I'm happy with it. So we're going to zoom until court comes on the record. I should have queued this up to the tippy top of Judge M's head on the feed. See? And then we're a little bit behind because they will not go on the record until exactly the moment he calls the case. That's his media ruling.
May we begin?
How busy the court is fluctuates so greatly day by day.
Whether or not there's any legal discussion we need to have regarding the text message excerpt that the defense offered
from yesterday. All right.
During cross-examination of Detective O'Driscoll
that
at
makes
the end
sense.
of the day yesterday.
The volume sounds so low.
Yes, Your Honor, I think we do. May I stay seated so I can read my...
Of course.
Okay. Just 1 second.
Oh, Chad, I agree with you. Well, Kouri is in a suit jacket today.
Look at it.
I don't know if yellow would be the choice to testify, but she is in a suit jacket today. But the court volume seems awfully low to me.
So it's up on the screen right now. So it starts with
that's a bit
Bates
better.
number state, STATE, 0335281. And this was produced to us
That sounds better to me.
before the state went through and updated the time So this is on UTC time instead of mountain time.
Okay.
At some point
I mean,
in this
that's a
case,
problem.
and there have been so many supplemental.
Oh,
I think
Chad,
we're
I
on
didn't
our
even ask.
10th
Let me know what you're
exhibit
coming in
list. I
from
think
and what you're
we're,
drinking.
You know, anyway,
I've got coffee.
hundreds
Not
and
enough.
hundreds and hundreds and hundreds of alterations and substitutions. But this is the one we got
okay.
before they had changed the UTC time, which was confusing to everybody. And so they went back and redid that. This version, they had not changed it yet to mountain time. This is
Okay, then grab the other version.
a consecutively numbered, Bates numbered document. There's no pages missing. This is coming from a Cellebrite extraction of
Okay.
Eric's phone that was seized by Mr. O'Driscoll. We just found the Cellebrite and extracted by Miss Gibson.
Can you show me the
do you mean you
Cellebrite
just
Yes,
found
we
it?
we can, and we're pulling it up right now.
It's a very big file, so what I've done is I've emailed Katie the cover page.
That's
and I'm
Ramos.
working on the box download, so she can download
Yeah.
it.
Forgive me. And this is a nuts and bolts question.
Sure.
Forgive my
Just the-
ignorance. I'm looking at one page that shows 3 text messages total.
Right?
Typically, these are a complete string that has a Cellebrite header. Where is that version of this text?
So
Right.
not all of the ones we've introduced in this trial have the Cellebrite header. Only some of them,
I
not all
don't
of them.
know if, is that true? I thought
That's
all of them had the
No.
Cellebrite header.
No, that is not true.
Hold on, let's pause there for a second, because I think that's how we've been laying foundation for the admission of them so far. Foundation.
Right.
Mr. Bloodworth, is my memory correct? Unless they came from, I mean, we've had
Demonstratives.
CDR-related metadata regarding text messages.
But that's not
We've had
Cellebrite.
some non-bubble related or non-bubble depicted cell messages that have come out of other extractions.
But those are
in
from the
terms of
jail.
blue and green bubbles.
They all come from
I thought all
Cellebrite.
of them had a Cellebrite header.
Yeah, I
You
believe
are
that's right.
correct,
If-
Your Honor.
If we
You're correct. That's how I
prepared
remember
an
it as well.
exhibit that comes from a Cellebrite extraction, it has the Cellebrite header.
Right.
Right. Because that's how you know it's
There's
authentic.
others where we just, you know, we've got texts from other means. Somebody sent us forwarded this text, right?
Right.
But if
Screenshots, for example.
correct,
Yeah.
if it comes from a Cellebrite extraction, as best I recall, it has the Cellebrite
Right.
header.
Okay. Ms. Nestor, I'll give you the record back here in a second, but it's also unclear to me, is this 3 text messages that we're talking about, are they part of a larger exchange that has already been admitted?
So
I just need to note that the purple tie O'Driscoll is not going to make up for the I don't knows. It's not going to do it. The purple tie alone will not curry favor with the chat. The chat stands competence above all else. Competence before purple. The purple tie alone is not enough. Also, what is happening? Chat, you are all asking very good questions. Here is what the chat has clocked in 45 seconds of court. 1, the defense can't enter her own text messages into evidence because, as to her, they're hearsay. Correct. 2, why are they entering random texts that aren't part of a Cellebrite extraction? Exactly. 3, why wasn't this already handled? Don't know. 4, what are we doing? Maybe this is why yesterday the prosecution was like, where are these from? What are these for? And it seems that the court is also like, where are these from and what are these for? Because there's been so much fuckery that the court can't really just rely on a representation at this point.
these are all the text messages he had with Kouri on the day
3?
the day he passed, on the 3rd.
On the 3rd or the 4th?
He died early morning in the 4th, so it's from the 3rd.
Okay.
So
These 3 bubbles are the sum total of their text traffic on the
no,
3rd?
we have more than 3.
She said it's all, you just said it was all the
there's a couple
text
pages.
messages.
It's the last set of text that they, there's multiple, see, that's the second page.
Then that's not all. All means
Yeah.
my allergy medicine hasn't kicked in yet. It's too early.
And that's the last text that they had between the two of them before.
Can you go to that one, please?
Oh my God.
Katie, can you blow up the third one on that sheet?
The court is like, what are we
So,
doing?
As I understand it, among other objections that the state may have, the first one is foundation, correct, Mr. Bloodworth?
Yeah, where are these from?
Yeah, so that's the threshold objection.
Right. And as I understood it yesterday, the foundation objection was this is not what it purports to be because the daytime information is inaccurate.
Well,
Correct?
Sounds like that's part of it, but maybe not all of it.
Your Honor, the state's question as to whether this is what it purports to be, the genesis of that is that I noticed that the time is not corrected. And I would expect for the Cellebrite downloads that we have authenticated and laid foundation for, the time change is baked in,
Consistent
consistent across the board.
Right.
So the fact that this
Yeah, they
is still in UTC.
okay, just before Emily just gets completely off the rails frustrated. Scott's mustache is looking glorious today. So thank you for the close up of Scott's mustache this morning before the rest of the fuckery pops off. You can't just splice 3 text messages out of a Cellebrite extraction and just be like, we good, especially if they've converted the time differently. A, that's confusing and misleading. B, you would need your tech expert to do it. C, why are we still talking about this? The tech expert was on the stand like Tuesday.
-5 instead of UTC -6 or 7 just caused me to question where this came from.
The jury hasn't
Which
come in yet.
Cellebrite
They're just
download
doing
it came from.
legal arguments.
And I still don't know.
So that brings us to, is there a version of this that has the Cellebrite header?
that's what's on the screen right now.
And so if you would scroll through this extraction report and show me where it includes the portions that you want to use with this witness, just so we're all on the same page.
Just give us a second.
No problem.
It's very long, so we have to go right to it. Just give us just 1 minute.
No problem.
Control F. Just Control F it to the date.
Oh, are you on a Mac?
Of all the things that you have said in this trial, counsel, this is the one that's going to make me lose my fucking shit. The judgment, the shade. How dare you? Ma'am. Of course that's what you just said. Of course that's what you just said. War. Just declare war. You're just declaring war. Immediately. Chad is immediately like other people's PCs. I backed it up.
Oh, are you on a Mac? Oh, God.
Miss Nestor. For those of you that are like, I couldn't make out what she said, they're trying to jump to a place in the PDF, and she said, are you on a Mac? Oh, God.
Mac, so it may take a second.
Well, this discussion doesn't need to be had with me on the record in front of everybody.
Yeah, the judge is like, can you stop shading Mac? She's like, I'm a PC.
But if you can have it with each other first and then distill down what the dispute is, if any, regarding the foundation.
Yeah,
I understand there may be other objections that we have to get into.
And perhaps, Your Honor, we could work parallel while they're seeking out the foundation information, we could address well, a couple things. I think it's hearsay, as best I can tell. These are conversations between the defendant and Eric Richins. The state's
I can barely hear.
further objection is that it's beyond the scope of the direct.
Let's handle those one at a time.
Okay.
Ms. Nestor,
I do
regarding
not know why the
hearsay,
mics in court are so
your
loud.
client's statements are hearsay if they're offered by you.
Right.
Eric,
Chad, I'm teasing mildly as a diehard Mac user since way back in the day, sitting at my friend Tracy's house playing SimCity, and them being the thing that was in all of the schools that I went to. I have always loved a Mac, so don't get me started. Don't get me started on my love of a Mac. But yes, it was kind of funny. However, it highlights some of the unfiltered informality that's going on with Nestor in court that when the jury is in is frustrating, right?
Richins' statements are categorically hearsay if they're offered for the truth.
I have no idea.
What is the non-hearsay purpose
Why the volume
of
is so
these
low.
particular text messages?
So we are actually not interested at all in what is being said, and we could.
Okay, then it's not relevant. It feels like the court is not gained up at all. I've gained myself down a little bit, but it feels like the court is not, the mics aren't on yet.
Do an instruction to that.
I'll see what I can do.
Excuse me, to that effect. What we are trying to get in with this exhibit is a photograph that was sent on the day before. Technically, Eric died on the 3rd, and that was sent the day before. That is connected to the GIFs, whatever you say.
How?
That all got accessed the next morning at 8:30, which the state is making a big deal out of and mentioned in their opening and has called.
The memes are a big deal. So she's saying this relates to the meme?
Witnesses about it.
Provide a little more context. What is the photograph of and who is it sent by?
The photograph is sent by Eric to Kouri on the 3rd from when and there's been testimony that's come in that he was out there spreading gravel to make it look nice for the closing or whatever. And he sends her a picture of it while he's there before he gets home that night. That is one of the pictures that is connected to the GIFs that were accessed, the orphan GIFs, the next morning.
Says
at
who?
8:40 as soon as the police leave. And they're trying to make it seem like Kouri was celebrating he died with these happy GIFs. And it's connected because that picture was, the implication that's being made is that those GIFs were being sent or accessed or sent by or to Kouri the morning Eric died, when actually the picture that was also accessed at the exact same time came from the day before. So it doesn't mean that. And that's what we're trying to explain to the jury. All I care about.
How is Kouri going to testify? Also, if you're buying that much gravel, you're definitely not rich. How are you going to connect the two? And how do we know they were accessed at the same time? How? Ma'am, you are trying to make fetch, but I don't think that's going to happen.
Is the non-testimonial section of the interaction that shows he sent a picture on the 3rd, and that's one of these pictures that was accessed with these GIFs at the exact same time, and it was sent the day before. And that's all we're trying to do.
Why are you asking O'Driscoll about it?
In the bubbles, we can black out what's in the bubbles. I don't care.
You need the date and time.
Mr. Detective O'Driscoll, why didn't you do it through Mr. Kotradimos?
Yes.
I'm not sure Mr. O'Driscoll or Detective O'Driscoll has the ability to testify to any of what you just said.
Well, he testified that he reviewed Eric's communications the day before he died. He did testify to that.
Right, but this goes well beyond that and is far more technical.
All I'm asking him to do is say, did you see he sent her a picture the day before? The rest of
No,
it
that's
we'll
not.
do separately.
That's not necessary foundation for the argument that you're trying to make. This is a technical metadata-based argument that I understand why defendant believes it's relevant, and I'm not suggesting it's not. I'm just not sure it's this witness.
I'm not going to ask him about any.
Your Honor, you've already clocked it. They want to ask whose job it's not to make the illusion that Eric was the one sending those gifts. That's what they were trying to allude to yesterday. And I think there were probably some people who walked away from yesterday and is like, holy fuck, did Eric send those gifts? The idiots everywhere? Was Eric sending those? They want to allude to it without the requisite tech expert to explain that they weren't accessed at the same time, what the metadata says. They want to ask someone who just doesn't know. So the someone who just doesn't know goes, I mean, I guess I saw it in there, and then leave the insinuation out there.
The metadata. I'm going to say, did you look at Eric's phone the day before? Did he send this picture to Kouri?
But you need
all
the
I'm
metadata
asking.
for that.
Nothing fancy, nothing technical. He said he reviewed Eric's phone, that he looked at his communications. And we can even take out the metadata and just show the picture. That's all I
And
need.
what good does
The
that do?
picture's not relevant.
Well, the
You
meta-
need the date and time.
We have that.
Yes, Your Honor. Just let the judge
No,
do it, Emily.
We do need the date and time, but I'm talking about the, I thought there was more information on the bottom of those things. And we can
Why are
take
we
that.
doing this through Detective O'Driscoll rather than through another witness that can testify regarding the relationship between the file paths for the GIFs and the file path for this photograph?
Because he reviewed it and saw it. I mean, I think
Because he can't explain it. Because he can't explain it. That's why they're doing it through this witness. You've clocked this game.
he can testify to it.
You can't testify to any of the technical relationship that you're asking for.
Correct.
Right.
And we're not asking for that.
They just want
That's
the
all we're asking
insinuation.
is to say that the picture was sent the 3rd. That's all I need him to say. And he knows that because he reviewed it. So he's capable.
He knows what he saw. How does
Right.
he know that the picture was sent the day before?
Because it's on the face of it.
But then it's coming in for the truth, right? And so
But that's not testimonial evidence.
I agree. So if it's not testimonial and it's on the face of the text message, what difference does it make that Jeff O'Driscoll reviewed it?
Mm-hmm.
I'm not suggesting you can't get the evidence in. I just don't understand why it's coming in through this witness.
This is the witness we would like to bring it in through.
I don't know that this witness has foundation to give you the testimony you're asking for. What's the question you're going to ask?
The court's going to go fold these are not the droids you're looking for in a minute. Your Honor, you've clocked it. You continue to clock it correctly. She's allowed to try her case the way she wants to try her case, but you have to have the right witness with the foundation to do it.
I already asked him. I said, did you review Eric Richins' communications the day that he died? And he said, yes.
Okay. And then what's the next question you're going to ask?
Is this picture, was it involved in what he sent the day he died? That's all I'm asking.
You just want a yes or a no?
Yeah. I'm
Is
not
that-
asking him for
I'm
any
not sure that's
technical.
even in dispute. Go ahead, Mr. Bloodworth.
Let's never come out before on any other witness.
Okay. But go ahead, Mr. Bloodworth.
I didn't have anything, Your Honor.
Okay. Is there any objection to him just saying yes or no to that question?
If the yes or no to the question.
I mean,
of,
the insinuation is the
did he
problem.
review Eric Richins' text messages from the?
I think that's already been answered, yes
Okay.
or no.
Yes. Then what's the follow-up?
Did Eric Richins send a picture as part of those text messages?
And so if
Detective O'Driscoll says, based on my review, he did, period.
I still don't know if that is sufficient foundation to admit this.
Well, I'm not sure it's going to be admitted. I just think they're trying to lay foundation, I guess. Did you want to publish the photograph?
The court's like,
Ms. Nestor?
huh?
I do want to publish the photograph.
And tell me why the
Chad, I
photograph
disagree.
is
Photos are not hearsay.
Well, that photograph is already in as part of Exhibit 340, which
It's not in, but we've stipulated.
we've stipulated is coming in next. But I just want to show it's the same picture. That's it.
And forgive me, you're referring to an exhibit that hasn't yet come in.
We've
How is he
stipulated.
going to say they're the same
About to
picture if he doesn't have that info?
O'Driscoll.
And what is 340?
It's the list of all the pictures that were accessed that morning at 8:35 a.m.
What,
Why don't we just do it in the reverse order then?
I can do that.
I mean, we can see, Your Honor, I still think there's a hearsay problem. Based on counsel's explanation now, I also think there's a relevancy objection. The photo that we've been discussing,
The gravel photo.
the gravel photo, was not accessed at 8:39. It was accessed at 10:42.
Well, this is a foundation question, but the
Bloodworth is buffering. He's like, these weren't even accessed at the same time. So even the insinuation is bad. It's like, Your Honor, I can't do my assignment if they don't do theirs. Bloodworth is starting to buffer. He's like, you can keep trying to make these insinuations, but that's not correct. They had the tech expert on the stand twice. Bring the tech expert, ask about the metadata, but they don't want to because it goes against the insinuation that they're trying to make. And yes, the defense can do what they want to raise doubt, but you can't bring in metadata through an expert or through a witness, not an expert, who didn't review it.
The premise of the question Ms. Nestor is seeking to ask is, was this photo among the communications or sent by Eric Richins to Kouri Richins on March 3rd, right?
Yes, sir.
Full stop. I don't think that's fairly in dispute, right? And I don't think that's a hearsay issue.
I don't think a photo's a
I
hearsay
think
issue either.
publication's a hearsay. The fact that any photo was sent is fine. I think if we get into the specific photo that was sent, there's a hearsay problem.
Are you taking the position that the photo is a statement?
Yes.
I'm not sure that follows without
I don't agree with
additional
that either.
context. Just sending the photo it's evidence.
The
it's a
photo's
fact.
not
I'm not sure
hearsay.
it's a statement.
The statement is,
There might be
I
foundation
just dropped
issues.
gravel at the Midway Mansion.
Well, I don't
Is
think
that
any of that's
texted?
coming in. It's just the photograph.
But that's what the photograph says.
I don't understand. Is there text on the photograph?
No, Your Honor, but the
I don't agree with Bloodworth
the
here.
defense has, the defense is, as part of their case, said that Eric Richins was into the Midway Mansion
They're trying to make that insinuation. I agree with
as
that.
evidenced by him dropping
I
gravel.
want to come back to what I understand is
The court's
is
like,
being proposed by
focus.
Ms. Nestor through this witness. Detective O'Driscoll, did you review Eric Richins' text messages with Kouri Richins the day before he died, yes or no? I understand the answer to be yes. Did he send Kouri Richins a photograph as part of those text messages on March 3rd, yes or no? Yes. Is this the photograph that he sent? Full stop.
I'm fine with that. The only, I think there's a third option. It's not yes or no. It's I don't recall.
Oh, no,
an
fair
option.
enough. I'm not telling you how to testify, and I don't know what he'll say. But as long as you don't go beyond that, Ms. Nestor, and as long as you don't make any representations regarding time, date is fine.
Great.
Then we don't have a foundation problem. We don't have a statement that would be subject to the hearsay rule. I think the low bar regarding relevance is met in as much as the defense seems to be laying foundation or argument to come later regarding when images and file paths on Ms. Richins' phone were accessed. Any other nuances here, Ms. Nestor?
I don't think so.
Do you understand, do we have a common understanding of the limits of what you can ask Detective
Absolutely.
O'Driscoll without drawing another objection?
Absolutely.
Do you have an image of just the photograph?
I do, but I think if it's out of context, he won't. It's too hard for him to. I mean, I think it needs
You
to
can't
be.
show the text messages without provoking the hearsay problem.
No, not to the jury, just to refresh.
Oh,
Because
that's
I think it's got to be. He's not going to know. It's just going to be a weird picture.
understood.
Should we just go
Are
ahead
you going
and?
to publish the photo to the jury, though?
No.
Oh, okay.
So, we could just go ahead and admit 340
Of course they're
now.
not. Of course, they don't want to admit the photo to the jury because then the jury won't really know what it is, and it leaves that insinuation lingering a little bit longer. All right, y'all, I'm going to try to boost this sound just a little bit more. Give me 1 second while I try to try to grab that and see if it works. The pool feed switched links today, and it's not quite the volume that we had in prior court days, which is a lot. So give me, oh no, that's not going to work. All right. We're going to have to try something else because that, oh no, that's actually a little better. All right. We'll see. But it is, let's see if that has sufficiently boosted our volume while we grab that. So we're just reconfiguring things in real time because, like trial, streaming is dynamic. Yay! So let's see if that's a little bit better. But the defense is like, we're not going to publish it. We are going to publish it. We just want to show it's the same picture. They want to leave that insinuation that Eric sent the GIFs. But again, I think it just burns good faith with the jury. Show them that the things sent the day before were accessed that day, but do it with the tech expert and say, so you can't say when this was sent. You can only say when it was accessed. That's fine. But trying to get around it in this way is just not, I don't think that's going to go well.
Photo to the jury, though?
No.
Oh, okay.
So we could just go ahead and admit 340 now, because then the next question is going to be,
oh my God,
is
the
this
judge is
same
just like, what are we doing?
That is in this picture right here. And then we're done. Is this the same photo?
This is not a question for me. It's a question for Mr. Bloodworth.
No objection to admitting 340.
Okay.
I don't know that. Now, there's the follow-on. Is this the same photo?
Right.
That is akin to publishing the photo that brings up the hearsay problem.
You've made a record regarding the state's position that the photograph by itself is a statement subject to the hearsay rule. I'm not persuaded.
Okay.
And so, however, I don't know that just admitting 340 without providing the jury any testimony to provide foundation for context is going to be helpful.
I'll do
so
it.
is somebody going to tell them what 340 is?
I'll do it through him. I'll just do it through him.
Okay.
That's fine. We do have one other issue. If we're resolved with this, I think we're all clear. I know what I can ask and what I can't. I think we're fine.
Okay.
There's
What?
another issue. May I bring it up?
Please.
All right. I really need Officer O'Driscoll to leave the courtroom when we talk about this, because it's about specific questions.
No problem. Detective, if you'd take a step into the lobby, please don't.
Okay, so they're trying to bring in photos to say that they're both the same photos that Eric texted to try to raise the insinuation that the memes were in response to that. This was such a mess without the jury in. I can't imagine how messy this is going to be when the jury's back in. This is just a mess.
Talk to anybody while you're out there, sir. Thank you.
Okay, so now O'Driscoll's out. Chat, you know I'm
Okay. Thank you.
tired and feisty today, so I'm just going to make a broad general reminder, and then poor replay crew is going to be like, what the fuck is happening? Oh my God, here we go. You aren't going to believe what's coming up next. All of that is still spoilers. And today is just a yeet kind of a day. So if you guys are watching in advance, I understand. I like having Zoom room. But all of that is spoilers. We're just watching court happened. We're happening. So I appreciate it. Thank you. Don't yeet. Don't get yeeted. EDB is going to be fast on the yeet button. I don't know what's going to happen next in court, but oh my God, shit's going to happen in court is still a spoiler. We're just watching court. Thanks, guys. Appreciate it. It's been hard today.
This out of an abundance of caution to avoid
So
any
O'Driscoll's
potential. I'm trying to be very
Why is
careful to comply with the court's ruling on the motion in limine not the motion in limine. The motion to admit the statements of David Norris.
Who the fuck is David Norris?
Correct. Our motion to admit that was denied.
So,
Yes.
okay, then it was.
So just to.
Okay. So we're going back to motions in limine again?
So
Not.
correct. our motion to admit that was denied.
Yes.
So just to
That's a
make
motion
the
to
record,
eliminate.
the defense sought in advance to get approval to, or actually, we gave notice to the state that we intended to call a witness named Mr. Norris, who would testify if called, that on an occasion in 2019, I believe. In
What?
2019, he had an encounter with Eric Richins where Eric Richins asked him if he had any fentanyl.
What?
He had corroboration for the interaction, not the statement, but the interaction.
What?
With Mr. Richins, specifically the check that Mr. Richins had given him, the date it had cleared his checking account, and the invoice for the work he had done for him.
Wait, what?
Corey, but
Correct.
Wait, what?
The court
Did you hear what the court just said? The check that cleared the work he had done from him, and the court says, according to Kouri.
he had corroboration for the interaction, not the statement, but the interaction with Mr. Richins, specifically the check that Mr. Richins had given him, the date it had cleared his checking account, and the invoice for the work he had done for him.
or for Corey, but
Correct.
Oh,
The court did.
the work he had done for him, the court said, or for Kouri. So this individual might not have even done work for Eric. He might have done work for Kouri. The court said, or for Kouri. So the defense is saying that in a motion in limine, they filed a motion in limine to omit a statement of somebody named David Norris, because David Norris says in 2019, Eric Richins asked him for fentanyl. And they have corroboration for the interaction, but no corroboration for the statement made. Well, then that's why in motion in limine, this isn't coming in. So why are we talking about it?
The reason we were trying to introduce that statement, we were trying to get it through the catch-all exception to hearsay.
the residual.
The residual, I'm sorry, I call it catch-all, same thing. The residual exception to the hearsay rule, which requires a head notice, which we did give. The state objected to that coming in. The court ruled upon it, did the analysis under the residual exception, and made a finding that the defense could not call Mr. Norris to the stand
Right.
to testify because the residual hearsay exception requirements were not met.
Right. So then it doesn't come in.
It is my
Why
desire
are we revisiting?
with this witness to ask him the following 4 questions
You want to do what now?
about his investigation. And it touches on Mr. Norris's testimony, but it's a separate matter. But I just, out of abundance of caution, I am giving you a heads up.
Well, it was kept out.
So the first question is this.
So
You discussed with Mr. Bloodworth yesterday that the way you approached this investigation was to look for evidence based on 3 possible scenarios: an accidental overdose, a suicide, or a murder, correct? Question number 2. And in order to properly investigate whether there was an accidental overdose, certainly any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Pause there for 1 second. I got it right.
I'm sorry, I do have these if you want me to email them to you.
I know it's okay. Just give me a moment.
the court's writing down the exact wording of the questions, which means the court is thinking we're
prior
treading into precarious
allegations that Eric-
territory.
Any allegations that Eric had a prior history
This was denied.
of
Why are we?
seeking fentanyl
What?
would be potentially relevant and important to look into, correct?
Got it.
And this is the next question. Within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about about an incident where Eric allegedly asked someone for fentanyl? Want me to read that again?
How?
Sure.
and within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team
No.
information about an incident where Eric allegedly asked someone for fentanyl?
That's the substance of what was kept out. That's the substance of what was kept out in the motion in limine. The judge ordering that can't come in the motion in limine doesn't mean you can ask another witness. Didn't someone want to say all of this? Because then the prosecution could just come in and be like, well, detective, didn't you investigate that Hayden Jeff said that Kouri was asking him for fentanyl? Like, This was already ruled on. That question is completely inappropriate.
And then there's one more question. Let me know when you're ready, Your Honor.
We're never going to be ready. I'm going to try to boost the volume on this one more time so we can, I don't know, listen to the fuckery louder.
Investigative team. Give me the last clause one more time.
Who wanted to share with the investigative team information
kills
about an
the
incident
closed
where
captions
Eric
that so we can
allegedly
do.
asked someone for fentanyl.
All right,
Okay.
let's see if we can make it
And the
work that
final
way.
question is, did you or anyone else
Nope.
connected to the
Then we lose our
investigative
full
team
screen?
ever sit down with this individual and talk to them?
Well, the booster's better, but then we lose our full screen, and I don't know why. So
Did you?
I can't abide that, and it completely destroys the closed captioning. Oh, this is awful. Sorry, chat. The volume today has been just the worst. But also, it messing with the full screen is not going to work. We're going to keep troubleshooting in real time, but not that way. So let's see what we can do from here. I'm just going to leave those
You
closed
make any
captioning on for a
efforts
minute. I don't know why this destroyed
see-
our full screen. Sorry, guys. I have to refresh this feed because apparently it just broke. No, there we go. Broke the full screen, which is so weird. All right. Apologies.
If this individual was credible or had corroborating evidence to back up their claims.
Now we need our other closed captions
it.
back because these are too far delayed.
Mr. Blood.
No objection to the first question. Objections to the next three.
Yeah, those aren't proper questions.
This is a transparent attempt to circumvent the court's 807 ruling regarding Mr. Norris by casting some sort of inference that what Mr. Norris would have testified to is admissible. This setup has been long in the making. After the court issued its 807 ruling, Mr. Norris called the Summit County Sheriff's Office. Deputies interviewed him, and he said he was calling on behalf of, he was calling because defense counsel told him he should call.
Oh,
Maybe we just pause here.
what?
I don't know that we need to go into any of that. I understand part of your objection to be a lack of foundation.
I don't. First of all, isn't the jury supposed to be back in? Second of all, we can't manufacture a situation to circumvent the judge's rulings, which is what the prosecution is alleging, that the defense told them, well, call the sheriff's office. Also, you have to have a good faith basis for the question, and it has to be based on admissible evidence. And we teetered really close to that with some of those text messages, I think. But if you know it's not admissible, there's no basis for the question. It's not even foundation. It's just not admissible evidence. There's plenty of evidence in this case that's not coming in.
I don't know that we need to go into any of that. I understand part of your objection to be a lack of foundation.
That is the beginning, Your Honor.
I mean,
I think that's the beginning and the end of the discussion. There's no foundation for the premise of your questions 2, 3, and 4.
I'm sorry, but I don't understand. We have been produced a report from the Summit County Sheriff's Department confirming this call was made and confirming that there was no interview of this individual. It goes not to the credibility of the individual, it goes to the credibility of the investigation that they chose never to even speak to him.
I understand where you're trying to go, but it's
no foundation.
there's no
for the
basis
premise of your question. It's as if you could make up any set of facts and put them in the question. If there's no foundation, it can't be the premise of the question.
I'm sorry, but I don't understand what you mean by there is validation from the state that this call happened.
It's not that did you interview a person named David Norris. It's the substance that is the premise of the question. There is no foundation for the premise that Eric had a prior history of seeking fentanyl.
But that's not the way the question is worded. The question is worded is someone contacting you, asking to give you information about it, and you refuse to interview them.
That's not the question you asked. Read the whole question.
In order to properly investigate.
No. Go to number 2.
That is number 2.
I don't think I've ever seen a judge say, no, read your question again. That's exactly what the fuck you're doing. There is a line between zealous advocacy and whatever's happening in court right now. And we are finding that line. The judge is clocking it, but the amount of time it's taking up is wild. You can't just throw a bunch of shit into a question that has no, and the court's saying foundation, but no good faith basis that it is based on reliable evidence. Because then, as the court said, you can literally just say fucking anything in a question and leave the insinuation out there. Isn't it true that this Lexus shot off into space, got some fentanyl, came back to Earth, and gave it to Eric Richins? Didn't you investigate that? Didn't somebody call Summit County Sheriff's and say, I saw a Lexus shoot into space, grab some space fentanyl, bring it back down to Earth, and give it to Eric Richins? Didn't you follow up on that? No. So you didn't do a thorough investigation? Space Lexus? And that's where we are. And that's where we are. Can't you just say anything in a question and leave that insinuation in front of the jury? No, there has to be a good faith basis for the question. The court is saying foundation, but there has to be admissible evidence behind the question. And why are we reaching so hard? You had an IO on the stand all day yesterday. It's like, I don't know. This is preposterous.
Of seeking fentanyl.
But that's not the way the question is worded. The question is worded is someone contacting you, asking to give you information about it, and you refuse to interview them. That's
not the question you asked. Read the whole question.
I've never seen a judge say, read your question.
In order to properly investigate.
No. Go to number 2.
That is number 2.
My apologies.
And in order to properly investigate whether there was an accidental overdose, certainly any allegations, not facts, not nothing, just an allegation that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
It's in.
Let me ask you this.
Go ahead, Your Honor.
What would your response be if Mr. Bloodworth got up and said, certainly, detective, you investigated whether Hayden Jeffs had done all the stuff that I've excluded in my ruling regarding Hayden Jeffs? Would you be like, no problem, you can say that?
Accurate.
That's a fair question.
Accurate.
It would be reversible error for me to allow that question.
Yeah, it would be. The court kept out Hayden Jeffs' statements. Why? Because Hayden Jeffs had passed away. Unrelated to this case. And you know what Hayden Jeffs said? Because we saw it in the pretrial motions. Hayden Jeffs said that Kouri was asking him for fentanyl and for the Michael Jackson stuff. And he said, fuck that, and never took her calls again. And the court kept all of it out. And so the court's like, I've kept out stuff about your client. And if the prosecution got up and said, hey, Detective O'Driscoll, did you investigate further that Hayden Jeffs told you that Kouri approached him right before she approached Carmen Lauber and asked to get fentanyl? I'm buffering that this is happening. What a great example from the court. You want this to go both ways, counsel?
That's a fair question.
It would be reversible error for me to allow that question.
Uh-huh.
There were two residual
have a headache
exception
this early in
rulings
the
in
day.
this case. Let's be fair about it.
Right. That's absolutely correct.
But we want ours. We want it now, Your Honor.
So
We
is
want
there
ours.
a way, if we scrub
Is there
out
a
the
way?
reference
No.
to fentanyl and we don't get into the specifics of exactly what was said, because
Then
I
it's not
understand their
relevant.
concern about that and the court's concern, which is why we raised this in advance, which is why I'm trying to do the right thing here.
I appreciate it.
If we just said that an individual contacted them
It was ruled on in pretrial motions, Your Honor. I'm trying to do the right thing. It would have caused a mistrial.
with information about an interaction with Eric involving drugs, illicit street drugs, and
No,
they
it's the
chose
same.
not to investigate it at all. It does go to they've set forth this hypothesis that, well, we eliminated all other possibilities. And that's just not true. They didn't eliminate all other possibilities because they chose not to interview at least one person that clearly would have supported the first hypothesis, that he ingested it intentionally. So that's all I'm trying to get in.
But-
I am trying to get that in.
You may be trying to get a little bit more in.
Well, as much as I can possibly get in.
Okay, I'm not mad at this argument anymore. She made the judge chuckle. Ooh, Jajem. All right, I'm not mad at this argument anymore. My rage has been quelled. The judge is like, that's not what you're doing, though. That's not what you're doing. Okay, well, we're rewinding for the judge chuckling because it's the only thing that's going to simmer down my rage at this point. This is preposterous.
Clearly would have supported the first hypothesis, that he ingested it intentionally. So that's all I'm trying to get in. I am trying to get that in.
You may be trying to get a little bit more in.
Well, as much as I can possibly get in.
Fair enough.
But
This went an entirely different direction. You may be trying to get a little more. And she's like, as much as I can possibly get in. I mean, how did we end up from the wildest legal argument I've ever heard to fanfic on the second Audible account? How did we shift gears so quickly? I can't keep up. One more time for the giggle chat, and then we'll get back to this outrageous argument.
that he ingested it intentionally. So that's all I'm trying to get in. I am trying to get that in.
You may be trying to get a little bit more in.
Well, as much as I can possibly get in.
Fair enough.
But I do think it's fair game to
clocked.
say, look, you've got someone coming to your office saying he tried to buy drugs from me and I want to be interviewed, and they are like, no, thank you. I think I'm entitled to get that in. And
If they clocked that bro was a fucking liar, okay,
I'm willing to do it in the most ethical, careful, reliable, non-inferential way possible, but I do believe that's fair game.
She's like, Your Honor, I'm not trying to make an inference. I'm trying to just say the thing that you excluded in pretrial motions.
And I'm open to suggestions. Whatever I need to do.
You need to
These
adhere.
4 questions are not it.
You need to adhere by the court's ruling. I'll do whatever I need to do. Just adhere to the court's ruling then.
Game. And I'm open to suggestions. Whatever I need to do.
These 4 questions are not it, Mr. Bloodworth. You look
Fucking
like you
hell.
want to say something.
No, Your Honor, as I understand
I'm sure Mr. Bloodworth's head's about to explode.
the status quo is the
The
court's.
judge is now self-soothing by rocking
I
back and
guess the
forth on the
court has
bench.
sustained the state's objection to those questions.
I have. I think what Ms. Nestor is trying to ward off is another set of objectionable questions that are maybe more general, less specific, some version of probing the bounds of the state's
Investigation?
investigation
Right.
of the charges.
Your Honor, no. It's the same foundational objection, right? This is all to suggest that there is admissible evidence that Eric Richins sought fentanyl
Right.
before. And at bottom, there is no admissible evidence that he sought fentanyl before. And I don't think that there is any good faith basis to
That
suggest
part.
otherwise.
That
Or
part.
to suggest that any investigation into it was incomplete. Because the fact is, detectives, that Mr. Norris's narrative has been so thoroughly dispatched that there's no good faith basis to allude to an improper investigation, much less that there may be admissible
He's
evidence.
buffering. I don't think I've seen Bloodworth
respond?
buffer.
Yeah,
I don't think I've seen Bloodworth buffer like this. But Bloodworth is like, this has been thoroughly dispatched. And what are we even doing? This was dealt with in motions in limine.
hear me out for a second.
Sure.
Or let me make sure I understand the bounds of the argument here. You said there's no admissible evidence that Eric Richins sought fentanyl. My sense of the evidentiary record so far and the evidentiary record, or the universe of admissible evidence that's available, is that there's no admissible evidence that Eric Richins ever sought or received narcotics except through a prescriber. Correct?
Correct. The only admissible evidence that's already admitted
I think it's his knee surgery,
is
right?
a 2016 hydrocodone prescription following knee surgery.
Right, okay. Very good. Now,
Well,
by
then
the
that's what you have
same
to stick
token,
with.
I believe all the admissible evidence of Ms. Richins seeking or receiving narcotics of any kind is already in, correct? All is putting it strongly, but
Yeah.
That is, to the extent there was any admissible evidence of Ms. Richins seeking fentanyl, it's either in or it's not admissible. Let me say it that way.
That was me.
Or it would come in a rebuttal case.
Understood. Okay.
Right.
Which was the basis, among other things, of, not the basis, but is related to the court's exclusion of the offered statements of Hayden Jeffs to his sister.
Right. Right.
So Hayden Jeffs made statements to his sister as well. Not just his interviews. And those have been kept out. Wow.
So I do wish to correct Mr. Bloodworth's statement that we have fully dispatched Mr. Norris's proposed testimony. To the contrary, the court was very clear that you were accepting, for purposes of your analysis, that everything in the affidavit that Mr. Norris provided was true, and that you did the analysis, the court did the analysis based on the law of the hoops you have to jump through to come under the residual exception.
That
and
would
for
be at the
purposes
rules
of
of
your
evidence.
analysis, you did not go into an analysis of whether Mr. Norris's testimony was credible, not credible. You just said, I'm going to assume for purposes of this ruling that everything in that affidavit is true. And then I'm going to rule on whether it fits the residual exception. And the court went through a very thorough analysis and decided it did not.
Chat, did sound get a little bit better? I'm trying to gain it up a bit on my end because it's just different than it was. Let me know if that's a little bit better for you.
So I don't think that's a fair statement that he just made, that we fully dispatched it like there's nothing behind it. That's never been litigated in front of this court, nor have we asked it to be.
More than one way to solve a
The
problem.
difficulty here, though, is imagine David Norris were on the stand.
Right.
And you asked him, hey, did you ever contact the Summit County Attorney's Office or Sheriff's Office? My apologies.
Yeah.
He says yes. And then you say, what did you tell them? It immediately provokes a hearsay objection that I've already dealt with under my ruling on the residual exception.
Absolutely.
And
we don't.
if you want to elicit testimony that, did you ever speak to a gentleman named David Norris? Yes. And then move on, fine, but I'm not sure how that's relevant.
Well, that's meaningless to a jury unless I can say, was there a gentleman named David Norris who tried to give information that would have supported the first hypothesis?
But that's the hearsay problem.
And that's the problem.
But it's not being offered for the truth.
It's
being
100%
offered,
being offered
Your
for the
Honor,
truth.
if I may please, it's being offered.
No, because he clocked it and we're going round and round and round and round and round. And he clocked it and he clocked it and he clocked it again. It's 100% being offered for the truth.
For the same reason they've gotten in a ton of other hearsay in this case by the impact it has on how they did their investigation. They got that in through Woody. That's how they got in Amy and Katie's statements, because it wasn't for the truth of the matter that Kouri tried to kill him before. It was how it impacted her investigation from there on out. This is the same exact argument. It's how the fact that they got that information and chose not to even investigate it, how that impacted the hearer. It is irrelevant for purposes of the truth, and the court can instruct it like you've done over and over and over for their witnesses when we had this exact same argument.
If that's true, Ms. Nestor,
Yes.
then the 807 residual exception
Doesn't
wouldn't
matter.
exist, and it wouldn't apply.
That
It
part.
does apply, and so you can't use this argument to undermine that.
I know, that's why I'm trying not to undermine your ruling.
That's why it can't, the substance of what
What are
he
we
told
doing
the
then?
Summit County Sheriff's Office can't come in.
And I think I could maybe craft a question where we leave out the juicy substance and just say there was an avenue that you chose not to investigate. But I've got.
And that's exactly what they want to do. That's exactly what they want to do. The juicy substance. Whoop, there it is. The juicy substance is the reason you want to bring this in. Because you want the jury to think that in 2019, apparently, Eric Richins was out soliciting street fentanyl from someone. It's not what his liver says, ma'am. There are rules of evidence for a reason. And those rules of evidence have largely protected your client. So if you want to throw the gates of the rules of evidence open, first of all, it's error. But second of all, it's going to hurt your client more than anybody else. I cannot believe that she's genuinely confused here. That doesn't make any sense. That she's genuinely confused about this point.
Got to get something in context so the jury understands, hey, you have this road, you chose not to go down it. That was your choice.
I appreciate why.
You can ask about the investigation, but you can't ask about what the person said. Did you pursue other leads? Yes, and we found that they were bullshit. I mean,
why you want to present this to the jury, but there are limits
Right.
on both sides of the V about what gets presented to the jury. And those limits are in part defined by the Utah Rules of Evidence. And this substance cannot come in under the Utah Rules of Evidence. For the same reason that the state could not argue that we want to get in Hayden Jeff's statements to his sister just for the effect upon law
investigation.
enforcement in terms of the scope of their investigation. No.
Okay. And there's no scenario which we're going to be allowed to question him about choosing not to investigate this evidence.
There's no scenario in which it's relevant without the substance of the excluded communications. If a crank from New Jersey, I don't know why I'm picking on New Jersey, but I grew up near New Jersey, called the Summit County.
Wait, His Honor's from Jers? What's up, Your Honor? We're from Jers? Why are we talking about Jers? I'm here for it. Shout out New Jersey.
Out the substance of the excluded communications.
Everyone picks
If
on
a
New Jersey.
crank from New Jersey, I don't know why I'm picking on New Jersey, but I grew up near New Jersey, called the Summit
He said
County
near New
Sheriff's
Jersey.
Office and said, I was in Utah on that day and I saw it happen, and the Summit County Sheriff's Office chose not to investigate it. Would we be having this conversation?
That's not this circumstance, though.
It is the same, though, because that evidence has nothing to do here.
Your Honor, we have questions. Weehawken? Where are we talking about? Near New Jersey.
It's even worse
The judge is like, everything's legal in Jersey. It's fine. In Jersey, everything's legal. As long as you don't get caught.
because it's inadmissible.
That's not legal advice.
It's
Song
inadmissible
lyrics.
from Mr. Norris's mouth, but I don't think it's inadmissible, period, in terms of if it was part of an investigation that was ignored or not followed.
The substance is inadmissible. The fact that they spoke to David Norris as a fact is admissible if it's relevant, but without the substance, it's not relevant.
Right.
We have just a moment.
Oh, my goodness. Yeah, T brought me some additional caffeine. He had an appointment this morning and grabbed some caffeine for me. Also, the song I was referencing, I know a lot of you are like, Emily Hamilton, deeper cut than that, Traveling Wilburys. Traveling Wilburys is how deep that cut went. The judge, it's time for the judge to shut this down. I'm surprised we're still going around and around. I'm annoyed that we're still going around and around. The jury has to be either furious, thanks T, either furious or playing Midas Merge. I can't imagine how annoyed they would be. Hey, Trev, the defense attorneys are trying to make fetch happen. Fetch is not going to happen. I know. We need to watch Mean Girls again. All right.
Oh,
Yep.
I think we've made our record on that, and I'll
Only JoJo, EDB, your live streams are the only thing keeping me sane when the world is going bonkers. Thank you. I mean, we're just here doing law. I'm here for all of us just being like, la, 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 law. We could just focus on what the fuck is happening in this courtroom. But the defense needed a minute, and where are we at now? Your Honor, we made a record? Okay. Where are we at?
okay, Your Honor, I think we've made our record on that, and I'll, of course, respect the court's ruling on that.
Did co-counsel look at her and be like, you're cooked? Stop now? Okay, Your Honor, we made our record. So we're just, oh God. So we're just done? Okay. Okay. The judge is buffering. Your feed did not freeze. The feed did not freeze. The court's buffering.
Let me take a minute.
Why?
Let me just take 5 minutes.
The court wants to do
Thank you,
some
Your Honor.
research. Or is the court looking at something else?
Before I take a break, Mr. Bloodworth, anything further on this issue?
No, Your Honor.
Ms. Nestor, before we take a 5-minute break. break any other issues before you invite the jury in?
No, thank you, Your Honor.
Mr. Bloodworth?
No, sir.
Okay, I'll be right back.
The
Thank
court
you.
was looking at something.
All right.
The court was looking at something. I don't know if the court is doing other research or if the court was looking at something else, but the court says I'm going to take 5 minutes. This is why we have Zoom room. That was more than 5 minutes. All right, let's see what happens when the judge comes back in. Emily, what's happening? I don't fucking know. The defense is trying to sidestep, it seems, the motion in limine pretrial rulings to get into asking the investigators, but didn't somebody come to you and say all the shit that was excluded in pretrial motions? And then you didn't follow up on that to try to get into how thorough the investigation was. And yes, the defense can get into how thorough the investigation was, but you can't get into, but didn't somebody come to you and say blah, 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 blah. That was excluded. There were pretrial hearings on these issues, and some of them we did not see because a lot of it was sealed. So the court takes 5 minutes, and let's see what happens when the court gets back.
I've just handed you a copy of State versus McCullough.
Oh, the court go do research? It looks like the court might have gone and done some research.
Record at 231-500-139. Counsel, thank you for your patience. I've just handed you a copy of State versus McCullough, 2014 UTF 215. I need you to take 15 minutes, read this case beginning at paragraph 25. This case stands for the proposition that what the defense is proposing to do is required, but
What?
it raises the prospect of also allowing the state to rebut the defense's charge of an incomplete or improper investigation by also putting in evidence, not for the truth, but for the effect it had upon law enforcement, of how they received and reacted to Hayden Cheff's statements to his sister. Pause for a second.
So the judge has found his own case law and is like, well, defense, if you open this door, it gets opened with a wrecking ball. We either mention it all or we don't. So it is not a sword and a shield. It's a sword and a sword. It's a two-way door? Okay.
I need you all to be very thoughtful about this. I can't unring the bell once this information is out, and sitting here at the moment without the benefit of counsel's argument after reading this case, I think I'd have to let both sides of that story in to make sure that the state is not prosecuting with one hand tied behind its back.
Oh, boy.
Mr. Bloodworth, I cut you off.
Sorry, Your Honor. We looked at this case while you had stepped out. I think in addition to Hayden Jeffs, it would also cause us to revisit the court's decision yesterday regarding Mr. Bon Savage's phone call with an inmate at Gunnison.
Ooh, I don't remember the detail of that one. Forgive me. Oh, I think I do. Yeah, a little bit. Now, let's talk about foundational requirements. I gave this a little bit of...
The court is like, would you like to open the floodgate? Because if you open the floodgate, then you open the floodgate. Okay.
thought after rereading McCullough. There is some precision and some technicality into how these questions would need to be asked. For example, Ms. Nestor, you wouldn't just be able to put the substance of Mr. Norris's statement in a question and ask whether Detective O'Driscoll ever followed up on it, because you would not have laid foundation that he ever knew about it in the first place. You need to lay foundation
Oh,
about whether or
boy.
not he ever spoke to David Norris, yes or no. If no, did anybody ever relate to you that David Norris contacted the Summit County Sheriff's Office, yes or no? Yes. Okay, after that, what did you do?
This all would have been a lot shorter if the defense had just cited the judge to the case that the judge is now relying on. And I think the reason, sorry, that was a rude pause. I think the reason the court keeps doing their own research literally on the bench is because the defense is making arguments on vibes, and then the judge is like, where is the case law? But the judge is, I think, going above and beyond what a lot of judges would do and finding the law that may, in this case, it seems, support the defense's argument. Which also is baffling because now I want to read this case. We're not going to do it right now. But the judge is just like, look, this is not a one-way street. You don't just get into what you want. It opens up a whole fucking can of worms. I'm very curious about this case law and how it came up because, that could be a big old mess. This could be a tactical nightmare for the defense, or it could help. I worry that it will hurt more than help. And then at appeal, they're going to be like, well, that was a poor strategic error from trial counsel, but the defense wants exactly what the court is saying. The defense wants to get in what they want and not what the prosecution wants. Oh,
Followed
boy.
up on it because you would not have laid foundation that he ever knew about it in the first place.
Oh, this could be
You need to lay
giant
foundation
mess.
about whether or not he ever spoke to David Norris, yes or no. If no, did anybody ever relate to you that David Norris contacted the Summit County Sheriff's Office, yes or no? Yes. Okay, after that, what did you do? This information.
What did you do?
This statements being made by David Norris to Summit County Sheriff's Office have to come in through a witness with knowledge of them. I'm not sure Detective O'Driscoll's that guy. By the same token, to the extent the state would want to ask or show
Oh my God.
that the investigating officers or the Summit County Attorney's Office investigators followed up on statements made by Hayden Jeffs to his sister, Aubrey Jeffs, or information received or is told by Mr. Bondsavage, they're going to have to call a witness that had personal knowledge of those statements and then lay foundation for what occurred next. We can't skip steps.
Your Honor, agreed. There's a little more to unpack here, too. Because I happen to know that Jeff O'Driscoll's not the witness for this.
Shocking.
We would need time to prepare the witness for this. We also have the problem that
We meaning
the state.
The state. May I ask you just a procedural question before you keep going?
Yes, sir.
Imagine that at some point, imagine it's not Jeff O'Driscoll, as
Right.
you suggest.
Right.
And imagine in the defense's case, they find or call the witness who received the phone call or talked to David Norris. Or they call David Norris.
Sure.
And they ask, did you call Summit County Sheriff's Office? Yes. What did you tell them? Did they ever follow up with you?
Yes.
I imagine the state's response to this and the state's offering evidence regarding how it responded to information regarding the Hayden Jeff statements and the Nick Bondsavage statements, that would come in the state's rebuttal case. Is that correct?
I would imagine so.
Not necessarily, Your Honor. I mean, we haven't rested. I think
Fair.
we would like to get out in front of this before a rebuttal case.
Oh, we're going to front load that shit. If this is coming in, we've now circled all the way back to
Mention it all. Mention it all.
the state's like, oh no, we haven't rested yet.
Mention it all. Mention it all.
Bring it in. Bring it in.
And while the state has investigated David Norris's statements and to show how they're not credible, the state pulled up on investigating how Norris came about. And the state would want to continue that investigation.
I think I know what you're talking about.
Oh boy. Bloodworth is like, yeah, we think that this witness was seated by defendant or defendant's family. And sure, we'll dig into all of that and bring it all up that this was seated. That's what the state is insinuating in that. Oh boy. Well, I guess we'll see where this goes. For all of you just coming in, Emily, what's happening? Well, the wheels continue to come off, and the defense started the morning citing vibes, and the judge pulled case law and was like, well, if the defense wants to charge that this was an incomplete investigation because some dude, not Chuck Norris, went to the police and was like, hey, I know this thing, and they didn't follow down that lead, then they're allowed to bring in other evidence that has been kept out in pretrial motions to say we didn't follow up on this lead for this reason, and here are the other leads we followed up on. And so in the totality of all of the information that we have, getting back to the detective saying, well, that's not all I know yesterday, then we get back to, okay, but a bunch of this stuff was kept out against your client because it's for a variety of evidentiary reasons. And if you bring in that they didn't follow through on the investigation with Norris, which I think that they can poke at the investigation without doing perfectly fine. But if the defense wants to get into it, the judge is like, if it's coming in, it's all fucking coming in. And there's no unringing the bell. There's no putting the shit back in the horse. And what the defense can't do is get into what they want to get into and then try to block the prosecution from getting into it later, which is, I think, probably what the prosecutor thinks is exactly what's going to happen. Is the defense is going to like slip in the bit that they want and then try to block the rest of it because it was kept out in pretrial motions. So I think the state's worried about the takesy backsies. And the court is like, if it's getting unleashed, it's getting unleashed. Oh boy.
But in terms of how it came to be that David Norris contacted law enforcement when he did.
Correct.
I don't know that I have any authority or interest in ruling.
I don't think you.
Well, the state might want more time.
I don't think so. My only point in mentioning that is it would just take a little bit of time and it would be necessary. The other point, I think, well, the other objection the state has is under 403. I think in proceeding in this manner, it's both prejudicial and confusing the jury.
If I let in everything, though.
Right.
So Norris,
Full mention it all.
Jeffs, Bond Savage.
Mention it all. Mention it all.
Any unfair prejudice or 403 concerns? And when I say let it in, I mean as premise for questions regarding the scope
investigation.
of law enforcement's investigation, not for the jury.
I appreciate that, Your Honor.
I tend to agree with you if I let in only one side.
It's interesting because both.
Right.
That assumes that the weight of unfair prejudice or the weight of confusion is equal on both sides. The state, I don't think it is. I think because of the complete incredibility of David Norris's testimony and how David Norris came to contact law enforcement, that prejudice and that confusion is much weightier than confusion related to recorded interviews with Hayden Jeffs while he has counsel and a recorded jail phone call. There is no doubt.
Doesn't that weigh in the state's favor, though?
No, Your Honor, because
Wouldn't it?
I guess the question is whether it's unfair prejudice or confusion. Confusion, it doesn't, David Norris's the purported effect on law enforcement of David Norris's is even way more confusing than the effect, just because the information
wouldn't that
provided to
benefit
David Norris
the prosecution?
is highly in doubt and would be highly litigated, whereas the information Hayden Jeffs provided is recorded. There is zero
Would be
doubt
too much time spent.
about what he provided. And the information that Nick Bonsavage provided is recorded. There is zero doubt. We're not bogging down into some mess
A
of
trial
who
within
said
a trial.
what when.
Is when you say the information, you mean the substance of what David Norris told
You guys
Summit
did this
County
in
Sheriff's Office
pre-trial.
a number of weeks ago?
Correct.
Okay.
Because it's changed. It has changed over time. We have affidavit number 1 from defense, affidavit number 2 from defense, phone call from David Norris, interview of David Norris. What David Norris says is a moving target, and it is a moving target based on when he speaks with defense counsel.
Forgive me. What is your understanding of the evidentiary landscape as to how many times David Norris has contacted the Summit County Sheriff's Office? Is it once or more than once?
I think he's had 2 contacts. Once he spoke with a patrol deputy to take kind of the initial, well, I guess there's once a call into dispatch, which was non-substantive.
Okay.
Then there was an initial contact with a patrol deputy, and then there was a contact with a detective.
Okay.
And then we have the affidavits that he'd submitted, that defense has submitted in the 807 litigation.
But those were submitted here, right, as part of the 807 litigation. Did those ever go to Summit County Sheriff's Office?
I don't know one way or the other.
If it's no, then those don't get shown to the jury, right?
Well, no, but the statements are, he's saying the
We just laid out
statements are a mess.
facts in our motion.
Okay.
It's a profit.
I'm familiar with what you're referring to. I'm a little less clear on
Sorry,
Yeah.
proffer is, proffer's the,
I'm not sure the proffer
What
has
a
any
mess.
impact here. I'm not sure the jury would ever be made aware of the substance of the proffer. They, as I understand it, under McCullough, would only be made aware of evidence related to the substance of what Mr. Norris told investigators and law enforcement.
Your Honor, the proffers do tie into this in that, the question would be, did this inform your investigation? Yes, we considered
So wild.
all of his statements
It's day 13. What are we
to
doing?
include the defense proffers
Got it.
in determining that they were just flat out incredible.
Okay.
So that goes to kind of the confusion argument. So in the 403 analysis, Your Honor, I do not think the weight of unfair prejudice to the defense is the same as the weight of, well, any of the 403 factors. I don't think the weight is the same for the state and the defense.
Right. And
And
I
to
think
put a
how
fine-
Bloodworth is seeing this is confusion is always going to benefit the defense. Clarity is what benefits the prosecution. Confusion benefits the defense. And that's where the prosecution, I think, is trying to balance with the court something that was thoroughly kept out at the beginning of trial and is now apparently on the table again. So they are buffering in real time as well.
Your point on it, you're concerned that the jury would be confused about who said what when? It's jury confusion that I need
It's
to-
jury confusion.
Right. And
Yes.
so what is it you believe they would be confused about?
I think they would. I think they would be confused about the effect on law enforcement, which is really what this grounds in, right? This is the effect on the hearer, the effect on law enforcement.
Okay.
And I think those waters would be so muddied in the case of Norris, whereas those waters are crystal clear in the case of Hayden Jeffs and Nick Von Savage. And the waters are muddied as it relates to Mr. Norris very deliberately. And I don't know, I suspect the purpose is to confuse the jury, right?
As you sit here today, have you identified the witness that would testify regarding investigators'
Well, this was kept
knowledge
out
of
until like
and
5 minutes
response
ago,
to
so
statements made by David Norris?
I know, I don't remember the name. I know the patrol officer. I think I know who he talked to. I think I know who the detective talked to. It also involves my office, right? And so
You would be able to call an investigator.
oh, and that's a mess
Not a lawyer,
too.
right?
right.
Yeah.
So probably 3 witnesses.
Okay. And then who are the witnesses you would call to testify regarding the state's knowledge of and response to Hayden Jeff's statements to his sister? Or, I mean, I
Well, the
appreciate that Hayden
investigators,
Jeff
right?
spoke directly to law enforcement in a recorded interview.
Right, that's what we would have to get into. What did you understand, why, with what level of detail, which is extraordinary.
In there, as I understand it, the state's position would be, well, if we're not admitting it for the truth, Judge, there's no Crawford problem, so the recorded interview comes in.
100%.
Okay.
And the same thing, by the way, with the Nick Von Savage jail call, right? That entire jail call comes in lock,
boy.
stock, and barrel. If we're going to mention it, we're going to mention it all. And then can I just say one final thing on the unfair?
Mention it all. Mention it all.
Yep. Full mention it all. Uh-oh. Is Bloodworth gonna replace Bethany on the soundboard? Of course, if we're gonna mention it, we're going to mention it all. Of course, you have to mention it all. Well, Your Honor, if the defense wants to use that ruling to talk about what law enforcement investigated, then we're going to get into, were there lab receipts? What about the tweezers? It's going to open a floodgate to rebut the presumption that law enforcement didn't do a thorough investigation. While there might be multiple ways to do a thing, you have to pick. Do you notice that the defense has now stopped talking entirely? The defense is like, we have caused this, and now we are going to sit there and be quiet. Oh boy.
All comes in lock, stock, and barrel. If we're going to mention it, we're going to mention it all.
Oh, I understand.
And then can I just say one final thing on the unfair prejudice? I think the court, in considering the weight of the various prejudices, the prejudice with admitting versus the prejudice of the Hayden Jeffs and Von Savage, I think the court needs to in the probative value part of that analysis, I think the court needs to consider kind of all of the corroborating evidence and the fact that
Oh boy.
David Norris's assertion is not at all probative because there is nothing that corroborates it, and it is inconsistent with all the other evidence in the case. Whereas,
Which means you're now litigating. I think where the prosecution's going with this is now we're shifting the focus, which is helpful for the defense, right? We're shifting the focus to now litigating what Norris said about the victim and not what Kouri did. So we're now shifting into, is what this person said bullshit or not? And that's a lot.
The Bond Savage statement and the Hayden Jeff statement is highly corroborated with a ton of admitted already evidence in this case.
And just so we're clear, when you're talking about probative value in this context, we're talking about probative value to the defense's theory of incomplete investigation
Right.
and probative value to the state's response to that theory.
Correct, under the 403
Got it.
balancing.
I understand your position.
Okay.
Woo!
Ms. Lewis, Ms. Nestor, Mr. Ramos, this is high-stakes poker.
Yes, it is. I was just going to ask you.
Oh boy. Trials are dynamic. Trials are dynamic. And here's where we're at. The defense did not raise the case law. Sua sponte, the court did. And take a minute, which again, this court has erred on the side of caution every single time. It has been incredibly consistent. So when there is an argument that kind of noodles at the court's brain, the court is going to be like, I'm going to check the case law. And the court checked the case law and is like, look, under this case law, if the defense wants to argue that there's an incomplete investigation because they didn't follow up on this lead, the prosecution is allowed to rebut that by running down all the other leads. And that opens the door to what Hayden Jeffs said about Kouri trying to procure fentanyl from him prior to reaching out to Carmen. The conversations Nick Bond Savage was having that were on recorded lines in the jail talking about who Carmen was getting drugs for and what they were. It might open the door to what Amy knows. We might get to a full If You Seek Amy on this, and what happened with Amy and Kouri, because the incident with Amy and Kouri also goes to that's strange behavior. All of these things start to inform the investigation. I still think after what we saw yesterday on cross-examination, there's room to poke at this investigation without opening this fucking floodgate. But when the court says this is high-stakes poker, it's because it truly is a strategic and tactical decision. Now, if the defense chooses to do this and the court lets it all in, will the defense still appeal if she's convicted on these grounds? Yeah. They'll say the court let too much in. I don't know if that'll be successful. I haven't read the case law. But the judge has pulled case law multiple times in this trial, and I think the judge goes above and beyond making sure that he is following with the case law in Utah, even when the defense does not cite him to those propositions. Because at the end of the day, it's still his job. And so even when the defense is arguing, but Your Honor, because we say so, the court's like, okay, but this case law, let me review it. And that's where we're at the moment. Do you want to open this fucking floodgate? And then we are going to have days and days more trial, because now we're going to have a mini trial on whether Norris, not Chuck, said that at some point in time in 2019, Eric Richins was trying to get fentanyl from him, and whether law enforcement went after that lead, or whether law enforcement looked at that lead, said, this is totally bullshit manufactured evidence, and here's why we think it's bullshit manufactured evidence. And then have a mini trial about whether this is bullshit manufactured evidence or whether this is a authentic lead that needed to be tracked down. Because if Eric Richins was taking street narcotics that could have been laced with fentanyl, and that was his regular habit, then we can see why the defense wants to bring that in. But with all of the things that were taken out of the house, if he's taking stuff for pain, why wouldn't he just be taking the other pain medication that was still in the house that was recovered by law enforcement? There were pain medications that were not empty in the house. So none of this makes any sense to me, but I understand it's the defense's job to throw up the spaghetti on the wall and say, see, you can't find a conviction in all this spaghetti. It's the prosecution's job to make it more clear. And I think where the prosecution is at sitting there is going, fuck, we're going to have a whole mini trial on what Norris, not Chuck, said. And we're going to stop thinking about Kouri and the walk the dog letter. It starts to distance it. I get it. I get where the defense is coming at. And I get why the prosecution's like, we did this in pretrial motions. Okay. And the jury's still
If we
sitting
could
there.
have a little time to meet with our client next door, she's got some decisions to make about that.
I want to make sure that you explain to her that if you're successful in persuading the court that the substance of David Norris's statements should come in not for their truth, but for their effect upon law enforcement and investigators, for their probative value to the defendant's theory of incomplete or incompetent investigation, that
Mention it all.
by extension, my view is that I need to allow the state to respond to that theory by, among other things, admitting evidence of their knowledge of in response to statements made by Hayden Jeffs and Mr. Bonsavage, not for their truth, but to show what they were doing and how they were doing it.
Can I just get a clarification on the Bonsavage? I want to make sure I'm on the same page.
Why don't we just get a proffer of it, Mr. Bloodworth, so we're all hearing the same thing at the same time?
Let's all find out. Let's all find out together.
Yes, Your Honor. In a March 4th, 2022 jail call
We heard a little bit about
between
this yesterday.
Mr. Bonsavage and an inmate in Gunnison, they're discussing purchasing a PlayStation.
We heard about this a little bit yesterday, and then the rest of it was cut off. The reason the court is doing this, in my view, and I've seen judges do this a lot, they want the defendant to hear from the court, this is everything that's gonna come in. Counsel, you need to advise your client and make sure you discuss this, because they want the client to hear it from the court and then hear it from their lawyer. Because there's no putting the shit back in the horse if this all comes in.
Controller.
Okay.
And they're discussing who's going to pay for it, kind of how to get the money for it. And Nick Bonsavage says to the inmates something like, Carmen will cover it. She just made money selling fentanyl.
So this is already in, other than we
The word
substituted the word fentanyl
We
for
illicit street
drugs.
Right.
Chat, while we pause here, if you're the defense or the defendant, what are you thinking? Because the defense stood up in opening and said, there is no information that connects what Carmen Lauber is selling to Kouri Richins to fentanyl. And if there is a recorded jail call with Nick Bonsavage, who was with Carmen Lauber on those hand-to-hand, one of those hand-to-hands at least, the day Eric died, saying Carmen Lauber just made a bunch of money selling fentanyl, doesn't that support Carmen saying, I talked to Crozier. Crozier said, I don't have Oxy, I have Fent. Carmen calling Kouri and saying, he doesn't have Oxy, he has Fent. Is that fine with you? Yeah, it's fine. Just get that. And then Carmen buying it. Because this is before they know Eric's dead. And they're talking about this shit out in the open. After Eric's dead, Carmen and Crozier are like, please don't fucking prosecute me for murder. Because we were knowingly selling Fent that caused somebody to OD. So then, aren't we getting to how did the fent get into Eric's system? Well, Carmen's bestie's on a recorded call saying Carmen's making this money selling fentanyl. And doesn't that then support Crozier's recorded interview when he was saying, I don't remember saying that to Carmen, but if I said fentanyl, then she knew what she was getting. And then doesn't that support further Crozier's statement on the stand that at the time, on the street, Oxy was being sold from people ripping their prescriptions, yes, but it was more common that people were making fentanyl look exactly like Oxy, and that he was selling those things for the exact same price and they looked exactly the same. Because that's what he said on the stand. Yeah, at the time, there were counterfeit Oxys made to look exactly like Oxys, which is why people were trying to buy Oxy on the street and overdosing from fentanyl because they thought it was Oxy. And he said, I'm selling the exact same thing for the exact same amount of money and it looks exactly the same. And they sanitized that testimony. And they're going to tell the jury it's not for the truth of whether somebody's selling fentanyl or not. But how is the jury going to parse that out of their brain? Oh boy. And once you hear that, there's no undoing that, even if it says this comes in for the investigation, because the investigators are going to be like, no, the day Eric died, we heard them on this jail call saying Carmen's selling fentanyl. We knew what the fuck was going down. We're yelling timber. Woo! That's some high stakes poker for the defense.
And that's a recording,
It is a recording.
as is Hayden.
And it's recorded,
Law enforcement.
which gives more weight.
And the upshot proffer of that interview, and this occurs many times, there's pages of transcript on this subject, but the upshot of the proffer is that Kouri Richins asked me to buy her fentanyl. I
is
explained to
Jeff's.
her, in really colorful language, how dangerous it is. She wants to stay away from it. Who on earth would want fentanyl? And then there's a second phone call where she calls back and asks for the Michael Jackson stuff, and they get into a propofol discussion.
Right.
And then the recorded interview from Hayden Jeffs comes in. It couldn't come in before. He passed before this trial. And that's what the recorded interview of Hayden Jeffs is. Kouri came to me and asked for fentanyl. I said, why the fuck do you want to mess with that? That fucking kills people. You don't want to fucking touch it. And then she came back to him again, which I didn't know because it wasn't in the pretrial motions. Came back to him again and said, okay, how about the Michael Jackson stuff? She asked for fentanyl. He says no. She comes back and asks for the Michael Jackson stuff, which is just going to make Carmen look more truthful. And then if the defense decides we're not getting into any of this, how frustrated are y'all going to be knowing how much other evidence there is in this case?
Okay.
Yeah.
How much time do you want, Ms. Nestor?
Good luck with that decision.
We have 30 minutes.
It's fine.
Thank you, Your Honor.
Can we have 30
Anything
minutes?
else before we take a recess, Mr. Bloodworth?
No, Your Honor.
Ms. Nestor?
No, sir.
We'll be in recess until 10:30. All rise.
Oh, fucking hell. Y'all are going to be so disappointed if the defense decides not to bring this in. I won't be surprised if the defense is like, we're not rolling those dice. It's not worth it, especially if their witness is going to have direct ties back to maybe their own walk the dog conversation. If they have faith in their witness, bring it in. And then I guess the defense has to pivot and say, no, Kouri was asking for fentanyl because Eric was asking her to get it, which is in the walk the dog letter. The walk the dog letter says, I asked Carmen for stuff because Eric was asking me for it. And then I guess the defense just pivots and leans back into the whole walk the dog letter is true. but I don't think the scientific evidence bears that out. So the defense has asked for a 30-minute conversation with their client. We are going to zoom past that. However, EDB is frozen in my office because it was so hot this morning. It is so cold right now. I need like 3 minutes to go and grab a jacket because I am so cold. I am going to fall over. So I am going to take 2 minutes to literally run to the other side of my house and grab a jacket. And then we're going to zoom past the 30-minute break and come back and see what the defense is going to do. Because, yeah, I'll put up a poll for sure. But I'll put up the hold music. You'll hear my music when we come back and we'll send out an app notification. I'm just going to put up a poll. Let's see. What do you... all right, I'm putting up a poll. What do you think the defense will do? Mention it all? Means they want it in. Or pause. That's not coming in. I think it would be, well, I think you can tell what I think about this, but I'm not the defense. And some of this is Kouri's decision. And that's why they want 30 minutes to talk to her. Because if Kouri is pushing this and Kouri's like, do it, Kouri might be back there going, I don't care.
Do it.
She might be so focused on, no, Eric was doing this, that she cannot shift from that. And the defense probably wants to cover their own ass on that. Because there are some client decisions that are just client decisions. And they need to explain to her how bad this is going to be. And she might think, nah, this jury's on my side. The walk the dog letter is true. She might have convinced herself at this point that the walk the dog letter is true. Eric was asking me for this. It's not on me. I think that's a bad strategy, but it's up to her. And ultimately, she's the one who's risking the rest of her life in prison. So it should be up to her. I guess we're going to see shortly what she's going to do. I'm going to try to clock it under 5 minutes. Because I have to get something warmer. Grab a snack. Let's see what the fuck happens when we get back. Chat, I'll be right back.
docket 214, but every law nerd on the internet calls it the walk the dog letter.
Law nerds, are you ready? I know. I am too. All right, you guys. We got the hoodie on. Today was the I Have Questions hoodie. Nothing else seemed appropriate. I am cold. I've got a sandwich. I've got some coffee. Let's ride, you guys. What in the world is happening? I saw a lot of you ask about if we have a break music playlist. We are working on some options for that for you. Do not worry. We are working on some options. We do not have them yet, but we are working on them. So we need to go back to court, though. We do. I know. I need to switch my AC to a heater because, well, it was hot yesterday. It's cold today. It's Middle Tennessee in the spring. That's what it is. I'm very interested to see where this goes. All right. I'm going to end the poll. Let's see.
We're back on the record. 231500.
56% of you think the defense is going to back down. 44% of you think they're going to like roll the dice and ride. Let's see what happens. Watch they just punt it and they don't even make this decision today.
139.
That would suck.
Counselor present, Ms. Richins is present.
I don't want
Ms.
that to
Nestor,
happen.
You've had an opportunity to confer with Ms. Richins. How does the defense want to proceed?
Thank you, Your Honor. Thank you for the break. We appreciated that. So we have reviewed the case. We clearly understand the court's ruling that if any of it comes in, all of it comes in.
Mention it all.
We also understand and appreciate that the court is going to require proper foundation, and we're not skipping any steps. We accept the state's representation in good faith that Officer O'Driscoll, he's out still. He is not the foundation witness because he is not the individual who communicated with Mr. Norris.
Are we going to punt?
And we will, if we proceed with this line of questioning and we decide to introduce this evidence, we will do it through the proper foundational witnesses, which
You're
we
punting.
accept as not him. So to avoid confusion now, since it's not him, we will wait and not ask the questions that he doesn't have, because it's like you said, there's no way to ask the question without introducing the substance. We couldn't figure out how to do that.
So they're punting.
So we're going to wait until we have a foundational witness, and then we will proceed that
This
way
is the
if we
state's
can
last
lay a
witness.
foundation.
Okay.
They punted.
And if we
oh,
decide to go forward with that evidence,
I appreciate that. If you make that ultimate decision,
we'll give everyone a heads up.
I appreciate that. And one of the reasons
And
I
that's
would
strategic.
do that is to make sure I
That's strategic too. Because if the state rests before they do that and they try to do it in their case in chief, it delays when the state can rebut it, which is not improper for them to do. And I'm not suggesting in any way it is. This is strategic. But the defense also spent the morning while the jury was waiting, probing, well, what would the state do? And what witnesses would the state bring? And how would that look? How would this all come in? Which again, the court allowed for that conversation, and a very thorough one this morning. And the defense knows that the court is going to entertain those conversations and use that, I think, to their advantage. So here we go.
give defense an opportunity to state on the record, or at least summarize on the record, their strategic balancing of the risks and benefits so that there is a
Right. The court
record
wants a
of that
more
going.
thorough record on
I
it so it
appreciate
doesn't
that.
bite the court in the
I think
ass
that's probably a
on
good idea
appeal.
for everyone,
Okay, very
including
good.
us.
So, Mr. Bloodworth, because the defense will not be opening the door to any portion of its incomplete investigation
At this point.
theory related to David Norris through Detective O'Driscoll, I don't believe the state would be permitted to respond to it yet. Is that your view of it?
That is my view of it, Your Honor.
Okay. So, as a matter of
What an
status quo,
exercise
we
in
are
futility.
going to proceed with additional cross-examination of Detective O'Driscoll, correct?
Yes, sir.
Right back where we were.
Did we reach I'm sorry.
Could we just
Lord.
go ahead and, well, I can just do it through, I think we decided I would just ask him about 340. I'm sorry, nothing, I apologize. I
Okay.
withdraw.
I was about to ask, did we reach an endpoint regarding 340 and the photograph?
So the plan
Yes,
is to
you
introduce the
did.
stipulated 340, which we'll get in. And then
You did.
I will ask him if he can identify the photo. If he can't, he can't, but I'm going to try.
Okay.
And I'm not going to get into the substance of any of the bubbles, and I'm not going to introduce
Okay.
the bubbles or any of that.
Okay.
The only thing I'm going to display to the jury will be the picture on 340. And then I may have it side by side in front of O'Driscoll so he can compare and refresh on the one that's not getting introduced.
And to the extent you ask him about whether it was sent as part of text messages between
Only the date.
Eric and Kouri on the date, it's a yes or no question.
Correct. Just
Okay.
on the date, not the time, because I don't want to confuse anyone or require UTC time or any of that conversation. And the time really is irrelevant to us.
Okay. Mr. Bloodworth, anything further?
How is the time irrelevant? You're trying to say that these were all accessed at the same time because they came in so much earlier. Why is the time irrelevant now? Okay, because it doesn't, right? The substance doesn't really matter.
On that.
No, Your Honor.
All right. Are we ready for the jury?
Yes, Your Honor.
Ms. Nestor.
We are, Your Honor.
Oh my God. Well, now we're finally bringing the jury. I guess we're going to fly to Utah. What a wild morning. So, Emily, what happened? We're right back to where we began because the defense punted. And they said, okay, well, O'Driscoll's not the right witness to get into this with. We're not going to get into it with O'Driscoll. And we'll see what happens. So we're right back where we were before we went under that side quest that took hours. So before that hours-long side quest, while the jury was waiting, because the jury was told to be back at 8:30, and then they took a break till 10:30. The jury was there at 8:30. The jury's been sitting there for 2 hours this morning, which is wild to me. We got right back to O'Driscoll, the text messages that we left off with yesterday. And the defense has gotten to thoroughly explore if they want to probe at the areas of incomplete investigation for not following up on this individual, Norris Nutchuck, who came forward and was like, Eric was asking me for this, and whether they followed up on that or not, and what doors that would then open, like a fucking wrecking ball. They had a very fulsome exploratory conversation about exactly what the consequences of that decision would be. Preparing for Mountain Life asked, EDB, why can't the prosecution say yes and kick the door in? Because they were kept out in pretrial motions, the prosecution cannot open that door. It would be improper for them to do so. This is a strategic defense call if they want to poke at the investigation with that witness. There's other ways they can poke at the investigation, but if they want to poke at the investigation with that witness in that way, it's going to open up a floodgate. There are other ways to poke at this investigation. If the defense starts going, okay, well, did you ever go to Kouri Wright and be like, let us see the inside of the truck? What did you take out of the truck? They can ask all those questions all day long without opening this door. But if they start to get into the witnesses and the information that was kept out in pretrial motions, it will open in, okay, but what are the other areas of investigation that informed your belief that this witness or this lead was not truthful, substantive, helpful, whatever it is? So no, the prosecution can't open that door to stuff that's been kept out. It would be improper, and it would be error for the court to allow them to do so. So I guess we're bringing the jury. Did we fly? I don't remember. Did we? I think we did. Did we get double miles? The jury's coming in. Let's just. If we did, we did. If we didn't, we didn't. Clearly my coffee hasn't kicked in. And now, how many of you are like, well, damn it, there's so much more that I know now that I didn't know before that the jury doesn't know. And it's hard to unring that bell too. Apologies. I have gained the cord up so much on my end. It's going to change the volume a little bit of some of our other things that we have modified. I can give you a brief rundown of what happened if you want a little inside baseball. But in the Court TV acquisition, the way that the pool feed is being provided has changed, and the volume is just way lower today than it was. So we are now dealing with a different feed because of the Court TV acquisition. For those of you that are like, Emily, what are you talking about? Court TV was acquired at the end of last month by the owners of Law and Crime. Law and Crime's owned in sub and substance by Jelly Smack. And so links changed in the way this was put out changed. And this one just doesn't have such, just doesn't have a loud enough volume. EDB, you should have bought Court TV. I mean, it says it's like $125 million purchase. So I'm good.
Thank you for your patience. We will now
don't have that much money. Don't know what I would do. We got our own Baker Media over here doing this. So
proceed with additional cross-examination of Detective O'Driscoll by the defense. Detective, let's have you come in the courtroom. Detective, please step in front of Brittany. We'll get you sworn back in.
I know. I don't think we'll get to see Court TV pop into the chat. I wonder if that has all changed. We're just going to keep doing this.
Do you solemnly swear the testimony you're about to give in the
this.
matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you. Have a seat.
Maureen, I thought that Grace was still running the cameras till the end of this trial. She's done a great job. Grace is the in-court producer. She's done a great job. I thought she was, but I don't know. But the links,
Ms. Nestor,
the
please
things
proceed.
have changed during this
Thank you,
trial.
Your Honor. May it please the court. Good morning, Detective O'Driscoll.
Good morning, Ms. Nestor.
I believe.
Are we going to end up back in like the weird fanfic version of this, or are we going to end up in like normal cross-examination, or what are we going to do? Because yesterday's cross was just weird.
When we stopped yesterday, we were talking about the GIFs or GIFs. And
the peanut
I
butter.
want to start by having you review a document that's been agreed to by the parties. It is exhibit number 3-40. And at this point, Your Honor, we're asking to admit it per stipulation of the parties.
All right, cross resumes.
So the witness can see 3-40. And do we want to publish now, counsel?
Please.
Mr.
I thought they
Bloodworth.
weren't publishing.
State's exhibit 3-40 is admitted.
All right. And this was talked about when, I believe it was Mr. Kostradimos, I think, it's all blurring together now, was on the stand. But this is the group of all the GIFs or the GIFs that were in kind of a group.
No, those are photos. Those are not.
And included the ones that were accessed on the morning after the police left Ms. Richins' home, after Mr. Richins passed. Do you remember the testimony about that?
Yes.
Okay. Can we go to the page that shows the GIFs in question? Maybe blow that up at the top.
The GIFs in question.
Okay. So I think that's...
They're showing on the screen the extraction report, created, modified, accessed. These were the image files. Stuff had been deleted. And so they are looking at these all being accessed at 8:29:03 a.m. on March 4th, 2022. And it is the 3 that we saw in opening statement.
2 of them.
Or that's
one of them
2.
is from, I guess, the movie Dumb and Dumber. And the other one is our president. And I think there was a third one, but it's...
Yeah. Idiots everywhere.
Yeah. Mr. Spacey and in a TV program, right? And those were the 3 GIFs that were talked about.
You're happy to say Dumb and Dumber, but we don't want to say House of Cards? Okay.
And if you blow up the time that they were accessed, they all were accessed at 8:29:03 a.m. on March the 4th. That's the day that Mr. Richins was found deceased, correct?
Correct.
Right. And I know we've already heard the testimony that these are what we call orphaned GIFs. You can't really tell which text they came with and exactly when they were sent or who they were sent to or by. All we know is that they were somehow accessed at that point by her phone, correct?
That was the testimony, Mr. Cotradimus, yes.
Okay, can you pull up another one of the photos that is the picture from the house?
Chad, I agree. She said the time wasn't important.
That's
Here we
it.
are. But she might have been talking about the time on the photos. But yes,
All right.
this is before.
This is another picture that was
The point of the time of the gifts was that Eric Richins' body was still in the house covered with a sheet when she was accessing these things. These all came from Kouri's phone. The thing is, Kouri yeeted her phone fairly successfully, so you couldn't tell where they came from because they were stuck in the system. But because Kouri had deleted everything, you couldn't tell if they were inbound, outbound, etc. And we don't know who they were exchanged with, so they didn't recover them, it seems, from anyone else's phone. It's not like they went to Chelsea's phone and was like, oh, there they are. So these were in the kind of deep within the files of the phone. That's how they were recovered.
accessed at that exact moment at 8:29. And can you blow the picture up a little bit? Do you recognize what that is, that photograph?
It's the legacy home.
It's the legacy home, right? And was there another photo that was accessed that same morning, also orphaned? Can you find that picture?
It's interesting to me that they all
Right
have the
above it, I
same
think.
time. I think that gives them room to argue.
There we go. Can you blow that picture up a little bit?
And this one, the other one's from
Thank you.
10:04, but the defense leaves themselves some room to argue that the one from Midway, the photo from Midway, is accessed at the exact same time as the gifts. It gives them room to argue, hey, this is really about the house, not about Eric dying. Yeah, there's room to argue that because they're at the exact same time.
Also orphaned.
Where that one
Can you
is.
Find that picture. It's right above it, I think. There we go. Can you blow that picture up a little bit?
I mean, I think many are still going to sit there and be like, why the fuck is she looking at pictures
All
of the
right.
house
And
while
is
her
that
husband's
also just a-
downstairs laying under a sheet? Fair.
Closer up view of the Legacy Mansion.
It appears so. It's very blurry on my screen.
It is. I think it is blurry. And then can you
it's
back out and
pixelated.
show the time that one was accessed according to this same group of photos? That one appears to have been accessed at 10:42 a.m. the same morning.
That's what this document says, yes.
Okay. Now, if we could put just on the witness's screen, exhibit JO, I think it's 11, not for the publication yet, Your Honor.
Understood.
All right. And can you take just a moment and blow that up just a little bit so he can read it better?
Chat, they said they weren't going to talk about the time, and now
Just
they're
take a
talking about the
second
time.
and scroll through that. And tell me if that refreshes your recollection about any documents you reviewed about Eric's final communications before he passed.
Your Honor, objection.
We've gone well beyond the bounds of just the
There's no
photo.
foundation to get to whether or not his recollection requires refreshment.
Yeah, let's pause there. Would you lay a little bit of foundation before we get there?
Sure. And it requires us to go back to yesterday. So yesterday I had asked you right before we stopped if you had, as part of your investigation, reviewed the final communications of Eric right before he passed away, and you mentioned you had. Is that correct?
Yes.
All right. Based on that, if you could refresh, do you recall the communications you reviewed that day?
Not all of them. Some of them, yeah.
Can we then please blow up this document in front of him and see if this refreshes your recollection as to what you reviewed?
Mr. Bloodworth, the witness doesn't have it yet. Any objection to that question?
Your Honor, I think the objection foundation, I think there requires additional foundation.
I think the question pending is, are these among the things he reviewed? Correct?
So that's the
Maybe I
foundationary
misunderstood
question.
pending.
That's the question.
So I think,
Can we back up a step? Maybe I'll catch up.
sure. Ms. Nestor, ask your last question one more time, please.
Are these texts that are before you part of what you reviewed from Eric's final communications on his phone?
Go one step before.
Are we refreshing his recollection? Are we admitting these through him? Make it short and sassy, said EDB. I think you give the defense team too much credit at times. I don't think they know what their strategy is. Oh, I think they know what their strategy is. I do not. I think their questioning can be inartful. I find the style to be off-putting, but they absolutely have a strategy. They know what they want to do. They know how they want to do it. So I think they know their strategy, but I think there is a smoother way to go about all of this, but that's not what they want to do. And it's their trial. They can do what they want. However, they definitely have a strategy. But please hang out in the chat for everyone that pops by and says, I'm way too hard on this defense team, and just populate that for them when they come back in. Just like all of you when I got screamed at during Karen Reed, it's like, you're way too hard on these prosecutors. They deserved it. So yes, just hang out for the, oh my God, you're so mean to these defense attorneys. And then just tell them that. We'll just stay there. Because there's a strategy here. For sure.
Doesn't currently have them in front of him.
Do you recall all of the communications you saw that day when you were reviewing Eric's final communications?
All the texts from his phone?
Yes.
On the day before he died?
Yes.
I don't remember all of them. I remember some of them.
So then would you please look at this document and see if it refreshes your recollection and as to whether these were included in his communications?
Any objection, Mr. Bloodworth? No, sir. Okay. The witness can now see what you're referring to, Ms. Nestor.
Thank you, Your Honor. And can you go down just one more and maybe blow that up a little, that photo? Does this refresh your recollection, these communications of Eric's and Kouri's the day he died?
These are time-stamped March 3rd. That's not the day he died, but the day before he died.
Totally correct, because he died in, we think, the early morning hours of the 4th, right?
Yeah, he was pronounced deceased on the 4th.
Okay.
Yes,
So,
Your Honor, sorry, objection. Foundation is to the meaning of died, right? He was pronounced dead.
But I think the witness and the
I think they have a clear understanding.
have a common understanding here. Overruled.
thank you, Your Honor. Okay, so were these included in what you reviewed in the communications between Eric and Kouri on the 3rd of March?
Yes.
All right. And this photograph, if you could blow that up.
Your Honor, objection. His recollection has been refreshed. I think the exhibit can now be set aside.
He can't
I'm not
just read
publishing.
from it.
I've just got one more question about the photo, and then I'm done.
I'll take you down and ask your question. If we need to refresh again, you can.
Okay, thank you.
Okay.
Wait, did you tell me I could ask the question?
Yeah, I took the photo down. Ask whatever you're about to
Yes,
ask.
yes.
Okay.
Does the photo that you just refreshed your recollection with match the same photo that...
Ma'am, we were at look at this photograph. Look at this photograph. Look at this photograph. I saw a great question in the chat. This is already giving me a headache. Baby Holly Pop said, EDB, isn't it true that the defense team doesn't really need to do anything? The burden of proof is on the prosecution. It is true. They don't need to do anything. I mean, there are objections they need to make. They don't need to prove anything. They need to make objections. They need to cross-examine witnesses. But the burden is on the state. The defense doesn't have to prove anything. It is not on them to prove that Eric did or didn't take fentanyl on his own. They don't have to prove it. They are trying to block the prosecution, and then raised out. The burden's on the prosecution. However, when the defense promises things in opening, it is my perception that they should follow through on that or not make those promises. But that doesn't shift the burden to them. But the defense can pull that burden onto themselves in the way that they do things. If they say, we're going to show you this, we're going to show you that, they need to be able to show those things because they've promised it to the jury, not because they're obligated to do anything. They don't have to bring a case in chief. They don't have to call witnesses. They don't have to prove that Kouri didn't do it. The state has to prove that she did beyond a reasonable doubt. They muddy the waters with doubt. That's their job. So, yes, but they have to do some things. Doing nothing, if they sat there and said not a word the entire case, it would be IAC. They have to do some things.
That we just saw in 340, that was the corner of the Midway Mansion.
Your Honor, the photo's still up on my screen and the witness is
My apologies.
staring at it.
The photos.
Is it
Lord.
the same photo, sir?
This one that we just saw that was enlarged, you're asking if that's the same as the one in the text message?
Does it match the one that we just put on the screen for the jurors that came with all those other pictures that morning?
Yes.
Thank you. That's all I have. Done with that. I'm sorry, maybe I'm not. Can I have just one moment, Your Honor?
Of course.
Oh boy. I'm done with that. No, I'm not. Yes, I am. Just kidding. No, I'm not. Breezy said, with all the waste of time this week, can the judge say we will be here Friday? Oh, they already added this Friday. It's next Friday. I think they had still had off.
Steph, if we could go back to
I think the judge had already added this Friday back in a couple weeks ago.
340, which has been admitted, and pull up some additional gifts that were accessed at that same time. If we could pull those
Casey
up,
Cat,
please.
I'll double check. We have a list.
There you go.
Okay,
of where our
so
music's
there's
from.
the picture on the bottom left-hand corner of the Midway Mansion house, right?
What in the what is happening? These are other things accessed at 10:42, it seems.
Yes.
And that one was accessed at 10:42 a.m. the morning of the 4th.
Yes.
And the one with the champagne is also that exact same time.
Yes.
And the one with the farmer is that exact same time.
So people are popping bottles?
Yes.
And we know for sure that the one on the bottom left was sent the day before,
That's a good question.
because we just looked at that, right? And you refreshed your recollection.
Yeah, I don't know if the part of the extraction that we're looking at right now is saying that that's where that came from. I don't know if that's the same file path, but that photo is the same.
Perfect. Thank you.
That's what she's
Okay.
trying to get
We can
at.
take that down now.
Why didn't they ask the tech expert, Emily? Well, because the tech expert would have a more artful explanation. They want to show, look, this shows it was accessed at 10:42, but it was sent the day before. So they're trying to distance the time of when those gifts were accessed because the gifts are fucking bad. But if they can raise, hey, if these were sent the day before, then maybe it wasn't accessed at this time.
All right. I also want to talk to you about, sorry, startle me. I also want to talk to you about the Google searches that were testified about here that were on Ms. Richins' phone or computer or both.
Okay.
Did you review those as part of your investigation?
Yes.
All right. And were you able to determine dates on all of those searches when they were made?
I don't think he
I don't believe
determined
so.
anything.
Yeah, that would be a question for Mr. Koutrodimos. I remember seeing the searches and the text of the searches, but I believe he testified that that there wasn't a timestamp associated with them and that they differed from the action in the phone that showed that a link was actually clicked on from one of those searches.
Okay, perfect.
And I believe those had timestamps.
Okay, the links, but maybe not the searches.
Correct.
Thank you for that clarification. And you agree that as of April the 13th of 2022, approximately a month and a few days after Eric passed away, that Ms. Richins' house was searched and she was detained in a police vehicle, right?
Objection, Your Honor.
Word detained is causing problems here.
Sustained. Lay a little foundation.
Are you aware that there was a search conducted on her house on April 13th?
On Miss Richins' house?
Yes.
Yes.
And are you aware that while that search was being conducted, Ms. Richins was temporarily detained in a police vehicle for a period of time?
Objection, Your Honor, calls for a legal conclusion.
Detained is causing problems.
On that.
Go ahead.
I think the word detained is the problem there. I think there's been dispute over
Right.
whether or not she was detained. But she was spoken to. She was
was
asked to wait
sat.
in law enforcement's vehicle until the lead detective could come speak to her about what was going on with the search.
Okay. So the searches on the website.
Yeah, this gets back to like Josh Duggar sitting in, well, they were searching his computers and stuff. Was it a detention? Was it not a detention? That gets into a whole pretrial issue. But she was with police in a police vehicle. The detention was contentious in pretrial.
Fair to say that all of those searches are believed to have occurred after April 13th of 2022.
I don't know if that's believed.
I don't know. Like I said, I don't know there were timestamps on the searches, so I can't be sure.
Did you ever interview any of Kouri's family or friends and ask them if they were responsible for any of those?
That's a good
or
question.
if they'd ever seen Kouri do it or who did those searches?
No.
Okay. All right, I'd like to talk about the
a good
orange
question.
notebook for just a moment. We pulled up, do we have the, do you have that orange notebook exhibit? I can't remember the number of it. Court's indulgence for just a minute, I have the number. I've got it.
Okay.
I'll tell you. Just one moment, I'm sorry, Your Honor. It's hard to keep all these exhibits straight.
Ma'am,
It's admitted, Your
I
Honor.
zoomed.
Oh, wait, I'm sorry. Before we do that, can we put up exhibit, 2-66R, that's correct. We don't have they redacted part of it, and we don't have that.
Scott, 2-66R, please.
Would he be so kind? I don't want to accidentally put something up that was redacted, Your Honor.
My apologies. We'll fix that. It's okay. One moment, please. Scott, if we do our normal dance, I'd appreciate it.
Well, Your Honor. Scott, can we do our normal dance? Plug it in, plug it out, plug it back in.
There you go.
All right, and can we, that's what we like to call the orange notebook, right? Because it's like in an orange kids school.
Well, this is what we like to call the orange notebook because it's in like a notebook with like an orange cover. Uh-huh.
That's what we like to call the orange notebook, right? Because it's like in an orange kids school notebook, right?
Correct.
Okay, and can you fast forward, Katie,
I don't think there's an
to-
age limit on
Zoe,
using a
please?
spiral bound notebook, but
Keep going,
sure, it's a children notebook.
keep going. Okay, right there. And can you blow out the bottom third of the page? All right, so this orange notebook that was recovered from the house, you don't have any knowledge about the circumstances under which it was prepared, do you? Or why it was written?
I do not.
And you don't know when it was written?
No, I don't.
And this was seized the day Ms. Richins was arrested, which was May 8th, 2023, correct?
I believe so, yeah.
So over a year after Eric's death,
Okay.
right?
Correct.
All right, and here on there is an entry that says,
Are we getting to she was grieving and is trying to keep her timeline, or are we getting to she was just outlining a book? What, or are we getting to this might have been her keeping notes for the civil litigation? I'm curious to see where we're going.
on March the 22nd, can you highlight that, please, Katie? Kouri starts counseling. Do you see that? Oh, you need to say yes.
Yes, sorry.
Did you take any steps to verify if that actually was the date she started doing mental health counseling?
I didn't learn anything about her counseling from interviews that we conducted. We did get Kouri's medical records, and I don't remember if mental health counselor was part of those, but that's possible.
And I imagine as a, I forgot the word you used, as a serious crime investigator, homicide investigator, detective.
As a serious crime investigator, detective guy, she's poking at, are you verifying if the things in the notebook are true? Though I don't think they would necessarily go to Kouri's therapist and try to get to that information.
That's scene investigator. You've dealt with a lot of victims and family members who've been traumatized by a death and have required counseling. Is that fair?
My involvement with victims doesn't usually go that far to know whether they sought counseling or not. We refer them to the Victims Advocate Service, and they're much more equipped to help them with that.
Great. And have you ever heard of what's called
That's fair.
trauma journaling? No. Do you know what that is?
We've got insinuations.
I'll move on. I'm done with that.
Are we approaching or moving on?
Why? We're moving on from the subject matter. No need to approach.
Got it.
We are moving on from the subject matter.
Very good.
Right? Just kind of sprinkle it in there. She's not trying to keep her story straight. She's not trying to write a book. Her therapist might have told her to journal. Right. Multiple explanations. If there are multiple reasonable explanations, they are leaning into what's in the jury instructions.
All right. You also talked about the fact that you found it, I think you said suspicious, but I don't want to put that word in your mouth, but it was of significance to you that Carmen had placed a Mr. Richins' obituary on her memory wall or her inspiration wall or whatever. Is that right?
I noticed it, yeah. I mean,
Okay.
it was something that caught my eye.
Did you happen to notice if there were any other obituaries right around it or next to it?
No, I didn't particularly notice.
Can we pull up exhibit?
Well, it'll be interesting if there are. I told you.
Yes, thank you.
She has a strategy.
The second one, 816R, I think. Oh, it's 15? Okay, 815R. And that's in, Your Honor, if we could publish it.
I can't see it yet, Katie. Oh, you don't have it. My apologies.
Oh, that
Scott,
one's got things
Would
blurred.
you help us?
Are we going to get back to the
Let's
walk
see,
the
this
dog
is
letter being
8-15R.
trauma journaling?
Let me just make sure this is the one you
I guess
intended,
maybe.
Ms. Nestor.
That is the one.
And Katie does have this one if you wanted to switch back.
Okay.
Yeah, because I'm going to need her to blow it up. Can we
One
switch it
moment.
back to her, please? I'm so sorry.
No problem.
There was a recent version where they blurred a lot of children's faces out and stuff. Okay. Do you remember
And
this
stuff.
picture we introduced of Mr. Richins' obituary on her memory wall?
Yes.
Can you please blow that up, Katie, to show what's right beside it or right under it? Do you see another?
Those aren't obituaries. but those do look like they could be the programs from a service. I guess they could be memorials, because that does look like it says in loving memory. But that's not an obituary.
In loving memory, right below it.
Yeah, it looks like a program pamphlet from a funeral.
Okay. All right.
That's not an obituary. And
Also,
we don't know
the
who it
CNE
is.
hat.
But we also don't know who it is and when.
I believe that was on that wall that you noticed. Did you do any investigation to determine if Carmen actually, if Carmen actually did any work for CNE?
Yeah, based on our conversations, she never worked for C&E as a company. She did work on the Richins house. She interacted with Eric, but she was never employed by C&E.
Okay. Right. I also want to show you a text. As part of your investigation of reviewing texts between Eric and Kouri, Katie, if you could pull up Exhibit 2 dash, I believe it's 9. 2-3. Thank you. That's it. Before you look at that, do you recall trying to determine, investigating whether or not Kouri was aware prior to Eric's death that at least some, maybe not the house, but at least some of the assets that belonged to them or to Eric were shielded under some kind of a trust, if she was aware of that before he passed?
Yeah, that was part of our investigation.
Right. And did you review conversations she had with people about that and texts about that and
You're
things
getting
about
real
that?
close to trying
I
to
didn't have any recorded conversations that she had had.
introduce your clients.
I guess it depends on the
statement.
timing that you're asking about.
Okay, I'd like to refresh your recollection and see if you look at these texts, if it reminds you
think
this is
you
one of
laid
the things you
foundation
looked
for
at
that.
and trying to make that determination, okay?
Okay.
Can you blow that up? It's Exhibit 2-3D as in Delta.
She's
And just let him look at all
on
of them,
the
please, just
line
slowly.
of,
Give him plenty of time to read.
Are we getting into introducing her client's own statements? No, but did you investigate what Kouri knew? Yes, because what Kouri knew is incredibly relevant. So there is a
Can you go
line
back up? I
there
think we're
that can't
missing-
be crossed.
That one. There you go. The next page.
So it'll be interesting to see how this plays out with, did Kouri know?
Does this
that
refresh
things
your
were
recollection?
in
Do you remember looking at this
trust?
set of texts between Kouri and Eric?
No, I didn't have time to finish reading that.
Oh, sorry. Keep letting him read it.
Ma'am.
Your recollection? Do you remember reviewing this
I had to
series
zoom.
of texts between Kouri and Eric relating to the trust?
I don't remember, and the context of those messages, I can't say that that's what they're talking about.
Okay, so this does not refresh your recollection.
No.
Okay, court's indulgence for just one moment, Your Honor.
Okay. He's like, those texts aren't indicating that. I'm going to zoom while Nesser's talking to Bloodworth or Ms. Shermanack. Okay.
We're working on something, but I'm going to ask a couple more movements. We're working on something, but I'm going to ask a couple more move back, and then we may come back to it when she's done looking. So
So now Ms. Shermanack is looking for what you're looking for? That's nice of her.
was it your understanding, without saying anything anyone told you, when you were conducting your investigation, did you become aware that Kouri knew of at least some portion of the
She just
some
asked that.
aspect of the trust being created before Eric passed?
Objection, Your Honor. More foundation, otherwise it's based on hearsay.
The foundation objection is sustained based upon the witness's prior answer. If you can start smaller, maybe build up to it. There may be some foundation here.
Did you interview people, look at documents, review texts to try to inform your investigation as to whether Kouri knew that Eric had created a trust for at least some portion of their assets prior to his death?
I reviewed information about the trust from several different sources. Everything that I reviewed suggested that she was not aware of how the trust worked or the consequences of the trust.
Totally fair. I think you're right about that. But was she aware that it existed?
Objection, Your Honor. Same foundation objection.
Overruled.
I think it's also speculative as to whether Kouri knew it existed, but that's not the objection that was made. And again, this is what the defense is trying to get to without Kouri having to take the stand and say, I knew the trust existed. It'll be interesting because Kouri's actions seem to undermine that. But again, there are good topics of cross here. But the way that it comes in, those points might just get lost. Maybe they'll come back up in closing to some effect, but I think some of it is hard to follow just because of the way it comes in.
Based upon his prior answer, you can answer, Detective.
I can't think of a specific instance, but I think there was some information that might have suggested that.
Okay, thank you. All right.
And that's the answer she, I think, wanted. There might have been some information that might have suggested that Kouri might have known that Eric might have put some things in a trust prior to death. Okay. So did Kouri know that everything was put in the trust or not? She was like, good enough.
Now I want to talk
Good enough,
about
moving on.
Valentine's Day. You were here when Ms. Staking testified to the jury that in a conversation with a bunch of friends, there was some joking references made to Kouri wanting to poison Eric, and then Eric stating he had an allergic reaction and used an EpiPen. You heard that testimony, right?
Objection, Your Honor. Foundation. That's not what happened.
I think your recitation of Ms. Staking's testimony was correct until the last either sentence or clause.
Okay.
Which is the problem I have with this defense team quite a lot. We were correct to a point, and then it shifts. It's like, yes, yes, yes. What the fuck was that? Every single time.
Did you become aware that at least in some context there was a discussion about the Valentine's Day incident relating to Eric taking an EpiPen, using an EpiPen?
Mistaking from my memory testified that there was a comment made by Eric in a joking manner that Kouri had tried to poison him. And then she said that Kouri's explanation was that it was an allergic reaction.
And that he used an EpiPen, right? Didn't she say that was the very last thing she said, I think?
I think so.
Okay. So did you do any investigation into whether or not Eric was treated regularly for allergies?
Yes.
And in fact, he had an allergy doctor. Is that correct?
Yes.
And he had an EpiPen device in the master bathroom that was recovered during the first search.
Probably. I know that there were some located in the refrigerator on one of the searches. EpiPens, that is.
Did you ever investigate whether Eric discussed this allergic reaction with his doctor? his allergy doctor?
I believe one of our investigators contacted the allergy doctor and conducted an interview. I don't remember what the results or content of that interview was.
Did you determine what Eric was allergic to? Was he allergic to avocados or wheat or peanut oil? Do you know?
From what I remember being told by the investigator that had that conversation, it was like seasonal allergies, trees, grasses, dander, things like that.
Okay.
Pollen.
Were you ever
All
able
the
to
pollen.
confirm that Eric ever sought any medical treatment for what allegedly happened to him on February 14th?
Just that in his text message, he mentioned that he might go to the hospital. So I don't know for sure if he did, but
Well,
he
wouldn't
was
you have
feeling
followed
bad
up on
enough
that?
he thought he might need to.
Were you ever able to confirm that he did?
No.
Okay.
Right.
All right. I want to also talk to you about Miss Susan Kohler. Do you know who Susan Kohler is?
Yes.
Who is Susan Kohler?
She's an associate of Carmen Lauber's. She worked for Doreen Kouri cleaning houses with Carmen Lauber.
Okay. And
I am still so confused because nobody's really cleared up the fact that Doreen Kouri spelled the same way as Kouri Richins, and it seems that the moms, I think, I don't know how they are related and their last name is Kouri and then Corey's first name is their last name. I don't know if that's the mom's side of the family and mom's maiden name, but it's confusing to me. They've never cleared it up, but they've never talked about it in court. And every single time I'm like, huh? Which is why I thought the Doreen Kouri name on the other thing was totally fake, because I was like, wait, what? But it seems to be the last name on the other side of the family. So fucking confusing.
in the course of your investigation, what did you determine, if anything, was the role that Susan Kohler played?
I think it is mom's main name, but
We
they haven't
determined that
talked about it.
she sold, I think the number was 15 to 20 Roxy's or prescription narcotic pain pills to Carmen at the request of Miss Richins.
Okay. And was Miss Susan Kohler offered immunity like Crozier and Carmen Lauber were?
Objection, Your Honor.
Do you know?
What's the basis of the objection, Mr. Bloodworth? Or do you need to approach?
Relevancy.
Approach for 1 second.
Okay, and now we're approaching. Chad, I agree with you about EpiPens and seasonal allergies. I don't think we're going to get much more clarification on it from this witness at all, because this witness doesn't know, which is, again, part of it. So they're approaching about whether or not Susan Kohler, the first person who sold seemingly her own prescription, got immunity. Which,
Relevance objection is sustained.
Yeah,
Ms.
I don't-
Nestor, please proceed.
Did you ever find any evidence or suggestion that anything Susan Kohler sold to Carmen Lauber contained fentanyl?
We found a bag of loose, I believe they were hydrocodone pills, in the mudroom walkway cabinet in the house.
we saw those
they were
much
tested.
earlier.
They did not contain fentanyl.
Thank you. You also testified, I think, yesterday that shortly before Eric passed away, he went on a hunting trip to Mexico. We talked about that a little bit, right?
Yes.
Thank you. Was there any effort made to try to track Eric Richins' phone movements while he was in Mexico during that time period?
That's a good question.
I don't believe we were able to get any kind of GPS location data from Eric's phone. I think the location data came from call detail records.
That's
as
interesting.
was demonstrated by Mr. Koutradimos.
That's interesting.
And you also reviewed
I have a lot of questions
the
about that. We're
phone
not going to get answers,
calls.
but
Well, strike that. I'll strike that, Your Honor.
That's withdrawn then?
Okay, I think I'm almost done. If I can just confer with counsel, I'm going to wrap it up.
Why do we need to know? Like, why do we need to know?
Just to recap a couple of days of testimony that got interrupted a lot.
Okay.
This investigation has now extended for a period of over 4 years, right?
Correct.
Okay. And during that 4 years period of
did
time,
Bloodworth just go, nah, I'll leave it alone? He was just like, no, I'll leave it be.
now extended for a period of over 4 years, right?
Correct.
Okay. And
Yeah, he loved
during
it.
that
That's
4
funny.
years period of time, as recently as less than a month ago, you were still issuing search warrants. Is that right?
Yes.
And there were a total of at least 10 searches by law enforcement of Ms. Richins' home. Is that right?
There were 10 search warrants issued, yeah.
And
Or around 10.
you heard that there's also at least 5 multi-day searches by a private investigator. Is that right?
I don't remember if it was 5 days. He said a couple days.
And the agencies that were involved in this case were the Summit County Sheriff, right?
Correct.
The Medical Examiner's Office.
They're not a law enforcement agency.
They have investigator, right? She testified here.
But they're not law enforcement.
Okay.
They're a civilian investigator.
Fair. Also, there was a private investigator that was involved in this case and communicated with you and provided information.
Because
No,
of the
he
civil
was
case.
involved in the civil case.
Did he provide you information?
He provided our office information. I never talked to him personally.
All right. The DEA was involved in this case, at least briefly.
They never took any official action. Well, I should restate that. They assisted us with forensic tools,
Okay.
like call detail records and things like that.
Homeland Security agent, or I'm sorry, U.S. Postal Service agent
USPIS.
was at one of the searches, right?
Yeah, I was aware of that.
We've heard, I believe that we're over 45 witnesses now in this trial. Is that right?
I haven't been counting.
We have,
And in all of that,
I think it is like 45 witnesses.
we have no murder weapon. Like, you haven't found
Oh, we,
anything that was connected to Eric's death. No fentanyl in the house, correct?
There was a boatload of fentanyl in his stomach that came out of the house with him.
Other than this, what's in his stomach?
Ma'am, there was no fentanyl in the house. It was all in the victim. I mean, that's one way to put it.
Did you find anything else that had fentanyl in it?
Oh, that
Okay.
we
You can't say
they got into that yesterday. Did you find anything else that had fentanyl in it? He said no.
anything else that had fentanyl in it?
No,
Okay. You can't say how the fentanyl was administered, right?
orally.
Besides orally.
That's all I know is that he took it orally.
We don't know exactly when it happened and what time of night or morning.
It was after
No,
10 p.m.
Time range.
before 3 a.m.
You can't say the dosage that was ingested, right? 1 pill, 2 pill, 20 pills.
Illicit fentanyl does not come in dosages.
Okay.
She's trying to tick off the things. No, she's not trying to tick off the investigator. She's trying to tick through the things that she promised in her opening statement. You can't tell us this. 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 Which is actually a more succinct cross than we've seen, I think, from her yet. Your feed didn't freeze. She's pausing.
You can't say what was ingested on Valentine's Day at all, correct?
Fentanyl is definitely ingested. Oh, I'm sorry, on Valentine's Day.
Yes, on Valentine's Day.
No, we don't have any kind of medical examiner's report of his stomach contents from that day.
And on insurance
There was an
fraud,
expert that testified about it.
we have not heard any testimony about any representations that Kouri Richins made to her insurance company. Have we?
Objection, Your Honor.
If you put a word to it. Foundation.
Well, foundation also probably then hearsay.
Would you approach for 1 second?
The defense is trying to wrap up their cross with, we don't have any of this information. Excuse me. I'm going to zoom while they're at sidebar.
Restate that. State's objections are overruled. If you would restate that question, if you can, exactly.
I will.
Which is
And
hard
we've
to
not
do.
heard any testimony in this case about statements or representations Kouri made to her insurance company, correct?
Not statements. We've heard evidence about it.
Okay. And with respect to the forgery count, we've not heard any testimony one way or the other whether Eric gave Kouri permission to sign his name on documents, have we?
I don't think that's required to meet the forgery statute.
Have we heard anything about that? Do you know one way or the other whether Eric allowed Kouri to sign his name on documents as a married couple?
No, but that's still signing
Forgery.
someone else's name, even if they give you permission, purporting it to be somebody else's signature.
Okay, well, the judge is going to instruct the jury on what the
Well, you're
law is
asking-
about that.
you're asking
But
him
what I'm
about it.
asking you is, as the investigator, do you have any knowledge one way or the other if Eric ever said to her, hey, it's okay with me, sign my name, I don't have time to deal with it?
I imagine that they have some thoughts about it, though.
I don't know.
And in fact, what we have heard is that he did give her at least one power of attorney at some point years ago, right?
Objection, well, not objection, maybe approach.
Sure.
That gets really close into the fact that it was kept out during pretrial motions, and we did hear evidence from Eric Richins' family that she might have forged that power of attorney, that it was not intended to be signed or used. We are getting very close to some of these pretrial rulings about the power of attorney being forged. The courts, I'm not zooming because the court's face talking to defense is kind of animated at the moment. But the fact that the questioning is choppy kind of undermines the point.
Okay, I'll withdraw that question, Your Honor.
The court's like, do you really want to open the door to talk about the fact that Kouri forged the power of attorney? Do we really want to go there? Well, Eric gave her a power of attorney. That's not accurate. And the court severed it out of this case. It's part of the other fraud case. The court, I think, has been overly cautious to try to keep that other fraud case separate. You can't have evidence kept out and use that as a shield and a sword. Well, Eric gave her a power of attorney, ma'am. But again, the jury doesn't know that, and it just gets kind of thrown in there, and just kind of hangs.
And you were here when Mr. Throckmorton, the handwriting expert, testified, and you heard him say that he could not say that Kouri Richins was who signed that document. Did you hear him say that?
I heard him say that it was probably
Probably not Eric.
not Eric.
But he could not say that it was signed by Kouri, correct?
Correct.
Okay.
Well, then why are you asking if Kouri had permission to sign it? Did Kouri sign it with permission, or did Kouri not sign it?
I think that's it. I appreciate your patience. Thank you, Detective. Thank you, Your Honor. We tender the witness.
And that's the end
Mr.
of cross.
Bloodworth, within the scope of cross, please.
And now we're on redirect. The inartful questioning I find frustrating. I think the defense on cross pulled some areas that they will be able to
Detective
use
O'Driscoll, in this
with their closing and with their witnesses. You can't tell us how this happened. You can't tell us how this happened. You can't tell us how this happened. The problem I think defense is having in getting that cross in more smoothly is that things keep getting twisted just a little bit. And so objections keep getting sustained because they keep shifting things just a bit. And there are some things that don't need to be shifted because you can't tell us this and you can't tell us this and you can't tell us that. It's frustrating to watch. There's room in that cross for them to poke holes. And when you have an investigator who's not on top of all of their reports, I mean, he does not have the command of the facts that we saw from the PI at all. If you go rapid fire with those questions and they are exactly how the jury remembers them, it has a lot more impact. But when the questions are like, wait, that's not exactly what was said, the answer loses the impact because everybody's still buffering on the, I don't remember it that way.
case, are you the lead investigator among many investigators?
Yeah, it's a large team. I've had a lot of help.
Does your job in part involve coordinating the activities of all the other sheriff's office investigators?
Yes.
And are you the lead investigator for the sheriff's office as opposed to the county attorney's office?
Correct. I have no authority over what the prosecutor's investigator does.
And does the county's, well, you may have just answered this, but does the county attorney's office have its own investigation capability and authority?
Yes.
Is it your job as lead investigator to be omniscient regarding every investigative detail in this case, to include details
I mean, we'd kind of like him to
of the
be.
county attorney's investigation?
No, I can't know every single detail. It's, as defense knows, terabytes of information.
And in
The prosecution is trying to say, look, there's a lot of moving pieces here. There's a lot of moving pieces here. The thing is, the PI was just like this, all of those things.
As defense knows, terabytes of information.
And in early 2023, was your personal investigative focus on determining the source of the fentanyl that caused Eric Richins' death?
Yes, because like I said at the beginning, I came into the investigations division as a narcotics officer. Before I became the lead investigator on this case, that was our focus, is investigating drug-related crimes.
In early 2023, did the sheriff's office have a digital forensics capability even remotely close to the capabilities of Mr. Cotrodimos?
No, that's why we hired him.
And in early 2023, did the sheriff's office have any forensic accounting capability whatsoever?
In which year? Which date did you say?
Early 2023.
They had a little. I mean, how early? Not until March and April.
Well, let me ask you
January,
this.
zero.
And any forensics accounting capability close to that of Brooke Carrington?
Oh, I'm sorry. Did you say forensic accounting?
He said forensic accounting.
I'm sorry. I misheard. I thought you said digital forensics. No, the sheriff's office has no experts in forensic accounting.
And is part of the reason that they have no forensics accounting experts and minimal digital forensics experts because you have a small office, right?
Yeah, it's relatively small.
It seems to be.
The county attorney's office become involved in this case in early May of 2023 when me charged Kouri Richins.
Yes, we only met with the prosecutors about a week before to give them our probable cause information.
Subsequent to charging Ms. Richins, did the county attorney's office engage Mr. Cotrodimos and Ms. Carrington?
Yes.
Right. So
And is Mr. Cotrodimos the investigator
This is also kind of a mess that the county attorney's office has stuff going on parallel, but also separate from the sheriff's department. It ends up being kind of messy that there's these two parallel things happening and there's not a ton of overlap. It makes sense, but it also makes messy, right? You can see it in the cross where it makes it kind of messy.
Who analyzed the digital forensics, including cell tower mapping and cell phone data.
Yes.
And was it Ms. Carrington that investigated?
Ms. Carrington was great.
Analyzed the forensic accounting, including the closing on the Midway Mansion.
Yes.
And does the state provide the material from each of their investigations to the defense in discovery?
As far as I know, yes.
He's trying to kind of undo some of the insinuations.
Cross-examination.
I mean, it explains why it's so messy, but he's trying to undo some of the insinuations that you are the lead investigator, but there's a lot of shit you don't know. Why don't you know shit?
When defense counsel picked a sentence from a May 2023 interview of Carmen Lauber, where it was either you or Detective Maynard told Carmen Lauber that she was something like the biggest piece of the puzzle.
Yes, I remember that.
What was the context of that comment?
I mean, we saw it yesterday.
She said something about, can we just lay out all the information, all of the pieces in front of us? Because we were trying to establish a timeline. And we told her, you're the biggest piece. You're the biggest part of the information that we don't know. She had the information.
Sorry, I didn't mean to interrupt you. And did that context involve a piece of the drug purchase timeline rather than a piece of this whole giant case?
Correct. The timeline of her involvement, not necessarily the entire case.
And did that interview predate any information on the forensic accounting?
Yes.
And
we didn't even get into that until well after.
And did it predate any of Mr. Kotodimos' investigation?
Yes.
And did it predate?
I don't know if they would have gotten into the forensic stuff if it weren't for Kouri suing the estate. I don't know if all of that would have come to light the same way. Kouri suing the estate was really the impetus for the PI to get involved. The PI knows this case inside out, upside down, and backwards, and is probably cringing while watching all of this. But I don't know if that all would have been uncovered the same way if Kouri hadn't sued the estate, because I think it would have taken the estate some time. They would have eventually done accounting. It would have taken more time to unearth that, because I don't think it would have been at the forefront of the Richins family mind if they're in charge of the estate to really investigate the finances of the trust and what finances Kouri may or may not have used, because the trust would have just kept Kouri in the house, paying for the house and things like that. I don't know if the trust would have looked at that until maybe this criminal investigation started moving forward. So I think Kouri brought a lot of that on by suing the estate.
Your understanding of Kouri Richins' relationship with Josh Grossman?
Yes.
Do you recall whether
I stepped on Bloodworth's question about Grossman, sorry.
Investigation?
That's me.
The forensic accounting?
Yes.
And
we didn't even get into that until well after.
And did it predate any of Mr. Kotodimos' investigation?
Yes.
And did it predate your understanding of Kouri Richins' relationship with Josh Grossman?
Yes.
Do you recall whether that empty 2016...
They were trying to follow the drugs, not follow the money, which makes sense because they pulled him from a narco unit. And so he was trying to, that makes sense. From his perspective, a victim with a, what did he say, boatload of fentanyl in his system, track down the fentanyl. Track down the fentanyl first. They weren't trying to follow the money first.
With Josh Grossman?
Yes.
Do you recall whether that empty 2016 hydrocodone bottle that went with Eric Richins' body to the medical examiner's office was discarded by the medical examiner's office in August of 2022?
Object to hearsay.
That's leading.
Please lay some foundation. Sustained.
Do you recall what happened with the empty 2016 hydrocodone bottle?
Made my objection.
Detective, it's a yes or no. Start there.
Yes.
How do you know what happened with the 2016 empty hydrocodone bottle?
I was told by other investigators that they're
Objection.
Sustained on hearsay.
Well, I guess we know why
Did
the
you or
defense
did-
why the defense feels so confident focusing on the hydrocodone bottle if the ME's office discarded it. I guess we know why the defense isn't worried they'll just grab it and send it out for testing. Because the ME witness said she wasn't sure. The ME investigator's like, we check it in. But if the ME's office discarded it, but again, the jury's only heard the question. The question is not evidence, only the answers. But it does give context to why they're not worried that the prosecution's just going to go grab it from the ME's office and send it out. So the empty hydrocodone bottle, however, if the walk the dog letter's true, didn't she say Eric was storing his drugs in an allergy bottle in the truck? So I don't know if that'll come into evidence that the ME's office discarded it. Because the defense is like, no, objection, nope. Though it might come in rebuttal.
that they're
Objection.
Sustained on hearsay.
Yeah, that might have to wait for rebuttal.
Did you or Detective Maynard give Carmen Lauber a ride to anywhere other than
Yeah, that's gonna have
Wasatch
to
County
wait.
Drug Court or her attorney's office?
just here to this building
To this building?
to
or
meet
this
with
building?
prosecutors or talk with her attorney. They're here.
Can investigators force anyone to speak with them if that person does not want to speak with them?
No.
I mean, they try.
Can investigators seize someone's cell phone without a warrant based upon probable cause?
No. It has to be consent or a warrant.
At any time, have you believed that the walk the dog letter gave you probable cause to seek a warrant to seize Ronald Darden's cell phone?
No, it didn't contain enough information for me to have gotten a warrant.
Did your investigation determine that the EpiPens recovered from the Richins home were for one of the Richins children?
Yes.
Well, there's that question. So the EpiPens are
The
for the
gift.
kids.
The one with Kevin Spacey that says, idiots, idiots everywhere. Is that from the TV show House of Cards?
From my understanding, yes.
He's going to say House of Cards. The defense was like, oh, Kevin Spacey. House of Cards. It's House of Cards. This is all a House of Cards. This is a House of Cards. All of it's a House of Cards. Right.
Thank you.
Is that his last question? No, I think that was his last question. Well, the prosecution's been consistent on ending with the gifts.
I'm sorry, is he finished? We have no further questions, thank you.
May we release this witness?
Yes, Your Honor.
Mr. Bloodworth.
He said thank you. He did not say I tender the witness because the defense objected like 4 days ago. The defense said, Your Honor, he keeps saying the defense may have some questions for you, and we think that that is burden shifting. So he stopped saying it. He just said thank you. Your Honor, is he done? I think he said thank you. I'm going to rewind.
Thank you.
Yeah, he said thank you and then walked back to his seat. And the defense is having a huddle over at defense table. The defense is having a huddle.
I'm sorry, is he finished? We have no further questions. Thank you.
May we release this witness?
Yes, Your Honor.
Mr. Bloodworth.
Yes, Your Honor.
Detective O'Driscoll, you are free to go. You are released from any subpoena.
The state may be done with their case in chief. Remember, the state does get a rebuttal. So
Mr. Bloodworth.
Your Honor, the state has a stipulation to admit. I don't even think we have to publish it. So if the state could, I think we marked it as 865. We'll admit that now.
Okay.
I think the state might
Can I
rest.
see it for a moment?
So this is probably a stipulation regarding one of the pieces of evidence. I think the state's done with their case in chief, chat. Don't take that out of context. I think the state's done with their case in chief, which means we should be getting to the defense
Please.
motion to dismiss or directed verdict, motion of acquittal, depending on what they call it in Utah. Not
Do
clandestine
you want me to
chemistry.
give the Mujisic stipulation of fact preamble?
I want you to say Muji as much as possible, Your Honor. Emily, what does Muji mean? Model Utah Jury Instructions. M-U-J-I. Muji.
And read this to the jury? Or do you want to just admit it?
Your Honor, I think if we can just admit it now, during jury instructions, when the court would instruct on that, we can read this.
All right, we'll have a discussion about whether to convert this into a stipulation of fact instruction when the time comes.
Right.
Thank you, Your Honor.
Okay. State's Exhibit 8-65, titled Stipulation of Fact, is admitted by stipulation between the parties. Mr. Bloodworth,
I think they
Your Honor,
rest.
state's in an interesting posture.
do you need a moment on the record outside the presence of the jury?
We do.
Okay. I think this would be an appropriate time to just set a schedule for the rest of the day. Are we going to be able to, it seems likely to me, you tell me, that we'll be taking a recess now, but not coming back for about 90 minutes. Does that sound about right?
Your Honor, that's my sense of it. I'm waiting on a defense decision.
Okay.
Right.
Well, in either way, I'll bet you a steak dinner it's going to be about 90 minutes, but
Can we take the bet? Can we take that bet? I want that bet. Steak dinner for everybody. The court's like, I'll bet you a steak dinner. He's talking to the jury. It's going to be 90 minutes.
Sense of it. I'm waiting on a defense decision.
okay. Well, in either way, I'll bet you a steak dinner it's going to be about 90 minutes, but we're going to rise for the jury, and I'll send out word through the bail.
I'll send word. I'll send word. How very Devil Wears Prada of you. We'll send word. Sounds like the jury was chuckling. There has been a lot of wasted time in this trial. So the prosecution is in an interesting posture because they don't want to rest. And yes, Chad, I do think the court just asked us out for dinner. All of us. How many are there here right now? You were here when? There are just almost 38,000 of you here in the chat. Your Honor, we're gonna need a bigger restaurant, Your Honor. We got about 38,000 law nerds here. They were here when you invited us all out to dinner. So I'm just saying, it's needed. It's needed. The reason the prosecution's at an interesting posture is because they don't know what the defense is going to try to do. And they don't want, everybody's now going to see who blinks. I don't think we've watched a trial. As the jury goes out, I don't think we've watched a trial where we've seen so much of the chess playing in real time in open court. Maybe we have, but it's not coming to mind because we have seen so much of the pieces being moved on the board in real time in court. The cards are not being held as close to the vest. Is that a law nerd shirt in court? Chat? Is that our I have questions shirt? That looks like sold out law nerd merch to me. What is happening? That is 100% a law nerd shirt. I'm going to have to go to my closet and grab one in a minute. That looks like our I Have Questions shirt to me. Hello, court law nerd. We see your merch. Because it is this heart logo that is in court with the purple cardigan. Law nerd alert in court. That's funny. I did not see that this morning.
Mr. Bloodworth, we're on the record. The jury is not present. Tell me what's up.
Your Honor, the state's way.
Tell me what's up. That 100% is our I Have Questions shirt in court. I'll pull up an image. For those of you that are like, Emily, I don't know what that shirt is, I'll pull it up. I want to hear what's going to happen with the court, though. And we'll go there from then.
Waiting on the defense's decision regarding the Norris matter. Because if they want to proceed in one fashion, the state will call some additional witnesses in its case in chief. If they want to proceed in another fashion, then the state will rest.
This is what I was trying to tease out, and I apologize for not being more specific. Given that they did not open the door to this issue through any of the state's witnesses in the state's case in chief so far, I understand the possible order of events from this point forward to be they'll make a decision about whether in the defense case to open the door to it. If they do, the state would be able to respond by, among other things, publishing evidence of Mr. Jeff's statements and, forgive me, the other gentleman?
Bonsavage.
Mr. Bonsavage's statements as part of the state's response to or rebuttal of the defense's theory of a failure or to investigate or incomplete investigation. But they haven't opened the door yet, so I don't think there's any need or ability for the state to get into it in its case in chief.
Okay, Your Honor, then the state rests.
Okay.
Okay.
With the state having rested, Ms. Nestor, does the defense have a motion?
We do, Your Honor. Mr. Ramos is going to take care of that.
Okay. So the state rested. The state was waiting to see what the defense was going to do. The defense was just like, we'll see what we want to do. And the state's like, okay. The state gets a rebuttal case. The defense can choose to A, be an agent of chaos, which seems to have happened today, and B, they can choose to try to call these witnesses later in their case in chief. They get to make that choice. So it's who's going to blink first, and the prosecution's like, well, you're kind of stuck with it. Ramos is going to be making the motion to dismiss arguments. I'm interested to hear his motion to dismiss arguments. It is very rare that these motions to dismiss get granted. And I think we will see kind of an outline of the defense closing, but we already know what they've been saying, right? We know that the defense has been saying they haven't proved that Kouri gave him the fentanyl. They haven't proved that she made any representations to the insurance company. They haven't proved. That's what we're going to hear. So let's hear their motion. And, the prosecution rests. What a wild day. I'm glad to hear from Ramos, honestly. With the three-piece suit today for the arguments. I'm here for it.
Your Honor, under both Rule 17-0 as well as 77-17-13, discharge for insufficient evidence, the defense presents the following and moves for a directed verdict. At the conclusion, this is just for the record, Judge, as Your Honor knows, at the conclusion of the evidence by the prosecution, which has just been done, the court may issue an order dismissing any information or indictment or any count thereof upon the ground that the evidence is not legally sufficient to establish the offense or offenses charged therein, or
This
any
is the standard.
lesser included offense. Judge, based on the evidence that has been presented over the past 10 days or so, including all inferences, of course, that can be reasonably drawn from the evidence, it is the position of the defense that some evidence exists from which a reasonable jury could find that some, however, not all of the elements of the crimes that have been proven beyond a reasonable doubt.
So,
In terms of the sufficiency,
I appreciate the calmness, but B, Ramos is going through what the standard is. I think if it continues going, I think we're going to get a very organized motion here where he goes through the elements of each case or each charge and argues those elements. He laid out the standard at the beginning. I think we're going to get full, like, proper legal argument, kind of issue, rule issue, you know, and then the elements of the offense. They do this in every case unless somebody is representing themselves and forgets. So, yes, every case at the close of the prosecution's case, there will be a motion made to dismiss. It very, very rarely happens, but it can if all the elements are not proven. And remember, we have a murder, an attempted murder, 2 insurance fraud counts, and a forgery count.
of the evidence, Judge, I'll start backwards, starting with count 5. With regards to the forgery, even looking at all the inferences in favor of the state, we do not believe that the state has proven a specific intent to defraud as it relates to the forgery. There's no proof that the signature was done without Eric's authority. And even assuming that the defendant, Ms. Richins, signed on behalf of Eric with or without permission, that itself does not conclusively presume that because she signed the name of Eric, that a forgery has occurred. The act, in other words, of signing another's name without permission doesn't constitute forgery, again, unless it was done with the intent to defraud, which we don't believe it has been met here. In terms of count 4, and forgive me, Judge, the way I'm approaching this is based primarily on the information, the criminal information, as the facts were laid out there.
Right.
It was a bit difficult
insurance
to follow
fraud.
through the testimony as to exactly what the state's position is. According to the criminal information, the basis for the true stage count 4 insurance fraud is that Ms. Richins, or rather True Stage left a voicemail with Ms. Richins requesting a copy of the prescription, any prescription Mr. Richins had for fentanyl. Then later that same day, Ms. Richins informed True Stage that fentanyl was not prescribed and that she had no idea how Eric obtained the fentanyl.
I think it's that last clause of that sentence that this is the state's prima facie showing.
Right.
You see it differently.
And taking that as their basis, what the evidence has shown thus far has been that Ms. Richins sought and procured oxy from Ms. Lauber, that while Ms. Lauber indicated that it was fentanyl, her source, Mr. Crozier, provided fentanyl, that Mr. Crozier did not provide fentanyl. Rather, he provided prescription-grade oxy. From that moment, from the supplier, Mr. Crozier, to Ms. Lauber, the evidence is that what was provided was oxy.
May I ask you a direct question about that?
Sure.
Yeah,
Why
X'd it out.
couldn't a jury, properly instructed on the law and consistent with the court's duty when considering a motion for directed verdict, drawing all inferences in the state's favor, view the evidence as showing that Robert Crozier sold to Carmen Lauber 15 to 30 bluish pills marked M30. Carmen Lauber provided them to Kouri Richins, and then, based upon the testimony of Eric Haskell, that during that time frame, bluish pills marked M30 likely contained fentanyl?
Two responses. One, the testimony from Mr. Crozier as to the quantity and the amount per pill does not jive at all with the Haskell testimony as to how much fentanyl grade, or I guess street level,
He said he
non-prescription
was selling them at the same
pills were
cost.
going for. What was indicated in the evidence was the amount that was paid was consistent with prescription grade oxys. So that's how I would answer Your Honor's question.
Okay.
Remember, at this stage, all reasonable inferences are taken in favor of the state. So the defense is trying to point out at this element, it's a miss, at this element, it's a miss, at this element, it's a miss. But all reasonable inferences are taken in the favor of the state. They're the non-moving party. That doesn't mean you have to agree with those inferences. It doesn't mean a jury has to agree with those inferences. It means that they can. A reasonable jury, properly instructed on the law, can make those inferences. At this point in the proceedings, all reasonable inferences, not Alexis shot up into space, got fentanyl, and like dropped it onto Eric Richins' face. That's not a reasonable inference of fucking anything, obviously. But reasonable inferences based on the evidence are taken in favor of the prosecution at this stage of the proceedings. So you're going to see the court pushing back on, couldn't the jury think this? Couldn't the jury find that? It doesn't mean that the court agrees. It means that there are, and sometimes, multiple reasonable inferences at this point. And for you watching this case, you might be like, no, there's multiple reasonable inferences for me. And that shifts things because there's multiple reasonable inferences for me. And if I have multiple reasonable inferences, then that's a not guilty. So that's where we're at with the court pushing back on it. And what could a reasonable jury find? And I think the defense is pushing on the counts that are not as well fleshed out in the state's case. And so I think that's why they started with the forgery and are working back.
Count 3, as I understand it, is that Ms. Richins, again, according to the criminal information, had indicated a phone number with an incorrect digit. The signature on the application that purported to be Mr. Richins is a forgery. We talked about count 5. And then in the context, and I think it was also the P.O. box. I imagine they were trying to establish that Mr. Richins didn't have access to that or something to that effect. I don't believe any evidence has been presented to that degree or
The P.O. box, circumstantial evidence that Eric didn't know about it.
not necessarily.
If I view the inferences in the light most favorable to the state.
And even with that, Judge, I mean, there was no evidence presented at all that from the Postal Service or anybody saying that Mr. Richins had no idea that that P.O. box existed. There was a statement and a question made by, I believe, the state, but no evidence was presented to show that that was actually the case. That's how I would answer Your Honor's question. Also an interesting point. Term life insurance. At the moment that she allegedly signed on behalf of Eric and was submitted and was paid from her account, I am not certain
This is an interesting
that
point.
Your Honor could find that that term life insurance actually had value.
That's
What I
an
mean by
interesting
that
point.
Is that there is case law, of course, in the civil process or context, that in the context of term life insurance,
That's a really good
courts
point,
have specifically
Ramos.
addressed whether such policies have value as property. And the Court of Appeals in Beckham v. Beckham, I didn't write down the citation. I'll provide that, Your Honor.
Beckham who? Which
Held
Beckham by
that
Beckham?
term life insurance policies generally have no cash value and therefore no property value. This is, of course, in the context of marital assets. So I bring that up. I think that's an interesting point. Obviously, it was marked for $100,000, but the actual value of that, I don't know, it raises an interesting issue.
Doesn't the statute talking about the elements of that particular crime for count 3 talk about property, money, or things obtained or sought to be obtained?
Correct. And that was going to...
Well, Your Honor, when you throw the or in there, it changes things. When you put the or on the rest of the statute, fair, it changes it a little bit. Or sought to be obtained, because it will have value at some point. I mean, fine.
To be my last point is at that moment, what the state needed to provide or prove, put forth evidence, is that at the moment that Ms. Richins allegedly signed on behalf of Mr. Richins for $100,000 term life insurance, that at that moment she knew that she was going to attempt to take her husband's life. And I don't believe they've met that, Judge. That's how I would answer that.
Okay.
With regards to count 2 and 1, most of these arguments overlap, but I will attempt to keep them separate, Judge. As I understand it, in order for them to have met the elements, in order for Ms. Richins to be found guilty of an attempt, she must engage in conduct constituting a substantial step towards the commission of the offense. Here, evidence has been presented that she did seek to obtain oxy. We've had that discussion. Obtaining that oxy, just obtaining the oxy itself, is mere preparation. There is case law, as I'm sure Your Honor is aware, in State v. Johnson, 821 P2D 1150, that indicates that that is not enough. Coupled with the information that we just discussed as to whether it was oxy, whether it was fentanyl, I believe that's even Ms. Richins' case currently is even in a better posture than Ms. Johnson. So with that, if we look at it in the context of the Valentine's Day, there is no evidence at this point that what was obtained was fentanyl. One, even if it was oxy and she sought to obtain that, beyond that, there's nothing else, no other evidence that indicates that Ms. Richins took those pills, the greenish blue ones, I think at that time 15 milligrams is what Mr. Crozier said, and did anything else with it. I think the evidence as to Mr. Richins ingesting a sandwich is clear in terms of Ms. Richins picking it up. Absolutely. That his reaction was a result of that and not anything else. I believe that the evidence is scant. Your Honor has a question.
No, I'm following.
He's like, Your Honor, your face looks like it has a question.
I will say
your
that
face is
even in the Johnson case, the evidence was clear that the defendant in that case had actually obtained a specific type of drug, methamphetamine. So even in that case, they knew exactly what was obtained. Here, it's unclear what was obtained. I will add this before I forget. It relates to all of this in your prior question. In terms of the pills, Ms. Lauber testified the amount of pills that was significantly different from what Mr. Crozier had indicated, as well as the packaging. I believe that's important in the court's consideration in terms of what type of pills ultimately were given from Mr. Crozier to Ms. Lauber. This same argument, not to rehash it, applies to count 1. And it leaves us with the administering of the drug. Zero evidence has been presented besides that fentanyl was in his system, in his gastric, and it was possibly orally ingested. There has been no evidence in terms of the administering of whatever it was at all. Judge, for those reasons, the defense requests that Your Honor exercise your duty under both the Rule 17 as well as the code, and we move for directed verdict on those counts, Judge, for those reasons, unless Your Honor has any questions.
And then we'll hear from the state.
You'll get the last word.
Thank you.
Because it's their motion, they will have a chance to rebut the state's arguments. We'll hear the state's arguments.
Your Honor, can I perhaps begin by asking the court if the court has any particular element that they would like the state to speak on?
Oh, I understand the standard. I believe I understand the state's theory on each of the counts, especially 1, 2, 3, and 4. Speak to count 5 if you want to. Specifically, Mr. Ramos's argument regarding lack of believable evidence regarding intent to defraud.
This is the forgery, count 5.
Your Honor, it ties into count 3, right? It's the same insurance. This is the $100,000 true stage policy. And the scheme charge, the scheme fraud in count 3 is that Kouri Richins, at the time she took out that $100,000. Well, this is interesting. The timing doesn't matter for count 3, but the timing does matter for count 5.
We're talking about,
as it relates to count 5.
He's talking about the insurance fraud and forgery counts. So 3 and 4, insurance fraud, 5, forgery.
At the time she forged Eric Richins' signature, she intended to defraud. I think the evidence that supports her intent is the fact that nothing on the face of the application indicates that Eric would know of this application, right? The mailing address, the email address, the phone number, everything, the payment, everything comes back to Kouri Richins. And she signed this, I think it was late January 2023, at a time when she had...
January 29, 2022, correct?
I'm sorry, 2022. It was the end of January 2022, at a time when she had already begun asking
Carmen Lauber,
Hayden Jeffs, and Carmen Lauber for drugs of some sort.
Is the timing
at a time when she had already expressed her...
I don't remember what the timing was that Hayden's partner said that call happened. But it's interesting that this was signed when Kouri was already starting to ask people for the prescriptions.
Interest in starting a fresh life with Josh Grossman.
And that's
and at a time when she had told Becky Lloyd that she would be better off if Eric was dead. And at a time when she had told Josh Grossman if he would just go away. So there is sufficient evidence in the light most favorable to the state that a reasonable jury could find that on January the 29th, when she forged Eric Richins' name, she had intended the entire fraud scheme that's charged in count 3.
Understood. Anything further?
No, Your Honor.
Okay.
Thank you.
Mr. Ramos, anything further, sir?
Just briefly, this is, of course,
The prosecution focused on the forgery and insurance counts frauds most, not as much on the others, because that's what the court asked him to narrow down on.
Mr. Bloodworth wants to respond to this. I did neglect in my argument initially as to count 2 the testimony regarding the joking nature conversation that Ms. Stakings had that she testified to with both Ms. Richins and Mr. Eric Richins. Of course, Your Honor, heard that, so I would just add that for the record.
Understood.
Thank you.
Thank you. Mr. Bloodworth, anything further?
No, Your Honor.
All right, folks. I appreciate the argument. This is an important motion. Let me just take 5 minutes to collect my thoughts, and I'll give you a ruling. We'll be in recess until 5 of noon. Thank you.
We're going to zoom. We're going to zoom past them going out of court. So Ramos, again, focused on the forgery and the fraud. I think they are easier to illuminate an argument than maybe they were through the testimony. I wonder if the jury even is like, wait, what? When did, who? We saw Throckmorton and then what? Which is fair. So we're going to zoom to the court's ruling with regard to the motion to dismiss. It looks like he takes a minute. Hold on, let me refresh my feed. It looks like he takes a minute on that ruling. And again, we are behind real time and in local time. So let me zoom past the court break to get to the court's ruling on that. Because I am very curious what the court has to say, especially as to the forgery and the fraud counts. Because I think as to the attempted murder, it's easier to line out where the prosecution has met their burden for the motion to dismiss. I think Ramos was wise to focus on the forgery and insurance fraud counts. And I think those are going to be harder even at closing to parse out when we eventually get there. So they should be coming back. I saw the top of the judge's head. We should be getting back onto the record.
2-3-1-5.
Oh, definitely not an athlete, said EDB. Have you had one where the judge grants it? Yes, there are cases where I have seen the judge grant it. It's more common from what I have seen that it's been as to like a 1 count. Because I have seen cases where you have had like multiple forgery counts and one victim doesn't show up. And sometimes you're like, we'll just move to dismiss this count. So it's not really at the motion stage, but it can happen where a count is dismissed here and there. And it can happen where victims for certain counts don't show up and those get removed at the same time at the close of the case. It just depends.
00139. State's counsel and defense counsel are present. Ms. Richins is present. Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yes, so that's fine.
Okay.
Aren't we just going to do the ruling?
Ms. Lewis, Ms. Nestor, what's the plan?
Wait. Aren't we just going to do the ruling? Did I miss it? Did I zoom too far? Aren't you just going to rule? Did I miss him coming back with the ruling? No. Oh, maybe I did miss him coming back with the ruling. Hold on. Did I? Did I zoom too far? I might have. I mean, Baldwin
Back on the
was
record in
different.
case
But Baldwin wasn't a motion to dismiss. Baldwin was a remedy for, well, fuckery.
231-500-139.
I went way too far.
Counsel for the state are present. Counsel for defendant and the defendant are present. The issue before the court is defendant's motion
went way
for a
too far.
directed verdict, seeking dismissal of counts 1 through
Told y'all I
5
was
in
tired.
the operative information. It has long been established that the elements needed to make out a cause of action may be proven by direct and by circumstantial evidence. And if there is any evidence, however slight or circumstantial, which tends to show guilt of the crime charged or any of its degrees, it is the trial court's duty to submit the case to the jury.
I did zoom too close to the sun. The court is stating what they are using to evaluate. So the court is lining out the framework for their ruling and what the law says. So the court has started all of its rulings with this is what the law is.
Which tends to show guilt of the crime charged or any of its degrees. It is the trial court's duty.
Let me just back up. For any of you who are asking what the rule is, what the law the judge has to follow, here it is. I know I zoomed way too far. I made myself motion sick by zooming so far. Yes.
It has long been established that the elements needed to make out a cause of action may be proven by direct and by circumstantial evidence. And if there is any evidence, however slight or circumstantial, which tends to show guilt of the crime charged or any of its degrees, it is the trial court's duty to submit the case to the jury. When evaluating a motion for directed verdict, the court is not free to weigh the evidence and thus invade the province of the jury, whose prerogative it is to judge the facts. Rather, the court's role is to determine whether the state has produced believable evidence on each element of the crimes from which a jury, acting reasonably, could convict the defendant. Not will, not would, but could.
Right.
Moreover, the evidence must be viewed in the light most favorable to the state. Applying these legal principles as announced by the Utah Supreme Court in State versus Montoya, 2004 UT 5. The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied.
I mean, we kind of figured that was going to happen.
Ms. Nestor, you asked for time to speak with your client to make some strategic decisions. Is between now and 1 p.m. sufficient time?
Yes, Your Honor.
Okay. Mr. Bloodworth, anything further before we recess until 1 o'clock?
Nothing further, Your Honor.
Ms. Nestor?
No, sir.
All right. We'll be in recess until 1 p.m., just confirming that to the extent the defendant will be putting on evidence or calling witnesses, you have a couple in the wings. Is that correct?
Yes, sir.
Okay. 1 p.m. Thank you for your time.
All right.
Court's in recess.
They will be back at 1 p.m. Well, I want to see what the court was saying. So if we need to take a break later, we will. But we already zoomed too close to the sun. So let's go take a look at what the court has to say, because we're going to go take a look at what the court has to say, because I went and got my sweatshirt earlier. So we'll just do it at lunch. All right. So the court, where are we? We're at the lunch break. This case has been such a wild roller coaster that I actually think maybe I'm not just tired and I'm motion sick. Emily, you're sitting in your office at a desk. Yep. It has been such a up and down and up and down and up and down that we are now at the lunch break. What day is it? Day 13. The prosecution is rested. The defense made their motion, essentially their motion to dismiss, their motion for directed verdict, arguing that the state has not met its burden. And while I think Ramos focused on the proper arguments. I think where the court ended up is where we're at. It doesn't matter that it is circumstantial evidence. Is there enough evidence when all inferences are taken in the favor of the state, the non-moving party? Is there enough to submit this to the jury? And that's what the question before the court was. The court took a quick break and said, yes, there is enough to submit this to the jury. So that's where we end up at the lunch break. The court asked the defense if they have any witnesses in the wings to the extent they choose to do that, because of course the defense is not obligated to put on a case, not obligated to put on any witnesses. They proffered a fairly extensive witness list, including experts. They indicated in pretrial extensively that they needed time for their client to testify and set out time for them to do that. So the state is rested. The defense motion has been denied. They are at the lunch break. And since I already zoomed past it by accident, we might as well go see what the judge has to say, because we zoomed past it by accident anyway. Today has been, I see how busy the mods are working. Don't make me close chat. I see that the mods are busy, which also indicates to me shit's afoot. But we're just going to go find out what happens in court, because we like watching it together in real law nerd time. Because again, we'll just figure it out. Are we ready? Let's see what happens after lunch when the judge resumes. Because I'm still not over the fact that the jury was waiting for like 2 hours this morning. I'm still just not done.
231
Keeping the jury waiting for 2 hours this morning was fucking
State's
wild.
counsel and defense counsel are present. Ms. Richins is present.
Okay.
Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yeah, so that's fine.
Okay.
Because he doesn't need to rest on the record.
Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
Can we have just a minute?
Yeah.
We have
What?
a couple of options.
Understood.
You just had like a 90-minute lunch. We just had a 90-minute lunch. What are we doing?
Your Honor, actually, at this time, the defense intends to rest.
What?
We should probably do that in front of the jury, yes.
Right?
Okay.
I agree.
I just want to make sure you've... Nope.
Mention it all. Mention it all.
I'm sorry, counsel. What? Okay. Sure. We talked about this yesterday, didn't we? We talked about who was going to blink first on the chessboard. Was the defense going to blink, or was the prosecution going to blink? And it seems like the defense is like, no witnesses. No witnesses. After everything that went on this morning, well, that makes a lot more sense now. That makes a lot more sense now why they fought so hard this morning, doesn't it? Because they wanted to push the absolute limit without having to call any witnesses. They're allowed to not call any witnesses. But we talked about this yesterday about whether or not they were going to try to call the prosecution's bluff and whether or not there was stuff that the prosecution might put in at appeal or not appeal. At somebody must have been talking about appeal in the chat and my brain was just like word to stave off a rebuttal case and just mount up and ride with just what the prosecution has put in. Interesting strategy. Probably better than letting the state have a crack at a rebuttal case, though, because the state does not get a rebuttal if the defense doesn't put on anything. There's nothing to rebut. Let's watch that again. I can't believe that they're still sitting at counsel table chatting like they haven't decided over the lunch break. So if they rest, then we're done, except for closing arguments and jury instructions.
00139. State's counsel and defense counsel are present. Ms. Richins is present.
That's a strategic choice.
Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yes, so that's fine.
Okay, will do.
Now I see why the mods were working so hard. Thank you, mod
Ms.
squad.
Nestor, what's the plan?
Ready to go.
We're ready to go.
Defense counsel's.
Wait, what is this? What is this gamesmanship that is still happening? We're ready to go. What is this gamesmanship? Do you have witnesses lined up? Yeah, we do. Thank you, mods. Y'all know how sad spoilers make me because I like to react in real time and you can't do that if they're spoilers. Huh. When they broke, do we have witnesses in the wings? Yeah, we do. Defense ready? We're ready to go.
Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
We're not doing anything, Your Honor. We're done.
That's fine.
Okay, will do. Ms. Lewis, Ms.
Is this
Nestor, what's
just
the plan?
pure gamesmanship? We're ready to go.
Who's defense counsel's first witness?
Is this pure gamesmanship at the counsel table?
Can we have just a minute?
Yeah.
Why?
We have a couple of options.
Understood.
What do you mean you have not decided? I don't believe for a fucking second that y'all haven't decided. They had a massive lunch break. There's no way y'all didn't decide. What's the theater going on here? Oh, we have a few options. Should we do it? Do you really want to do it? You would have had to have discussed this with your client. Oh, Your Honor, we're ready to go. Are you? We have a couple of options. What do we want to do? I don't know. There's no way you're actually making this decision in real time. Oh, the whiplash.
Your Honor, actually at this time, the defense intends to rest.
We should probably do that in front of the jury, yes.
Right?
Okay.
I agree.
I just...
Oh, gosh, I would love to see counsel table's face on the other side. At this time, we rest. It's a bold strategy. Kouri looks like she's about to vomit. Am I reading too much into that? Chat, tell me if I'm reading too much into that, because she does not look settled. No. We're not going to do that. I just wanted to rewind it to watch the defendant's face again because I'm still buffering.
Your Honor, actually at this time, the defense intends to rest.
We should probably do that in front of the jury, yes.
Right?
Okay.
I agree.
I just want to make sure you've consulted with your client about this.
Absolutely.
Okay, then why did you come out and say we're ready to go? We've got a few options, have the theater of whispering at each other, and then say we're not calling any witnesses. If you consulted with your client, you did it during the lunch break, and you knew when you came out that you weren't going to call any witnesses. So why the fuckery? Ugh, I hate it. I hate the fuckery that feels like it's for the sake of fuckery. There is room between zealous advocacy and fuckery, and it seems that the fuckery is winning at the moment. All right. And the judge is like, really?
We should probably do that in front of the jury, yes.
Right?
Okay.
I agree.
I just want to make sure you've consulted with your client about this.
Absolutely.
Is now an appropriate time to get a waiver
To do the
of
colloquy?
Ms. Richins' right to testify on the record?
Yes, you can.
Okay. You've consulted with Ms. Richins about her, or advised Ms. Richins about her right to testify, correct?
At length.
Okay. Ms. Richins, may I ask you 2 direct questions?
Yes.
Do you understand that you have the right to testify?
All right. They are taking the waiver from the defendant. And the defense is putting on no case. They're allowed to do that. Earlier, just withdraw everything I said earlier with the, we don't have to decide now. We have to see the rest of the case come in. No, this is it. This is the rest of the case. Done and done. I want to see the prosecutor's face. But the defense had a pretty extensive witness list. That's why the defense really wanted to get into the photos with the prosecution's last witness, because I imagine that they knew that they weren't going to put on any witnesses this morning, right? So when they were trying to get into those photos that they wanted to argue in closing, they wanted to just kind of squeak those in with the IO, because that was the last thing they wanted to argue. See, it's about the house. It's about the house. I think this is one of the best plays the defense has made this case. Yeah, absolutely. But that's why they were pushing so hard to see what they could pull in through the IO, because the prosecution has kept their case narrowed in. And with the massive break this morning and all of the puttering and nonsense, you get a little bit of distance from the walk the dog letter. Interesting. Also, the jacket and the sleeves and all of it. Today doesn't even feel real. Doesn't even feel real.
At trial.
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
I accept your waiver. I find it's knowing and voluntary.
Yeah.
Okay, thank you. Anything further on the record, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth, how would you propose we...
Mr. Bloodworth, how you do? How's your blood pressure? I think that is one of the smartest moves we've seen the defense make. It is a big decision. They said at the beginning of all of this, we need this much time for the defendant to testify. But again, some of trial is not just trying your case, but also knowing your opponent and keeping them moving around. And so the more the defense can throw up, oh, it could be this, it could be this, it could be this, it could be this. And the state is just like narrowed in, the defense has room to argue. The gifts are about the house. We don't have any evidence of this and this. Oh, we're going to have so much to talk about. Let's see what happens.
proceed from here for the rest of today?
So let me backtrack a little bit on your earlier question. I think I should then rest in front of the jury.
Yeah,
Understood.
if they're going to rest in front of the jury.
defense can then rest in front of the jury. I think then for the rest of today, and I
You got to
propose
do jury instructions.
tomorrow, the court recess, and that we begin. The parties can work on
Jury instructions.
jury instructions perhaps today or tomorrow, but then we instruct and close on Monday.
Oh, I don't know if the court's going to do that.
My face is not telegraphing any opinion one way or the other. I'm just waiting for a response.
my face is neutral. What do you want to do? The judge, my face is just, huh?
Could close on Monday.
My face is not telegraphing any opinion one way or the other. I'm just waiting for a response.
I don't think we have a problem with that.
Oh, y'all want the weekend?
We were thinking it might make sense to get the jury instruction conference out of the way, and then...
I agree with you. May we do it tomorrow? Give the counsel, both sides, a chance to talk to each other about any additional instructions you think might be necessary, narrow any differences or discuss any differences you have regarding any of those, and we can have that conference tomorrow.
Yeah, yes, that's fine.
Okay. So we'll talk about scheduling about that. Just want to make sure we're all comfortable with the jury being out in the wild between now and Monday morning. Yes?
Yes.
I mean, as long as they're not partying with their pants off like Bryce, it should be fine. So, closing arguments on Monday? I did not intend that. I did not see that coming. They said they were going to be in trial through March 27th. Nope.
Nope.
This case has been unexpected. And then for the judge, we get to the very end of the case, and today Bloodworth's like, we'll just mention it all. And the judge is like, my face is saying nothing. And we still don't know why Bryce didn't have any pants.
Okay.
Wow.
Okay.
Okay. The judge is like,
All right. Are we ready for the jury, Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
okay. ST71778 said LawTube scrambling for a new case. Oh no, not it. Definitely not. There is so much stuff I'm behind on. There is no scrambling over here. We are booked and busy. Nope. This one's not done yet. And even when we think it's doing something we understand, it's not. Jury's coming back in to be instructed. It sounds like we got a jury trial conference tomorrow. Y'all have whiplash yet? I love that everybody's like, what's the next case? This one's not done yet. At all. This one is not done. I think it's funny that everybody's like, okay, moving on. No, we've got the best part coming up. Jury instructions and closing. And we've got a law nerd in the wild in court wearing the EDB law nerd merch. Today's been unexpected. Well, I guess everybody who's in court today is glad they're in court today, because that's a really big decision to make for Kouri Richins, to decide that they are going to rest without putting on a defense, which they don't have to, and throw their defense to the state didn't prove it, which is their right to do. So
Have a seat as you come in.
it's a difficult strategy when there are emotional pieces to the case like this, to throw it up on the state didn't show you how the fentanyl got in his system.
Thank you.
It makes the end of Miss Nestor's closing. It makes the end of Miss Nestor's cross-examination today make a lot more sense, because I don't think they just decided that in the moment at all. But it makes a lot more sense why Nestor was talking to the IO about the photos, the gifts, and you don't know how the fentanyl got in his system. You don't know the time of death. That makes sense that that's where the defense wanted to bookend. I do not like the defense team's delivery a lot of the times, but I have said that they had a strategy, and we can see the through line of the strategy even when I don't agree. But to stand on, no, you didn't prove it, is, I think, a good decision for the defense. I think it's a very
Mr.
good decision
Bloodworth.
for the defense.
Your Honor, the state rests its case.
Very good. Ms. Lewis.
Your Honor, after consulting with our client, the defense rests.
Understood. Thank you. Ladies and gentlemen, there is
That's
some
it. Done.
legal work that I need to do with counsel in this case to get from here to the next stage. Rather than use your time inefficiently with you in the courtroom, we're going to do the following. We're going to recess for today. You will be on your own in the wild between now and 8:30 a.m. on Monday morning. I cannot emphasize this enough. Between now and 8:30 a.m. on Monday morning, please do not say anything about this case to anyone. I would understand if you had to tell somebody that you have to be back here at 8:30 a.m. on Monday morning. Other than that circumstance, please do not discuss this case with anyone. Do not allow anyone to attempt to talk to you about it. It will take affirmative effort and diligence.
Right.
I need you to use that same affirmative effort and diligence
they don't have
to
mods
make sure you
to eat-
avoid
they don't have mods to eat
watching,
things.
listening, or reading anything about this case from any source whatsoever. And please do not do any search, research, query, anything of any kind between now and 8:30 a.m. on Monday morning. Please travel safe. Enjoy your weekend. I'll see you at 8:30 a.m. on Monday.
Wow. Well,
Please rise to the jury.
I think the defense is going to, in closing, lean very heavily into if there are two reasonable interpretations for any fact, you must pick the one that leads to not guilt, or however it is languaged in Utah. But there is a jury instruction that talks about two reasonable interpretations, and I think the defense is going to lean heavily into the two reasonable interpretations. I think the defense not letting the state have a crack at rebuttal and not having the prosecution team be able to cross any of their witnesses is smart.
All right, folks, have a seat.
The biggest question was, is Kouri going to testify?
May I propose
And the defense said all along, Kouri's going to testify. I imagine the prosecution prepared their case as if Kouri would not testify, and then you deal with it if she does. You do not prepare your case the other way around. So I'm sure, even though the defense said Kouri's going to testify, they planned their case for Kouri's not going to testify, we'll deal with it if she does. Because it's always, a bold choice for the defendant to testify. And many of you were like, I don't care if the defense says she's going to testify or not. She's not going to. Well, she's not going to. And it told the court that with less fuss and bother than Donna Adelson did. And I think it's probably the smartest decision she could make. Would I have liked to have seen Kouri Richins testify? Absolutely. But the defense, well, let's see what happens at the end of the day, because I guess we're getting to the end of the day then.
Following.
Because they're going to do
That
instructions
counsel
tomorrow, and then we'll talk about it, or what I think.
Have an email exchange or a phone call, say 4 p.m.-ish today, about the state of the jury instructions and whether you think there need to be any additions or amendments. And then, to the extent there are, please send me an email or file something in the docket and let me know that you did. And then what time would you like to get together to talk about the instructions one by one tomorrow?
9:30.
Do you want to do it a little later just so I have time to...
Oh my God. Who said 9:30? I got to back that up. When the court suggested, could we do it a little later? Never has Miss Nestor looked so happy in this court. Please, can we do it later? I relate to that so much. Please, can we come in later in the morning? Yeah, because these attorneys are tired.
Please send me an email or file something in the docket and let me know that you did. And then what time would you like to get together to talk about the instructions one by one tomorrow?
9:30?
Do you want to do it a little later just so I have time to look at whatever happens?
Late as possible.
Want to do it at 1?
Yes.
Ooh,
Mr. Bloodworth?
Sure, sir.
All right.
yes, sir. Oh, that's exciting. 1 p.m. We can do that.
So
Happy with that.
You're all at least going to compare notes by the end of the day today. And if you file anything additional, you'll let me know by email. And I'll plan on being back on the record with you all 1 p.m. tomorrow. Mr. Bloodworth, anything else today?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Richins, 1 p.m. tomorrow. The court is in recess. Thank you. All rise.
Wow. I mean, awesome. I'm very excited about court being back at 1 p.m. tomorrow, but maybe only as excited as Miss Nestor, who was clearly very excited to come back at 1 p.m. tomorrow. Magdalena, will you send out a notification to the app and let them know that that if they missed it, they need to come on back and have a chat? I don't even know how we word that. The defense rests. And we're going to have to talk about it because y'all have a lot of questions. And I went to the bathroom earlier planning on streaming for another like 3 hours. So we got some time to answer some questions. I guess we can release the chat a little bit. Let me go do that. Will you send an app notification, Miguelina? I'll release the chat a little bit now that we are back from the brink of spoilers. I know the mods must have been working very hard to keep the spoilers at minimum, which must have been frustrating, chat. So for that, I know the mods were working hard. I saw that the times got bumped back into the chat to try to help with that because we want to watch in real time. There will always be those on the internet that are like, haha, fuckery. So apologies, chat, for anyone who did spoil, but most of them probably won't be able to spoil again because they would have been yeeted from the channel. So I told you all this trial, I got no patience, just none, just no patience. And a lot of you said, oh, I only see people talking about spoilers. Don't worry. The mods yeet them before people see them, but it is an interesting day in court. There are a lot of questions. I am going to try to summarize what happened today because it's just whiplash. And then Miguelina, I can't pull up questions at all. Well, that's going to make it difficult. I can't change I can't change anything. And I cannot pull up chats at the moment. So let me give a summary and see if that will fix for me because I cannot pull up chats because things are freezing on my end. Okay. You know what I kind of want to do? Chat, can I beg the chat's indulgence? I kind of want to go back and see what the defense said when they were leaving for lunch. And then I want to see what they said after lunch. And then we'll do a summary. Does that work? I hope that works. I'm curious. And since we've got a minute, since we're just chilling, oh my goodness. I'm not totally surprised. I'm not totally surprised because it's a very smart move. However, I am surprised by the amount of like acting and playing up the oh no, we're doing this, we're doing that. That part surprises me more than the strategic decision surprises me. But I should not be surprised by the gamesmanship because we've seen it throughout this trial. We've seen things get shifted and shifted and shifted and shifted. And we've seen it. But when it is playing in the court's face is where it still surprises me. Though it shouldn't, because the defense team's done that a couple times. But I do find it surprising to kind of drag the court through that. So let's see where we're at. I have backed up to before the lunch break because I'm curious what was said. Let's see if we've queued this up to the right spot real quick. For those of you just coming in, we are revisiting some of the things that happened today, and then we've got a lot to talk about.
Any subpoena.
Thank you.
Thank you, sir.
So this is them letting O'Driscoll go. They're going to let the jury out, kind of in the who let the dogs out fashion. The court bet everybody a steak lunch. I think they were out for 90 minutes.
The jury is not present. Tell me what's up.
Your Honor, the state's waiting on the defense's decision regarding the Norris matter, because if they want to proceed in one fashion, the state will call some additional witnesses in its case in chief. If they want to proceed in another fashion, then the state will rest.
This is what I was trying to tease out, and I apologize for not being more specific. Given that they did not open the door to this issue through any of the state's witnesses in the state's case of chief so far, I understand the possible order of events from this point forward to be they'll make a decision about whether in the defense case to open the door to it. If they do, the state would be able to respond by, among other things, publishing evidence of Mr. Jeff's statements and, forgive me, the other gentleman?
Bonsavage.
Mr. Bonsavage's statements as part of the state's response to or rebuttal of the defense's theory of a failure or to investigate or incomplete investigation. But they haven't opened the door yet, so I don't think there's any need or ability for the state to get into it in its case in chief.
Right.
Okay, Your Honor, then the state rests.
Okay.
Okay.
With the state having rested, Ms. Nestor, does the defense have a motion?
We do, Your Honor. Mr. Ramos is going to take care of that.
Okay. So they argue the motions. We saw the motion argument. We're not going to go through that again. The court says I need like 5. I accidentally zoomed right past it. I don't even know how. The court comes out and gives his ruling. And that's what I wanted to see is what the defense
Court's
says
in recess.
After, because he asked them about scheduling. That's what I'm curious about.
Moreover, the evidence must be viewed in the light most favorable to the state. Applying these legal principles as announced by the Utah Supreme Court in State versus Montoya, 2004 UT 5. The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied.
Okay, now.
Ms. Nestor, you asked for time to speak with your client to make some strategic decisions. Is between now and 1 p.m. sufficient time?
Yes, Your Honor.
Okay. Mr. Bloodworth, anything further before we recess until 1 o'clock?
Nothing further, Your Honor.
Ms. Nestor?
No, sir.
All right. We'll be in recess until 1 p.m., just confirming that to the extent the defendant will be putting on evidence or calling witnesses, you have a couple in the wings. Is that correct?
Yes, sir.
Okay. 1 p.m. Thank you for your time.
Yes, sir.
Court's in recess.
But then again, the court said to the extent you are putting on witnesses, you have a few in the wings. Yes, sir. Yes, sir. Because again, the defense does not have to put on a case. I think that decision was made long before they came back to court. Maybe I'm wrong. But I think that decision was made long before they came back to court, which is why it's so confusing to me. Because yesterday they said, yeah, we have a few witnesses lined up and ready to go for tomorrow. When I do not think this is a game time decision. I think this is a beginning of the case decision. So then the prosecution is like, okay, well, what are we doing? And the defense is like, we need to have a kiki.
Wait just a minute.
Yeah.
We have a couple of options.
Understood.
I think the defense set up their case planning to not put on a case. And then the couple of options were worst case scenario. But I don't understand what's going on at counsel table, because this is not a game time decision. Maybe it is. Maybe I'm giving credit to strategy. They had 90 minutes for lunch, and then they're just sitting there. I don't think they're making this decision now because they have to consult with their client. Their client has to know what they're doing. So are we making sure we admitted all the evidence we want, or no?
Your Honor, actually, at this time, the defense intends to rest.
We should probably do that in front of the jury, yes.
Right?
Okay.
I agree.
Okay. The reporter from, I don't know if this is KUTV, whatever Utah affiliate 2 is. Do you see how quickly the hands hit the keyboard? Watch how fast the hands hit the keyboard.
We should probably do that in front of the jury, yes.
Right?
The defense rests. It's like, boom. Ready to go.
Your Honor, actually, at this time, the defense intends to rest.
We should probably
Blink,
do that in front of the
blink,
jury, yes.
blink,
Right.
hands to keyboard. Enough time to process and then hands to keyboard immediately. It was like
You've
3 seconds of what did they just say? And then immediately.
consulted with your client about this.
Absolutely.
Blink,
Is now
blink,
an appropriate
blink.
time to get a waiver.
Okay. So now I love how calm the court is. The court didn't look at them and go, the fuck? All right. So where are we at the end of the day? Well, we're not at the end of the day, 13. We're at the end of evidence. Or it's the end of the world as we... No, Emily, it's 2 on the nose. Nope. Cut it from the case brief. 2 on the nose. It's too stressful. I'm going to give everybody anxiety. People are already anxious. No time for REM at the moment. All right. We're at the end of the case. We're at the close of evidence. The prosecution rested, and then the defense rested, and then the court went blink, blink, blinkety, blink, blink. Can I take a waiver from your client? And then they took a waiver from the client. Kouri waived her right to testify. And they're doing jury instructions tomorrow on day 14, and they're closing on Monday. So, after a bumpy few days, which in hindsight make a lot more sense, after a bumpy few days, the prosecution of Kouri Richins is headed to closing arguments on Monday, March 16th. The jury was told that this case would run through March 27th. So for all the time wasted in court, for all the turbulence that was there, the jury is going to be done early. And that's a good thing. So when I said this morning, well, where we are or where we aren't, we'll just wait and see at the end of evidence. I didn't expect that would be today. But then again, this case has been anything but expected. I think we can see some of the defense strategy in trying to double down on what they were going to get in through O'Driscoll. And you kept hearing Nestor earlier today. And again, in hindsight, everything looks a little different, doesn't it? The defense was working really hard to get in through O'Driscoll that these photos were all accessed at the same time. So these could have been sent earlier, and trying to bring those photos in around the time of the gifts to try to undercut what those gifts stand for. And I think they have argument with some of the jurors that those gifts go to the closing of the Midway Mansion. And I think they can argue that with a straight face. I don't know if the jurors are going to find that that's a reasonable interpretation in the context of everything else. I think the defense has done, well, it's been clunky at times, but I think with O'Driscoll, you could see Nestor wading through the nuggets that they want to pull out for closing argument. And you saw that at the end of the cross. Clunky though it was, they need those things said so they can argue them in closing and try to bring them back around in closing. So does it matter how much of the jury appreciated it during the cross? Maybe, maybe not. But they are trying to pull out those moments to raise doubt as to each of those little pieces. Now, in the context, we'll see how that flies with the jury, because if the defense has already burned their trust with the jury, the prosecution holding up a puzzle and the defense trying to go and poke out pieces of the puzzle, they might be like, you didn't poke out the puzzle. You didn't poke out the pieces of the puzzle. Didn't see it. Didn't know. Don't agree. And I think we saw some of that with the Eric and Bryce texts and with the insinuation of Eric's affair that was asked about the coworkers were asked about it, not his closest coworker. The wife of his business partner was asked about it and a few others. It was kind of woven in, but it wasn't asked of the tech expert. It wasn't asked of the PI, and it wasn't asked of the witnesses who had the answers to say, no, that wasn't there. But they wove those things in so that they can pull them out in closing to argue doubt. Now, they might be able to, I think it's a good argument with, oh, those gifts go to the closing of the house. Gets a little harder with the idiots everywhere, doesn't it? Not to mention when you see the forensic accounting and then you see the I'm so rich, the forensic accounting and the I'm so rich don't really square if it's closing on the house, especially when we saw some of the text messages that the closing on the house put Kouri another like almost $3 million into debt. And then there was going to be another, $4 or $5 million or more to renovate it. I think the thing that undercut the renovating of Midway being the path to getting rich is that they were completely forestalled from getting permits on it. I think having the forensic accountant go through all of the notices and restrictions on the property was a really smart play by the prosecution, because Kouri's not just flipping this house and getting rich. The Army Corps of Engineers has put a full stop to anything happening on that property. But the defense is going to say, no, Eric Richins was on board. He was laying gravel. Obviously, the memes are about closing on the house. Some jurors are going to be like, why are you worried about closing on a house when your husband's literal body is downstairs covered in a sheet? So the prosecution from here is going to need to focus on that timeline. And I think that's what they'll do in closing. Eric Richins is texting, I don't feel well. I think I need to go to the hospital. Kouri's like, oh no, do you need to lay down? But her phone shows that she's with her lover. She's not heading back to the house. And then later on February 14th, Eric Richins is like, where are you? And Kouri's like, no, I'm on the way. Still down with the boyfriend. And so while there was a ton of argument, while the jury was not yet called into the courtroom this morning, you could see where the defense kept saying, I just need to get this. I just need to get this, because the defense is also working towards their closing argument. And the prosecution is going to have to remind the jury of everything that they saw from the beginning of the case and tie that timeline together. And the defense in closing needs to bring up two reasonable explanations. Is it reasonable that the walk the dog letter is the truth? And if the walk the dog letter is the truth, the walk the dog letter says that Carmen was buying pills for her and that she asked Carmen to buy pills. That's in the walk the dog letter too. Okay, so if that's true, then isn't Carmen's testimony true? And then if Carmen's testimony is true, then is Crozier's testimony true? When Crozier said, yeah, if I told her that I was getting fentanyl, then she knew what she was getting. That's what I got. So the defense is in an area where they, I think, need to focus on the points that they are going to make during their closing. And if their closing is going to be, this is the sound of a wife turning into a widow, I don't think that will carry the day. I think they need to focus on the reasonable interpretations, because the strategy of the prosecution playing the jail calls with Kouri laughing about all of this and then showing the walk the dog letter is those things are not going to sit well with a jury. And the defense knows that and was trying to distance themselves from that. But I don't think that O'Driscoll was the best last witness. I think he was the necessary last witness. But it kind of ends on a fizzle for me with O'Driscoll as the last witness. Because, you know, when we're talking like more passion, more energy, that's what we got from the PI, not from O'Driscoll. From O'Driscoll, we got a bit of a beard and headlights going, yeah, no, that wasn't my part of the investigation. Yeah, no, I didn't do that. Yeah, not this. Though I think Bloodworth is a confident enough prosecutor that it will tie back round in closing, because the prosecution has been strategic. I am surprised by a few things, and I think I'll have more. I am surprised by a few things. One, that they didn't get into any of Kouri Richins' interviews with law enforcement. I think that was a strategic choice, and we haven't heard all of them. I have seen references to them in pretrial motions. But I think when we're looking at the rule of completeness, the prosecution strategy might have well been, we're not even opening into anything that was in Kouri Richins' interviews, because we do not want to expand the self-serving hearsay that the defense might be able to put in. So no, we're not getting into what Kouri told law enforcement. You want to get into what you told law enforcement? You can take the stand and say it. So I think there was a lot of strategy there on what they were forestalling with the rule of completeness, and then using the things Kouri had handwritten instead. But again, when the prosecution gets to closing talking about you stole Kim's fucking house, not Kim, Miss Barney, it was OG Real Housewives of Beverly Hills fans know what I'm talking about. But when you're getting to you stole Kim's fucking house and start going back through that timeline, even though it has been whiplash of the last 2 days, I think the timeline is going to be very interesting. And I don't know how the defense will navigate that timeline, because the defense argument seems to be there are reasonable interpretations, and you don't know if Eric Richins took that fentanyl himself. That's where they're going to have to focus. You don't know how it got into his system. Well, I think everybody, well, maybe not everybody. I think I am pretty confident on how that fentanyl got into his system, because it's pretty clear that it was orally ingested. I think when we look at the statements of Carmen Lauber and Robert Crozier, especially in their interviews, we see them talking about the fact that fentanyl at that time was being made to look like Oxy, and Crozier was selling it for the same price. Okay. But I think there's an argument there for the defense to say, but then how would Kouri know she's getting fentanyl? Is she asking for it, or is she being told that's what she's given? Or did Kouri think that enough oxy could kill somebody? And that's, I imagine, what the narco undercover testified about with the witness that we did not see testify about what the street drugs were, what they can do. And we did see experts talk about the fact that the hives and the allergic type reaction can happen when you have two, it can happen as a reaction to opiates or opioids. I don't remember. I think they said opiates. And then, when's the last day of trial? We heard the word gummy. Right. Week 1, all of a sudden the gummies have kind of disappeared. And now we're back to, oh, he went to Mexico to go hunting, which it seems that he did. And the defense is going to lean in. He could have gotten this in Mexico. Okay, well then why is Kouri Googling if someone's poisoned, what does it go down on a death certificate as? And I think some of Kouri's Google searches about life insurance are going to come in at closing too. So when we're looking at the strategy, whether you are on the Emily side of the fence with, I do not like the way that this all played out. I do not like the manner of presentation of evidence from the defense. I don't think I have ever said that they don't have a strategy. I think at times I've said it is real hard to see what their strategy is. But the defense went into the case with a plan. I do not like the way that is presented. The circling back to the court's rulings again and again and again and again is hard for me. At some point, the rulings are the rulings. But the judge entertained it. And I think the judge was incredibly cautious. At times, maybe too much so. However, you're not going to get overturned on appeal by being too cautious in hearing out the defense. That is not going to cause a case to get overturned. And the state can't appeal it. So too cautious on the side, erring on the side of the defense is not going to get a case overturned on appeal. So there are times where I think the court was overly cautious and hearing the defense out and was also trying to make a record because I don't think that the court was confident that the defense was bringing the legal arguments that gave him all of the information he needed. And we saw the court more than once say, no, that's not what was said, because the intentional shifting of words was so deeply ingrained that it was at times incredibly frustrating for me to watch. Because if I just heard you say this, don't tell me it's this. I heard it. You're not going to convince me that this is a picture of a wife turning into a widow. And I think knowing the defense strategy, because they did, opening with the prosecution's going to try to show you the picture of a witch. We're going to show you the picture of a widow, is a bold choice when question after question after question, it was the defense who was shifting the way things were stated. And I think with some other prosecutors, could you imagine this defense team like versus Hank Brennan as a prosecutor or Carrie Morrissey? We'd all sit there and go, we're not watching this case anymore. Nope. Turn it off. Turn it off. Tell me when it's done. I think the way that the defense presented their case becomes more apparent because the prosecution team kept it so incredibly narrow. There was minimal amounts of pushing from the state, where with Brennan, there was a lot of pushing. With the state in this case, there was a lot of, they were kind of the straight man to the comedy trio that was happening. And they just kept it right down the middle. And so there were times where you saw the court saying to the prosecution, I think your argument is this, is that correct? And the prosecution's like, yes. And then going back to the defense and being like, okay, but that's not what was just said. And so because you had the precision of the state, it made, I think, for me, more apparent that that's not what was said in other areas. So we're going to see. I don't know if people will be split on whether or not this was a good strategic call. I think there's two parts to how I feel about the defense's strategy. One, I think it is the best legal strategy, and I think it's a solid play. Two, I was really wanting to see them call like Ronnie and Mom and Kouri and everybody else to the stand and just get messy. I was ready for the mess. I'm not afraid to admit it. Were you ready for the mess? Good legal strategy. I was also ready for the mess. We were promised mess. I was ready for the mess. But also, now we see why the defense was pushing so hard to be able to do their direct examination of witnesses that were on their witness list. Right? We saw it with one witness. They were able to do a direct examination of Allie staking. Was it Allie? Mistaking. Witness staking. But we saw the defense push for that with a couple witnesses and get shut down elsewhere. Maybe this is why they were pushing so hard to have their direct and run no defense too, because then they don't have to call their own witnesses. But they pushed for direct of Kouri Richins. They pushed for the direct of Allie, and they got it. And they pushed to kind of expand the bounds of some of the other witnesses that got shut down. But they were pushing with a lot of the witnesses, and the prosecution argued outside the scope more than we've seen, I think, in any other trial. So because the defense did not put on a case, they were allowed to kind of direct one witness that was also on their witness list. But because they didn't put on their case, there is no rebuttal case. It's done. The evidence is done in this case. So again, a good strategic play, but I think we can look back at the breadcrumbs that were left and know fairly confidently that the defense was playing for, one, not calling a case in chief, two, calling witnesses if they absolutely have to. So all that's really left is jury instructions and closing and deliberation. So when the prosecution prepared their case, I am sure that they planned for no defense case at all. And then what if the defendant testifies? And then what if these other witnesses come in? Because you really have to build your case from the defense puts on no case, because that's what happens the majority of the time. We have seen a lot of cases where the defense puts on a case, but we've seen some really kind of high stakes and high profile cases. But a lot of the time, the defense puts on no case whatsoever. It is more common that they don't. And so the prosecution has to prepare for, what is our case? What is our case if the defense puts on no case? You do not save things you absolutely need for rebuttal. And that is a pretrial strategic call, especially knowing what the motions in limine look like. That's why they do the motions in limine in advance, so the attorneys can plan for their case. But I wonder how much in closing we will see the defense try to insinuate that, oh, well, Ronnie knew that Eric was doing drugs. Okay, then where the fuck is Ronnie? Okay, if you're telling me Ronnie knew that, and the IO or the lead investigator is telling me we tried to talk to Ronnie didn't want to talk to us, where the fuck's Ronnie then? Ronnie, where are you at? Come and explain it to me. So I think some of those insinuations can backfire. The defense does not have to prove anything to the jury. It is not their burden. It is the state's burden. But when the defense starts to make promises, either through their questions, their actions, or their opening statements, the jury starts to clock those things. It happens with the prosecution too. If you start making promises of what you're going to show and then don't, the jury will absolutely clock it. Now, the prosecution's in a little different spot. The defense can clock it in closing. The prosecution has to be more careful clocking it in closing because the prosecution cannot shift the burden. And so the prosecution has to kind of thread that needle of clocking it, but not shifting the burden that the defense has to bring in Ronnie to prove that Ronnie was saying this. Because, well, we didn't see Ronnie. We just saw insinuations about it. And that's really where the defense is leaning into in their closing. I imagine Nestor will be doing the closing because she did the opening. But I will be interested to see how the prosecution builds their timeline. We're never going to find out why Bryce was partying with no pants on, I suppose. We're going to have to just let it be. I think if the jury is still completely appalled by some of the insinuations about Eric and Bryce's texts, the jury, there's a very real possibility in this case that the defense kind of turned off the jury enough in the way that they were going about things with Carmen that they never recovered from that. If the jury does not feel that you're trustworthy, they stop listening. They're just like, wah, 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 whatever. And so if jurors were turned off by that, it's real hard to keep listening to the points. I feel like even though there are times, maybe more often than not, that the defense's delivery was off-putting to me, we can still pull out the good points. Then again, I've been a lawyer for that long, and that's my job. I have to see the defense good points even when they're pissing me off and I'm sitting in the same room. Because you cannot, it's like sports ball. You can't get so in your head about whatever's going on that you don't see the plays that are being made on the field. That's not how jurors operate. Jurors don't have to operate that way. And so I think we saw some good points made by the defense. I just don't know how much was lost in the way that they did it. So we'll see. I'm very interested to see closing arguments. I'm going to answer a ton of questions. I'm going to put up a poll real quick. Let's see. There are 35,000 of you here, and maybe we do one thing before we do questions. How long have we been streaming? 5 hours? We got time. Let's see. Now that evidence is closed. All right, I'm putting up a poll. Chat. Would you like to form an alliance? Would you like to go over the entirety of the Walk the Dog letter? Would you like to look at the unredacted version of the Walk the Dog letter? Evidence is closed. We are done with the case. Ariana, you're the first one who I saw say, absolutely, I would. So would you like to form an alliance? Would you like to look at the entirety of the Walk the Dog letter, chat? And then we will do questions? Yeah? Maybe? Nolan Void, yes, a lot happened today. The defense put on no case. They're closing on Monday. They're coming back tomorrow to do jury instructions. All right. Most of you have said yes to the unredacted Walk the Dog letter. I'm curious if there's more context now that we have seen the state's case. I think tomorrow I'll have more thoughts about stuff I wanted to see. I am surprised and very curious why we didn't see the lab testing of the gummies at the house. We know they were. We heard about it in pretrial. And this is the hard thing with following pretrial. We know that the weed gummies in the house were tested. We didn't see those lab results. We know that there's something else going on with lab results from O'Driscoll that didn't come into evidence. It got completely shut. It was like, whoop, nope, back up. We don't know what was going on with the tweezers. So there are still some of these questions that I'm like, I really did want to see the lab testing on the gummies. There was no fentanyl in the gummies, but the jury doesn't know that. However, there was no THC in Eric Richins' system, so maybe it just muddies the issue. Maybe it doesn't matter because there's no THC in his system, so why would we even think the gummies came from there? And to that point, I don't think there were any opioids in Eric's system at all. So when you look at what we saw at the beginning of trial about the victim, there's not very much alcohol. There's no alcohol in his blood. There's no THC. There's all these texts where Kouri's like, gummies? And Eric's like, you're gonna need food first. It's a couple texts. So no THC in his system, no opiates in his system. Her prescription of Seroquel's in his system. There's a little bit of alcohol in his system. And a truckload of fentanyl. And all of the metabolites of the fentanyl. So, you know, when we walk that road, we'll see. Because I think maybe it's just a distraction, or the prosecution sees it as a distraction, going down the avenue of testing the THC gummies. All right, let's continue on. Let's get to the walk the dog letter, shall we? Because at the end of the day, it is one of the things about this case that became abundantly clear, but I think the defense left a lot of room for, no, I think the prosecution left room for the defense to argue that the walk the dog letter is true because of Allie's testimony that they didn't really rebut, because they didn't bring in a witness to talk about the fact that the walk the dog letter had become public. The defense was able to ask about, did the walk the dog letter get sent to anyone? But the prosecution didn't clarify that the walk the dog letter became very public. So there's room for the defense to argue, look, a reasonable interpretation of this is the reason Allie knew about this is because it was true. Then again, if the defense is arguing, well, Allie knew that Eric was putting drugs in Kouri's bag and haha, so funny is because it was true, well, then Allie was also talking about the fact that haha, funny, Eric tried to poison, or Kouri tried to poison Eric and said, don't eat anything Kouri gives you. So is that true too? Which one's true? Because it's not going to be, oh, the stuff in the walk the dog letter is true, but the haha, funny, Kouri tried to poison Eric, don't eat anything that Kouri gave you. That's, which one is it? Or is it a combination of the two based on the other evidence? So I think the defense has to thread that needle a bit carefully as well, lest it backfire on them. Okay, let me pull up. Well, what are we pulling up, Emily?
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
I expected that we would be in trial till 8 o'clock tonight. I didn't think that we would be pulling up docket items. So I was ill prepared to pull up the entirety of the walk the dog letter. And since we have been streaming for, is this 3 weeks of trial? Are we on week 3? My voice is a little tired. But yeah, I'm also surprised that we didn't see more about Eric's affair. Right? Loretta asks, only 8 deliberating jurors. Correct. There are only 8 deliberating jurors. Yep. Maria said, like you said, Emily, then where were all the pills? Right. If Eric is buying this, where are all the pills? If he took this by himself and died because of an accidental overdose, where are the rest of the fentanyl pills? Because there's no indication that he took all of the pills in existence as a choice. So Crystal says, Emily, she could have flushed them. Yeah, yes, she could have. But that is to the side of my point. If Eric accidentally ingested fentanyl, where's the fentanyl? Where are the other pills? If Eric was like, hey, go get me some pain pills, even though Kouri still had pain pills in the house from her pregnancy that they recovered. Hey, why is there no fentanyl in the house? Well, I guess they're going to argue it was in the work truck. Oh, it was in an allergy bottle in the work truck. Well, why is he taking street pills if there's still pain pills from Kouri's pregnancy? Why aren't you just using, if your back hurts or whatever from work, why aren't you just taking the leftover prescriptions you have? Why would you be even fucking with anything bought off the street, hoping that it's safe? So why would you be doing that? And if he accidentally took a pill that killed him that quickly, you would think you would see more. But I guess the work truck is what they're going to argue, right? But if you have a bunch of pain pills that you're taking on the job site, you're keeping them in your truck? However, the truck not being searched because they didn't search the truck leaves room for some jurors who might just be like, well, what about the work truck? Does the work truck thing make sense? No, it doesn't. But Kouri knew that the work truck was taken. So it makes an easier avenue to argue. And honestly, after seeing the PI testify, if anyone's going to find anything, I think it was going to be the PI. Because when he said, I sat down with the family and was like, look, if you can't handle the truth, I am not your guy. I'm going to find out what the fuck happened. You might not like what I find. You cool with that? Because if you're cool with that, we're cool. I think he would have found it. And I think he would have come in and said, you know what? I do see evidence that Eric Richins had an issue with pills. But Eric Richins' medical records didn't say that. His liver didn't say that. His toxicology didn't say that. So I don't think you can say that it was there. I think the PI was one of the strongest witnesses for the state, and I did not expect that at all. He was great. Okay, excuse me. Some of you are saying that the business partner also showed that he wasn't going to lie. Cody proved he wouldn't lie for Eric with the hunting stuff. I agree with you. I absolutely agree with you. Yeah, I thought the PI was great. All right, let's look at the walk the dog letter since court's done for the day. For those of you just coming in, Emily, what happened to court? The prosecution rested, the defense rested. They're doing opening state or closing arguments on Monday. And they're doing a half day tomorrow, which is great. Spring break. And I'll get to see the kiddos a little bit. So it's perfect. All right. Let's take vague notes. And then we will get to, hold on, that. Let's take vague notes. I'm going to pull this up in our document view. And then we'll get to questions. I will do my best to pull them up. I'm just having some glitches on my end. I'm going to take down my court bug here so it doesn't get in your way. And then for all the members that watch me record the podcast in the background, you know what time it is. Emily fights with technology. It's going to need its own stinger at some point. EDB fights with her tech to make it look the way she wants it to look on any given moment with any given document. EDB versus technology. We're almost there. That actually doesn't look terrible. All right. Trying to make this so it's readable with the margins. Almost there. I moved this for news articles and not docket items, and then it got all squirrely with me. So apologies for that. But I didn't plan on pulling up documents because we were in trial. We were in trial. I didn't plan on pulling up documents because we were in trial. And now we're not in trial. And I'm confused. I mean, I guess we are. Closing arguments haven't happened yet. We're still engaged in trial, technically. All right. Walk the dog, but take vague notes so you remember. The beginning of this letter was redacted. Redacted. Sky is saying even if the gummies have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies so Eric would have them. Stupid, I know, but that's what she's thinking. We will still test them though. Oh, my voice is just like done. We will still test them though. However, she wants to link Eric getting drugs and pills from Mexico. So we need some kind of connection. Her private investigator is doing some research on the ranch/cartel place Eric would stay at. Here is what I'm thinking, but you have to talk to Ronnie. He would probably have to testify to this, but it's super short, not a lot to it. Again, if it's the truth, why do we need... He'll have to testify to this, super short, not a lot to it. He will need to tell Sky at the meeting next week, upon information and belief, just like they say, which was hilarious after hearing Kouri yelling about that on her jail call, right? A year prior to Eric's death, Ronnie was over watching football one Sunday, and Eric and Ronnie were talking. I think that's talking, discussing, talking, chatting about Eric's Mexico trips. Eric told Ronnie he gets pain pills and fentanyl from Mexico. Then why are you hollering at the ME on the phone? Why are you hollering at the ME on the phone that you have no idea where the fentanyl came from? If everyone knows that Eric is getting pain pills and fentanyl from Mexico, why are you shocked that there's fentanyl in his system? And why aren't you telling the ME that? Eric told Ronnie he gets pain pills and fentanyl from Mexico from the workers at the ranch, not to tell me because I would get mad, because I always said he just gets high every night and won't help take care of the kids. There are pictures in my phone of Eric passed out on the floor or in the chair. Look, my takeaway from the cases that we have watched together is God forbid a dude fall asleep. I have never seen anyone with a picture of any of the women in the cases being like, she's asleep. But God forbid the dudes fall asleep. You fall asleep on the fucking couch, it's over. I have pictures of him passed out on the floor or in the chair. You're not going to ever convince me that she did not watch the Depp Heard case, ever. That may not be true at all. But in my brain, it's just, maybe it's just such a coincidence, but I doubt it. Ronnie should have texts from Eric talking about getting high as well. Okay. So where are the texts then? Show me the text, Ronnie. Show me the text in Eric's phone then. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck, so I wouldn't find them. Ronnie never told me about the conversation. Eric finally told me and asked if Carmen could get him some. So you were buying pills from Carmen then, or no? Eric never wanted anyone to know he had an issue. Okay, then why are there still pills in the house, though? Eric never wanted anyone to know he had an issue, especially get caught. He always wanted Kouri to go down for him. When they traveled, Eric would put his drugs in Kouri's bag at the airlines right before they boarded. That way, if they were caught, Kouri got in trouble, not him. Once they got to wherever they were going, Eric would pull the drugs out of her bag and it would cause a huge fight. She was pissed he would risk her going to jail for his drug use. Does this track with the things that we've seen in any of this? J-Rod said, oh, so we are in the third person now. Yes, because Kouri's writing this to her mom to tell Ronnie what Ronnie needs to say. So this is what Ronnie needs to say. Per the letter. That's why it's in the third person. Tell Ronnie to say. So this is Kouri writing Ronnie's story. Does that make sense? Let's see. He would risk her going to jail for his drug use. He just would laugh about it. Eric couldn't ruin his image that he had drug issues, so he would do whatever he had to. Kouri has never done any type of pills, didn't like them. Well, if you've never done them, where's the didn't like the... Emily, you can't argue with this whole letter. We'll be here for another 3 hours. I know, but it just doesn't make sense to my brain. Rarely would she consume THC, only if Eric begged her because it was a special occasion. Wait. Remember when was it Allie Staking they were asking about the party? And they asked Allie if people were taking gummies at the party. And Kouri was just like it was one of the moments in trial where Kouri's head whipped up so fast. Interesting to me. I'm wondering if they were taking gummies at the party. And she was wondering what Allie would say because her walk the dog letter says she wouldn't consume THC. Also, no shade to THC. I don't give a fuck. But the defense made such a big deal out of it at the beginning that they kind of have one way. They've kind of boxed themselves in on that, given Kouri's text where she's talking about that more than he is. And on the call with Bryce saying, I mean, we like to party. So it is what it is. Also, if it's the truth, which I think the defense is going to, if the defense touches on this at all, I think the defense is going to argue that it is. Why then does it say reword this however he needs to make the point just include it all? Isn't it much easier to say, hey, it's okay to tell Ronnie to tell Skye everything he knows. Just tell him to tell Skye everything he knows. The connection has to be made with Mexico and drugs. Ronnie will have the messages to prove Eric confided in him about getting high. I still have questions about that. I have questions. I want to know if there was activity in Eric's phone afterwards. I have so many questions that we're not going to know. I have so many questions. But Ronnie will have the messages to prove Eric confided in him about getting high. Okay. Where are the messages? It can be short and to the point, but has to be done. Upon information and belief, lol. They never found pain pills or fentanyl in my house because he hid it in an allergy bottle in the work truck. And I think that's what the defense is going to say. The defense is going with the walk the dog letter, and they're going to say it's because it was true. And Cody emptied out the work truck within a week, so they were never found. Easy peasy. When you talk to Ronnie about this, meet up with him in person. I worry sometimes your house and phone are bugged. Maybe drive down to SL and meet after work without Bree. Sky has to make the connection between Eric and Mexico because that makes the most sense in her mind. If it's Ronnie's information and belief about the conversation over football, she can use that as a connection. Tell Ronnie, don't overanalyze it. It was a quick 2-minute conversation, lol. Tell him I need him to do this. Bring me home, and then we will get those damn bitches, which has a lot more sense, which makes a lot more sense, given more of the context we know about her sister-in-laws. Also, please text Lotto, still no idea who Lotto is, or call. Tell him, do not text me anything about us doing things together ever, like church, skiing trips, nothing that puts us together. It doesn't look good. I don't know who Lotto is. Maybe we'll know later. I don't know. We are so close to the end. Let's push through. Have the conversation with Ronnie before he meets with Sky. Go tell Ronnie what to say before he meets with Sky. Right. Have the conversation with Ronnie before he meets with Sky. Then tell him to tell Sky at the meeting about the conversation. Hang in there. We're almost there. Love you to the moon. Take vague notes of all this so you remember before you walk the dog. Page 4. Lucid Stream and a lot of you in the chat said, why was this redacted? Parts of it were redacted after pretrial motions for attorney-client privilege. Parts of it were redacted for relevance. The rest of this was all kept out for relevance because it's just not relevant to the murder case. So that's why. But true, chat, it does not say burn after reading. It says take vague notes. Page 4. I saw a commercial yesterday, Utah Mortgage Relief. Google them, please. It's for people behind on their mortgage. Like, this isn't relevant to this case. Some of this goes more to the financial case. It's for people for help on their mortgage. Can you see if they can help at all on Marissa's house, please? We have to get hers, yours, and Chelsea's taken care of ASAP. Remember, Chelsea, though she testified in this case, is a victim in the other case it's trailing. So talking about the house here is a little bit too much, and is not more probative than prejudicial. Try to go to that place in Camas. What about asking Lotto to do a loan solely? I wonder if Lotto is one of the lenders then. What about asking Lotto to do a loan solely in his name and not have any of you on there? I know he can do a home equity line of credit. I wonder if Lotto is the one that she was emailing. The forensic accountant said that there was an email in there where Kouri was talking about how like inconvenient it was to be married. I wonder if it was that one. The one that was like, oh, being married is so inconvenient. Because why are you texting a lender you work with about that? Might be. I mean, it's a reasonable inference. Don't talk about us doing stuff. It looks bad. Also, if he's the money lender, it makes sense that he would be called Lotto. I just wonder if Kouri only had one boyfriend. But that's purely speculative, Emily. That's speculation. Purely speculation. All right. Let's see. Maybe Lotto can do a loan solely in his name and not have you on there. I know he can do a home equity line of credit. Oh, we're well aware. We're well aware of who can do a home equity line of credit. You're well familiar with those, aren't you? I think the HELOC's going to come up a little bit in closing. Not sure if he would, but I know he has like $1 million in equity. Maybe he just doesn't know about a HELOC. Who doesn't, if he's a lender, he would know about a HELOC. And then she put in parentheses home equity just in case mom doesn't know. If he wants to help me, taking care of these loans is most important. I don't give a shit about the yotels. Why is he trying to take care of you? I don't think Lotto's Josh Grossman. If he wants to take care of me, why does anybody care about taking care of you? I got questions. She goes on to say, remember I told you one way to get at Katie. Oh, this was prejudicial and not probative. That's why this was redacted. Remember I told you one way to get at Katie is going through my phone and finding a picture of her girls, even with the boys, the girls being Katie's kids, the boys being Eric's kids. Print 15 copies and send them out anonymously to different media companies. Obviously, don't email the pictures so it's not traceable. She would be livid if it got out to the public. You would just have to do it sneakily and be careful. She would try and trace it back to you. If not, no worries. Still mad at the sisters-in-law, right? Still mad at the sister-in-law. Now, you can see why that doesn't come in, right? When we talk about if something's more prejudicial than probative, I think this makes the point. First question, does this shit piss you the fuck off? Pisses me off. Does this piss you off? The fuck, Kouri, what are you doing? Why don't you fuck with my mom? I need to fuck with the sister-in-law. Send pictures of her kids to the media. That'll piss her off. Pisses you off. But does it help you decide if Kouri killed anybody? No. Does it help you decide if Kouri forged a document? No. Does it help you decide if Kouri was engaged in insurance fraud? No. More prejudicial than probative. It makes Kouri seem like a horrible person, but it does not help you decide if she did the things she's charged with. That's a very good example of more prejudicial than probative. We don't always have good examples. This is a really good example. That part of the letter might make people so mad that they're just like, if somebody's willing to do all of this, yeah, they probably did, right? If you can do all of this, right? That's why it doesn't come in. That's why it doesn't come in. A number of you are asking, will the walk the dog letter come in the civil case? Parts of it will, and it might be redacted differently. That part's still not coming in. Well, no, this part will come in possibly in the civil case, but in the other criminal case, some of the stuff about the mortgages may come in as well. So it'll be different. But it really depends on what happens in this case, because what happens in this case will impact all of the civil litigation quite substantially. Anyway, do it sneakily. More sneakily than the book was sent to law enforcement. I'm still buffering that happened. Remember, there's two sides of every story. The fuck? This is a grieving widow writing the first ever child's book about losing a parent. Ma'am. Continuing on, this was all redacted. So we are going over the entirety of the walk the dog letter because we had a minute. Sky is having my girls do the first interview with Good Morning America. Please tell Chelsea to bring up that he hasn't been to church in the 13 years she has known him. We can see where the attacks on Eric began, can't we? The attacks on Eric began well and above this case going to trial. Tell Chelsea to say this. Tell Chelsea to say that. Tell Chelsea to bring up that Eric hasn't been to church in 13 years and that Eric would brag to her about how much he drank and did pills in high school. Tell Kelsey to say, quote, Eric always wanted Kouri to go down for him. I almost read that wrong. But all of this is not probative. All of this is just prejudicial. For example, he would put drugs in her suitcase when we would travel together. Tell Chelsea this. Tell Kelsey this. I think the Kelsey stuff probably could have come in. Tell Kelsey to say Eric always wanted Kouri to go down for him. For example, he would put drugs in her suitcase when we would travel together. So if anyone got caught, it was Kouri. He would put it in her bag right before they left the house. Earlier in the letter, it says at the airport. By the way, there is an internal inconsistency. He would put it in. Damn it, Emily. No, he would. Shit. He would put it in her bag right before they left the house. So Kouri didn't know. Scotty didn't know. Scotty didn't know. Scotty didn't know. Don't tell Scotty. But the story's shifting. Then they would land wherever. Eric would take them out of her bag and Kouri would be pissed about it and they would argue about it. And tell Kelsey to say how Eric didn't care and would just laugh and say, well, I can't get in trouble, as if it was okay that I got in trouble. Have Selma talk about Eric in Spain not being able to drink, so he was looking for drugs the entire time, and explain the drink the waitress gave him and how I called his doctor and went to the pharmacy immediately. Have Allie talk about how the sisters have always been jealous of me. Because anything they could do, Kouri could do better. Have Allie. This was supposed to be on Good Morning America. It was never on Good Morning America. Have Allie talk about how the sisters have always been jealous of me because anything they could do, Kouri could do better. Being a mom, college, stay-at-home wife until she built a Milio. There's probably Millio. Yeah, $1 million company. A nice house, car, everything she had they wanted. This comes down to jealousy, money, and Eric's partying. I don't think that's true. Jealousy, money, and Eric's partying that they don't want to acknowledge, and sadly, an accidental overdose. Lastly, don't forget to work on the gun receipts. We want to file charges and let the prosecutor not do anything about it to use in our defense. They are already, which is what we heard argument about today, ceding the defense. We saw the prosecution today buffering. Like, this dude came in with a story, talked to defense, came in with a different story, talked to defense, came in with a different story. Yeah, no, we're not doing this. But we want to use this in our defense. And then, will you buy a box of Crest White Strips? Open them up, put them in an envelope, and have Sky give them to me? It's contraband. Emily, it's Crest White Strips. Doesn't matter. You can't have them in custody. Will you buy a box of Crest White Strips, open them up, put them in an envelope, and have Sky give them to me? You can't tell her what's in the envelope. Or you can tell her what's in the envelope. I'm sure Sky won't care. Your lawyer doesn't want to smuggle things into custody for you. Yes, she'll fucking care. There are rules. I'm sure she won't care. I'll make sure they can't be found in my cell. My teeth are yellow from so much coffee and tea all day. Shadfish. I love you, I love you, I love you. Hang in there. We're getting there slowly. You're the best mom in the whole world. I'm so lucky to have you. So when the defense was arguing, well, we don't know this is written to Kouri's mom. Would you like us to bring in the last page then? You want us to bring in the last page then? You're the best mom in the whole world. I'm so lucky to have you. Should we just unredact it then and bring it in? Let's do it. Let's do that. So that is the entirety of the walk the dog letter. A lot of this was redacted in court. So yeah, you can't ask your lawyer to smuggle things in for you, and they're not going to do it. You're not their only client, and their law license matters to them. So no, they're not going to smuggle in Crest White strips. A number of you asked, and I can't pull them all up, but a number of you asked why Sky was no longer on the case. The court made a record about it during pretrial motions ages and ages and ages ago. It had to do with a conflict that arose out of the civil litigation. I do not know what that conflict is. It is not because of the walk the dog letter. It's not because of the jail calls. Well, she was, calling Sky names up one side and down the other. Attorneys are used to that. It was not because it just became too hard of a case. There was a conflict that dealt with the civil litigation. We don't know what it is. The specifics of that conflict are ex parte. So we won't know. We might know later, but we won't know. So that is the entirety of the walk the dog letter. We're going to get to some questions. For those of you just coming in and are like, EDB, is court on a break? No, court's not on a break. Court's done for the day because the evidence in the case is done. Both sides have rested. Closing arguments are on Monday. Tomorrow they're doing jury instructions. So, yeah, evidence is done. That's why. All right. Let's get to some questions. I'm trying to grab them out of the chat as fast as I can. Courtney said, how long till our flight departs? EDB EST is a wild time zone. Yeah, EDB, first of all, I've not switched to daylight time yet because my brain has not. And this morning was just a busy one. But yes, that's why we ping the app so that you guys know exactly when we're going live. Because some days it's just like, always try to be as close as possible. But some days, close is not close enough for me. Deborah said, and this message came in because it's time stamped at 10:30 this morning. It should be an interesting day. The law nerds are prophetic this morning. Puddle piddle. It's POP. This is POP instead of OPP. If the walk the dog letter is true, why wouldn't Ronnie offer up all that information to help Kouri instead of avoiding talking to law enforcement? Yep. The behavior and the arguments do not line up. The defense is leaning all the way in to see what sticks. Just see what sticks. Abby Road in the chat said, and Jen, thank you so much for the gift of memberships. Abby Road said, why wasn't Eric allowed to hunt in the U.S.? He hunted, I think it was a stag without a tag. Might have been an elk without a tag, and was caught. Somebody said he's got an elk without a tag and was on a ban of elk stag. Thank you. Was on a ban for, I think, 4 years where he could not hunt within the U.S. because he had an elk without a tag. Can't do that. He knows he can't do that. Can't do that. But it does start to make that connection to Mexico that they were trying to make of he was going down to Mexico and hunting. So Kouri wanted there to be a connection there. So that's the connection they had. But again, I don't think that's untrue. I don't think it's untrue that Eric was going down to Mexico to hunt. It seems that that was accurate. I guess I'm not well familiar with hunting. You still need tags on your own land, I would imagine, because I know their family had quite a bit of land, but I think you would still need tags on your own land and couldn't hunt. Even if he had tags, couldn't hunt because he was banned. So I don't think he could hunt on the family land either. I think that's why he had to go down to Mexico to hunt, and he had somebody in his phone that he was texting that it seemed that that person was connected to the hunting outfit that he would go down to Mexico. Everybody's saying, yes, you need tags on your own land. That makes the most sense to me. I just don't know. I put out birdseed on my land. I'm just, I'm hunting green onions. That's about it. Hopefully berries next year, though. I've been watching lots of Epic Gardening. I have many ideas. The problem is I'm also very ADHD and I have no follow through. So ADHD and gardening might be a bad thing. So we don't know. Alley Cat said, was watching Last of Court with BF last night. Me trying to explain the whole case to him in 2 minutes so he understood was like a meme of a guy in front of a board with pins in her. It's like, okay, so this is this. This is this. So, yes. Melanie said, I absolutely love my Law Nerds hoodie just arrived. I'm so glad. We might have to re-release the shirt that was worn in court today because those sold out real quick. All of you are saying lots of gardening patience. It's the forgetting to go back out and do things that's hard for me. I forget all the time. See Judge M, if you allow the defense to shenan once, they will shenan again. The defense really epitomized they're nothing if not persistent. Nothing if not persistent. I'm so far away from what did he say? I have no idea. There's just super chats for the mustache because yes. Did you see where Nestor said something along the lines of, I don't give a fuck when they asked for a continuance the other day? No, I didn't. I saw Nestor say, ask for one. That's all I saw. Would it shock me if a lawyer dropped an F-bomb in court? No, it wouldn't. It wouldn't. But when Lewis was asking for 2 days and the court's like, no, she's like, ask for one. That's all I remember. So I know that Lewis got frustrated. I mean, both of them seemed frustrated at points, and we heard them under their breath a couple of times. Including this morning where I think it was Nestor who was just basically like, you're on a Mac? Gross. She didn't say gross, but she was like, it was funny. Kai said, I turned 40 today. Congrats to me. Congrats to you. Paula, I'm so sorry. Paula said, watching to distract myself from drama. My husband got bitten by a rattlesnake yesterday. Paula, I'm so sorry to hear that. I hope your husband is doing well. Thank you for following up with this. He's in the ICU, going to be okay. He was protecting our dogs, so I love him even more. I mean, I'm glad he's okay. I'm so sorry that happened and had to protect the doggos. This sounds like some Arizona stuff happening. I had no idea. A friend of mine was telling me about the rattlesnake training they do for their dogs in Arizona. I was like, whoa, that's a lot. Undercover Angel said, oh, I'm here for all the tea. And yet it was wrest from our hands today. Not nearly enough tea today. I feel denied the tea. I'm still buffering from fucking today. Leslie in the chat said, Mac, ew, David. That's exactly what it was. Ew. That's exactly what it was. Jen the Law Nerd, said, I'm saying this as calmly as I can, but I cannot stand Nestor. I understand. Look, there are ways to make the same arguments, to make the same points, and to do it in a different way. I do not mind an attorney that pushes back at the court. I do not mind an attorney that is going to fight on every point. It is the way it is done that I often find more off-putting. And the comments and the constant commentary, those are the things that start to undermine what would otherwise be solid points and solid arguments. But the misstating is the number one thing for me. And we have seen other defense attorneys that have pushed back on the court quite a bit, who have done so in a way where you're like, I see their point. That's not going to fly, but I see their point. Like, I see where you're getting at. Like, good luck. Good on you for trying. A+. 10 points for defense. But you don't have to manipulate every single sentence to get your point across. And that's where it really starts to lose me, is the misdirection, the misstatements. And it doesn't seem, ho-hum, I just misread that. I'm just exhibit E's, my bad. It was more intentional than that. And that is what bothered me so much. That's what bothered me so much. So, look, the job of the defense is to push back on the judge's rulings and the prosecution's evidence. That's our job. However, you can't do it by deceit. There is a duty of candor to the court. And that doesn't mean that the defense has to disclose if they're calling witnesses or not until the moment of truth. They don't have to. They can make a game time decision. I don't think they did, but they can make a game time decision. The defense's job is to leave every possibility open and then argue to the jury, there's too many possibilities for you to come to a verdict. It's their job. But there's also a duty of candor to the court. And that, well, you saw me scream about it the entire trial. It really frustrates me. Really, really, really. Let's see. The term LAS, used car salesman lawyer. I don't know that term. When does impeachment become perjury? Impeachment is impeaching somebody with a prior statement. The thing is, if somebody says they don't remember, you get into a difficult pickle of, do you really not remember? Are you lying that you don't remember? Is it perjury that you don't remember? Did you create a false memory? Perjury can be really tricky in proving that somebody flat out lied. I did a perjury trial as a district attorney. But when you have shifting of statements, is it that memory has changed? Is it that you genuinely think something different now than you did then? Is it that you've gotten new information? So like if Carmen Lauber said, oh, it was this, and then sees her phone and is like, oh, it must have been in the other order because now I see my phone. That's not perjury. That's that's evolving based on new information. So it really just depends. The perjury case that I tried was just incredibly clear. And that's the reason we tried it. I also enjoyed fraud cases. So I was like, ooh, tag me in. Tag me in. Tag me. Me. Let me do it. And we came back with a conviction in like maybe an hour. Oh, the defendant was so mad. I thought he was going to throw a chair. He was out of custody. He was so pissed when the verdict came in. We had a lot of bailiffs that were just like, whoop. But, don't lie about shit that's on video. I might have had a little too much fun on that case because the defendant testified. And I kept playing the video back. I'm like, is here where it happens? No? Let me back it up again. How about here? No? Okay, let me do it again. Is it there that it happens? No? Let me run that back again. What about there? Is that where it happens? No? We've got the whole video. Let me back this up again. Is it there? Show me where. Let's play it again. Where does it happen? The way you said it happened. No, I didn't see it there either. Let's do that again. Let's start at the beginning again. Show me where it happens on the video. No? Yeah, I didn't see it either. Okay, back it up. Let's do it again. No, I didn't see it that time. Can you show me where let's do it one more time. It was akin to the prosecutor looking at at Brendan Banfield and being like, okay, so that's 2 times Christine was stabbed. Where are the others? Where are the other times that Christine was stabbed? Can you explain to me where the other times were? 1, that's 2. Where are the rest of them? I also think the defense probably didn't want Bloodworth to have the best time ever of cross-examining Kouri Richins. I think part of it was to just to, deprive Bloodworth of all of the fun. Oh no, it was 100%. Somebody was saying, Emily, that's so petty. Yes, it was 100% petty. No, because look, by the time we got to a criminal perjury prosecution, this individual had been confronted about this statement a lot of times and given the opportunity to, would you like to take that back? He was given the benefit of takesy v backsies so many times. And then by the time we get to a criminal prosecution and get past a preliminary hearing and get to a felony perjury trial, takesy v backsy had been on the table for so long. So by the time we get to trial, takesy v backsy is gone. Takesy v backsy is out. So we're going to go through this video a whole bunch and you're going to explain to me why this isn't perjury. Why is this not perjury? You were confronted with it. It's kind of like in the Sherry Papini case. She was confronted multiple times with, if you lie to law enforcement, this is what will happen. She was like, no, I'm not lying. You sure about that? You can be prosecuted. Not lying. You will be prosecuted. We know that you're lying. I'm not lying. Well, then we can't help you. So prosecute away. Melmo said, could them not putting on a defense be an out for ineffective counsel? Oh, I don't think we're at ineffective assistance of counsel. I do not like counsel's style, but there is no argument, I think, that can be reasonably made that these attorneys did not do work. They had strategy. They did work. They made strategic decisions. They objected to evidence. They did extensive pretrial litigation. Ineffective assistance of counsel is you gave me the exact same defense that I would have gotten from a pet rock. So when you're thinking about ineffective assistance of counsel, if a pet rock was sitting with you at counsel table and it's indistinguishable from your lawyer, that's really the circumstance that we're getting to IAC. They have to do literally nothing. In some of the cases I've seen, attorneys were like sleeping through most of the case, or like showing up or forgetting to show up, or never showing up. It has to be that your attorney did not do the things they need to do. And then you can also get these little nuances where they did not make necessary motions. Like if you got to the end of the prosecution's case and they just did not make a motion to dismiss or directed verdict or whatever they call it in a given jurisdiction, if they did not make the necessary motions at the end, that can also be IAC if they did other things. So there are some narrow instances where if they don't make particularly egregious legal arguments, or it's particularly egregious that they don't make a legal argument that has to be made, that can be IAC. Not advising your clients of things sometimes, but it's not that they are, that the stylistic choice is not great. You do not have the right to, the world's greatest attorney ever. You have the right to counsel. And so the boundaries of what counsel has to do are specific. You have to read the file, review what the witnesses are going to say. But the bar to get to IAC is incredibly high. And what counsel has to do is basically nothing. It's incredibly low. Like Daryl Brooks sitting next to you saying, objection, there's no jurisdiction, this is Admiralty Court, might pass that bar in some states. It might. It might. So what lawyers have to do is almost nothing. And getting to IAC is high. Stylistic choices, strategic choices, a bad strategic choice is not going to get you to IAC. But things like not making a motion to dismiss is not a strategic choice. It is an error. I hope that makes sense. So I don't like the stylistic choices that were made in this case, but choices were made. A defense was provided. You can't argue that I don't think there's an argument that there was not zealous advocacy. They definitely pushed back on the court's orders and at some points got leeway. They didn't always cite the case law, but the court swooped in and did that. So there were times that the defense had some rulings that were very much in their favor, even when the court was frustrated. And that's another reason why I think judicial temperament matters so much. And they did a ton of pretrial litigation to keep things out. So yeah, no, they absolutely worked. We'll see how it goes with the jury, but they have a difficult case, I think. I do not think the defense has an easy case here. I think the defense has a difficult case. I think that the prosecution had some things happen in their case that could have been better, that they couldn't do anything with either. The prosecution has the IO they have. Not much you can do about that. You got who you got. And they had a witness that was I think a very good witness for the state pass away in a motorcycle accident. It happens. It's unfortunate when it happens, but it happens. And it makes their case more difficult when stuff like that does happen. Is the case stronger if another witness comes in and corroborates Carmen Lauber? Yeah, absolutely. Was that going to happen? No. Because unfortunately, it happens. So, and that's unfortunate because then again, it's frustrating to look at the things Kouri was doing and be like, but the jury doesn't even know everything Kouri was doing. No, they don't. They don't know everything that Kouri was doing. There's argument that they don't know everything Eric was doing either, and that's what the defense was trying to argue today. And the judge entertained it for a very, very long fucking time. Whew. It was a lot. I am trying to go through to questions. Sally Sweet said, can we tag Ramos in? I'm surprised we didn't see more from Ramos at the end of this. But then Ramos made the motion to dismiss. And I think it was a different demeanor today. And I wonder now, I'm going to answer this real quick. I wonder now if part of the reason Ramos seemed a little, I don't want to say shaky, but Ramos seemed a little out of sorts in making his motion to the court. And I wonder if it's because the decision had been made to have no defense. Subdued, I think is, yeah. Off kilter, subdued, yeah. A little defeated, yeah. And I wonder if it's because the decision had been made prior to that they were going to put on no defense. And I wonder if he agreed or not. And maybe it's not the argument to the court that was impacting his demeanor, but it might have been that he was ready for their tech experts and their experts and wanted to run more of a defense and disagreed. That's purely speculation on my part. Ramos could have the flu for all we know. So who knows? but it was different. So we'll see. But again, part of working with a team is that at the end of the day, somebody gets to make the call. And you don't always, you might not always agree, but somebody has to make the call. And that should be with the input and discussion with the client 100%. So let's see. Melanie asked, if Kouri testifies, can the prosecution ask about all the fraud? They can ask about more of it, but there would be some boundaries to that, but they could ask about more of it. Samantha said, we found it. It's in the victim's stomach. I mean, it was a pretty pointed answer from the IO today. You didn't find any fentanyl. It was in the victim. There was a lot of fentanyl in the victim. There was no more in the house, which again is not what OD scenes look like unless somebody has cleaned up the scene. I think we're going to hear the prosecution get into the pack. Matthew, thank you for the 50 gifted memberships. That's incredibly kind. Thank you. We will blame you for slow mode being broken today. I'm teasing. I appreciate that. Thank you. Welcome to all the new law nerds. But I wonder if we will hear more about A, what was in the victim system, but B, that all the trash cans were emptied. When law enforcement got there, every single trash can was empty. So if every single trash can was emptied and there were no pills anywhere, I imagine the defense's argument on that is, well, if she wanted to stage a scene, she could have staged it better. But there's a lot of activity on Kouri's phone. And all of the trash cans downstairs were completely empty. I think my house has completely empty trash cans for 30 minutes max. So it's interesting that if somebody came and cleaned the house during the day, you still have 3 little kids at home and you still have 3 kids doing evening things, dinner and what have you. And then when law enforcement gets there at 3:30 in the morning, 4 a.m., all the trash was empty, all of it. Interesting. And I think we will hear from that too. So, Mofin said, I don't think she thought they would do an autopsy. I don't disagree. I think Kouri was surprised that the coroner was going to take Eric and they weren't going to just get to bury him. And I think that's why Kouri was probably talking all of a sudden about doing a cremation. So there's also that 15-minute window that we're going to hear more about, I'm sure, at closing. And then the memes. I wonder if the prosecution will end. What do you guys think? Do you think the prosecution ends with the memes again? Because the prosecution will close, then the defense, then the prosecution should have a rebuttal. I think Massachusetts is the only place I've seen that doesn't do it that way. But we should have the prosecution, then the defense, then the prosecution. Will they end with the memes? Ladies and gentlemen of the jury, the morning of March 4th, Kouri Richins' thoughts and memes were idiots everywhere. Don't prove her right. Is that a little heavy-handed? It might be. I haven't been looking at the jury for 3 weeks. The prosecution has. Don't prove her right. You heard her on the call. O'Driscoll's an idiot. She called a couple other people idiots. She said idiot a whole bunch. It's her, you fools. Idiots everywhere. I think it'll be interesting to see where those memes come into play because the defense is going to try to say she was closing on a house. So who are the idiots? The people that are lending her money then? Who are the idiots? I also will be curious to see if the prosecution brings up Allie Staking saying Don't eat what Kouri gives you. Kouri's friends were standing around talking to Eric. Don't eat what Kouri gives you. Well, unfortunately, Eric Richins did. And that seems to be why we're here. And Allie told you. She tried to play it off like jokes. Maybe it's because it's too horrific to think that your friend would murder their spouse. So it's just jokes. Yeah, well, is it really just jokes? Is it really just memes? Is it really just other people's money? Is it really the THC gummies? Is it really the open marriage affair with Bryce? Is it really just jokes? Or is it the truth leaking out? Because they knew. I guess we'll see. Because no gummies were found in the house when they were searching it the night of Eric's death. Right. So, let's see. Music Addict, great question, asked, is who else but her a way to get to guilt? I offer you Murdaugh. Motive, opportunity, plan. You will hear about it in the jury instructions. Motive, opportunity, and plan. Who had the opportunity? Who had the motive? Who had a plan? So, yes, there needs to be more than who else. But there are two people in that, there are two adults in that house, and one of them is dead. Did they ingest something on their own? Or did Kouri make him a drink that evening and nobody listened to Allie saying, don't eat what Kouri gives you? The defense is going to argue, we don't know who made a drink. Eric could have put Kouri's prescription in his drink. But if that's true, then why isn't Kouri saying to EMS, I think he took some of my Seroquel to sleep? I think he took a pain pill? Because Kouri has said in all these letters she knows that Eric has a drug issue. Then why aren't you telling police when you're trying to figure out what the fuck happened to your husband? And why aren't you doing CPR when you say you are? Why are you lying about doing CPR? Why lie about doing CPR if you're freaked out? Okay. And trying to lean into, well, Eric had a drug problem. That's not what the autopsy says. The autopsy does not have the pathology that indicates that Eric was taking a lot of prescription pain meds or a lot of pain meds at all. So, Casey Cat said, Mr. Bloodworth, Purple Tiger, the law nerds are making requests. I mean, y'all said in Biggin and it happened the next day, so I get it. Mr. Bloodworth I can't say was, this case isn't over yet, is a very precise prosecutor. And I appreciate it. There was some very artful questioning. And I think that the amount of people involved in this case made it not the easiest case to present in an orderly way. And I think that the prosecution presented the case in a very orderly way. A lot of you were saying he's an addict, but she's like telling everyone he's a mountain goat or whatever. He's so healthy. I know. I'm kind of mad we didn't get to see Bloodworth do cross-examination too. I am. I'm a little bummed about it. But they're going to have the whole weekend to work on closing. I'm very interested to see that. Also, what do you guys think of sending the children's book to the cops? I don't know if it was Mom or if it was Kouri, but either way, it's fucking wild. It might have been Mom, but what are we doing? Like, what are we doing? Sending the children's book. Wild, wild, wild. I'm looking at super chats with questions to kind of grab them and members chats and other questions. EDB, we know Bloodworth is watching you. What advice would you give him for closing? Oh, I don't think I have any advice for closing. I had some questions. I think you stay in your lane. They know what the defense is going to do. You never write your closing to the defense. You write your closing to your case. And then maybe plan the last few things you want to end on at your rebuttal. And then address their rebuttal at the beginning. But the pacing for opening was really good. I think the prosecution has done a really good job this case of trying their case. They've like, you run your own race, follow your own arrow, whatever analogy, stay in your lane, whatever analogy you want to use. I don't think the prosecution tried their case to the defense. They tried their case and let the defense respond to them, versus what we saw, I think, in both Karen Reed cases most clearly, is that the Karen Reed prosecution felt like it was playing whack-a-mole with what the defense was doing instead of just putting on a case. And there are prosecutors that will get pulled into what the defense is doing. And these prosecutors have kind of stayed above the fray. They've responded when the defense is like swirling into whatever, but they haven't gotten sucked into it trying to play whack-a-mole with it. And it's effective when the defense can pull the prosecution into the chaos. And then it feels like the case is completely disjointed. The prosecution didn't do that at all. They just stayed in their case and kept it, I think, as succinct as they could without it being too succinct. The way that the Banfield case, at times the Banfield case felt too succinct. And I imagine there will be some of you that probably feel like this case was also too succinct. That the prosecution maybe cut down too much. And I think that's fair. Because we got to the end of the case and the door came slamming shut and it was like, wait, fuck, that's it? What the fuck? We're done now? It's fair. Because they kept it succinct. But they know their jurors in their case better than I do. But it was succinct. And, excuse me, I wanted some of the lab results. And I thought there would be some more jail calls. I'm kind of bummed about that. But that's T. I wanted more jail calls. Do I think they need to? I don't know. But no THC in the system. I think we're going to see the prosecution tie together their case in closing, even though all the building blocks are there. In a way that I'm interested to see if it surprises some who are like, I forgot about this, I forgot about that. Because again, we got pulled a bit into the defense swirl as well, because we're like, what are they even doing? Why is it all swirling? Stop it. But a lot of that was outside of a lot of the roller coaster was outside the presence of the jury. So I'm really excited for closing. And we'll see. But the defense, we'll see how the jury resonates with the things that they pull out of this case. And if the jury believes that those alternate explanations are reasonable or not. But no matter what evidence the prosecution put in, there's, with the memes, there's photos of the house and there's memes. There's no other evidence that's going to change that exists. So there's not much else they can do with that. So a lot of you are asking, can any rebuttal come in if there's no defense case? No. They can have rebuttal argument after the defense closing, but no, they can't. Let's see. I am looking for just a few more questions and then I'm going to go. I don't know if the juror issue was resolved. We never heard anything about it again. And I didn't see anything put on the record anywhere. So it must have been resolved. Or everybody forgot about it. Or that juror is going to be the alternate that gets yeeted. We'll see. And that's possible too, because they do have a number of alternates. And they have 12 jurors. I think they still have 12. And we'll see that only 8 testify for a verdict. So with all of that, Lauren said Lewis doesn't look happy about resting. I don't know, the dynamics of the defense team, I can't always read, so I don't know. I was surprised when she said we have a few options. I don't know what options, because I would imagine they would have dealt with that over lunch. So I was surprised as well. But I think you could hear with Ramos that there was just like, there was heaviness. I don't disagree. Kouri looked a little shell-shocked. Do you want to, here, let's look. Before we wrap up, let's just go look. Let's just see. Let's go look and see if we feel differently about it now. Because I can't imagine they're still making that decision in the moment. But Kouri looked like she wanted to, like we're back to other people's puke. Kouri looked like she was going to throw up. Maybe I'm reading too much into it. Maybe I'm not. But she did not look happy. Let's see. That's when the jury came back in. I'm trying to find where they told the court that. So let me just, I think we're just about there. Emily, you can't say we're almost there. It's been too much of a fanfic kind of a trial. All right. We can take a look.
315000139.
Let's just take a look again.
State's counsel and defense counsel are present. Ms. Richins is present. Mr. Bloodworth, would you like me just to tell the jury
I don't know why it froze.
when they come back in that the state has rested?
That's not helpful. Everything froze. Hold on, let me just refresh that. It completely froze. That wasn't you.
Or actually this time.
All right. It wasn't you. It was me. Well, it wasn't me. It's like, no, we're not rewatching this again. We're done. What are they doing? Just absolutely frozen. Let's try that one more time. All right. The court asked Bloodworth if he wants to put that he's resting on the record when the jury comes back. And that's where we're
Mr.
at.
Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yes, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
Because even Kouri's leaning forward like we are. Like Kouri is sitting as straight in her chair as we've seen this whole time. It's just the vibe is so different.
Who's defense counsel's first witness?
Let me back that up one more time. Emily, are we overanalyzing this? Probably.
Would you like me just to tell the jury when they come back in that the state has rested?
Probably.
Yes, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
Everybody kind of looks at Nestor. Kouri's looking at everybody. Lewis is like,
Wait just a minute.
Yeah.
We have a couple of options.
Understood.
Ramos looks like he's biting his fingers. Wait, no, go back.
Or actually, this time, the defense intends to rest.
We should probably do that in front of the jury.
Ramos doesn't even look up until the end.
I just want to make sure you've consulted with your client about this.
Oh, Kouri does not look surprised at all. Kouri looks like she's going to be sick, but she does not look surprised. I think she looks kind of scared. Like, it's a big move to make, but I don't think she looks surprised. Well, actually, Your Honor, we're done. Yeah.
We should probably do that in front of the jury, yes.
Right?
Okay.
I agree.
I just want to make sure you've consulted
Yep.
with your client about this.
Absolutely.
Right. They're not
Is
making this
now an
decision on the
appropriate
fly.
time to get a waiver.
Yeah. They're not making the decision on the fly. And I think it's appropriate of the court. Yeah. Nestor looks like she's trying to hold in a smile. But they're not doing this on the fly. And I can understand why the court is like, you've had a chance to talk to your client, right? Because y'all are whispering here and are like, we have a few options. No, we're not putting on any witnesses. You talked to your client about that, yeah? Okay. Aurora asked, 1, fully believe Bloodworth is speaking to the Lawnards, and 2, can we get an OPP list in the lounge? Yes, we are working on a playlist. We have had so many phrases this trial. Might take us a minute, but we can work on it because we had a bunch of them. AE3 asked, thank you for the super chat. Would this be the rare case you'd consider recommending the defendant to testify? No. Seems like trying to explain could be worth a shot. No. Here's why I think the only thing Kouri can do is talk herself into a conviction. This is not a self-defense case. This is not a where you would have to testify. This is 2 people in a home. One of them is dead by unnatural causes. Kouri gave multiple statements to law enforcement that can be played to rebut what she says in court. Her walk the dog letter came in, which gave part of her side of the story. It looks like she's trying to tell witnesses what to say. It looks like she's coaching people, but also it gives the defense room to argue her words because it's in evidence. Eric was putting things in her bag. It gives them an out without putting her on the stand and proving that what she says is bullshit. It is incredibly rare that in a take self-defense cases out of it, in a non-self-defense case, that a defendant testifying is going to be the thing that clears them. I think more often than not, when the defendant testifies, it eliminates all doubt for the jury. And if the defense has done a good job peppering in doubt and other reasonable explanations, the defendant testifying just slams all those doors. Other witnesses, if Ronnie really had text messages showing that Eric was doing all of this stuff and they'd had all these conversations, then yeah, Ronnie can testify and do that. Bring that in, bring those texts in, go ahead. If there's really an investor that Kouri's buying pills for from Carmen, go ahead. But Kouri's texting people, oh, I need these for an investor. Oh, Carmen, I need these for an investor. And then in the walk the dog letter, she's like, Eric asked me to buy them. So you start getting all of these areas where Kouri can not really help herself, but can accidentally hurt herself. Like Murdaugh. And as you guys are saying, like Murdaugh, like Banfield, like Sarah Boone, like the examples continue to go. Let's see. Kim asked, do you think Bloodworth held evidence back in order to bring it up in rebuttal? I feel like that would have been a huge error. I think there is evidence that they had planned for rebuttal, not in their case in chief, that would only come up if certain other things happened. So this isn't something that's going to come up unless A, B, or C. That is what you keep for rebuttal. If they do A, then we do B. But you do not hold back things from your case in chief to spring them forth, because there is always the expectation that the defense will put on no case and you won't have a rebuttal case. And so you prep your case, assuming that there won't be a rebuttal case, and then knowing that if the defense uses some of those witnesses, how you'll rebut them, that becomes like plan B. That is never plan A, or at least it shouldn't be. It shouldn't be plan A, because it's dependent on what the defense does. And if you plan your case for, oh, we're going to save this and like spring it forth later, the defense can just not put on a case. And then if you didn't put in everything you needed, you might not meet your burden. I think most prosecutors go into their case looking at meeting their burden and what they're going to argue in closing, and then planning for what if the defense puts on a case, because it's rare that they do. So, Claudia said, what happened to all the other people who were held under subpoena? They are released from subpoena now. And generally, the prosecution will say you guys are released from subpoena. I'm still surprised that the defense, actually, no, I'm not. The defense never asked about the catch poll. They kind of left it at the beginning with the witness who was bad, never brought it up with O'Driscoll because they didn't want to let him explain. They just kind of left those things hanging. Interesting day in court. So, Miss Casey Miller said, Emily, how do you think the defense will explain away bestie Chelsea? I think they don't touch it. I think they don't touch it with a 10-foot pole because it's so bad. But it's a big misunderstanding. Kouri held on to that money so that she could close on the mortgage. And then she was arrested. It's the cops' fault. If she hadn't been arrested, none of this would have happened. They're the ones who messed it all up because they arrested her. But I think the smarter play is to not touch it and to focus on how Eric got fentanyl in the system and not bring it up at all. Yeah. That's what I think. But we'll see. Lisa Bowers asked, did I notice Kouri's breathing? You can see the jacket moving, very nervous. Of course she is. That doesn't surprise me at all. That is a huge decision to make, and there's no way to know it's the right decision. There's no way for Kouri to know it's the right decision. I think it's strategically the right choice, but it's also really hard if you want to fight. It's hard to sit there and feel like we're stopping. It's hard to stop, especially if it's like, but I want the witnesses to come in. That is not the best legal strategic decision. And I'm sure she's nervous. She has to be. She's facing going to jail for the rest of her life. Of course she's nervous. And even if she doesn't go to jail for the rest of her life, then what does that look like? Do you go through the courts and fight to get your kids back? I don't think any of the options here are easy for her. And she might not get out of custody because she has pending cases. She has another criminal case behind this. So it's just, there's not any good, there's not really any good option for her. So of course she would be nervous. Yeah, any defendant would. And I'm sure that the defense, though agents of chaos they may be, probably feel good about the decision that they made. And they're like, yeah, we're going to rest on you didn't prove it. And that's what we're going to see in closing. The defense resting on you didn't prove it. And the prosecution, I imagine, building a big old timeline of all of the puzzle pieces. It's a circumstantial case. Many are. And so you're going to see a lot of puzzle pieces in closing. One last question. My Python fan, 828. Is there a criminal financial case or is it all civil? There's both. There's all the litigation over the estate, and there is a criminal financial case tracking this one that has, God, is it 16 counts? We haven't looked at that in a minute. I covered it when it was filed. It has, no, I was wrong, 26 counts. That's the one with the mortgage fraud, the money laundering, the bad checks, the forgery, all the rest of it. So that case is trailing behind this case. It was filed this year. No, we're in 2026. It was filed last year. I think it was filed in 2025. It could be filed in 2024. No, June 27th, 2025. So I have a video on that where I covered that indictment if you want to go see it, but that's trailing behind this. Who do I think will be closing? Nestor and Bloodworth. Who has the kids? The Richins family. I'm not going to be more specific than that. I think that's private information, but that is who has the kids. They are not with Kouri's family. And with that, a number of you have asked, including Katie, will Bloodworth and Judge M be involved in that case? Currently, it's before Judge M. Bloodworth is the assigned prosecutor. The defense attorneys are specially assigned until the end of the murder case. And then once it's done, I think we will see this, we will see movement on that case or not. I do not think these attorneys will stay on the financial case because, well, they indicated that they won't, but I do not think they will stay on the financial case. So I've been covering the financial case. I covered it when it was filed, but it's trailing behind this one, so it's kind of paused. I don't know if it'll be televised. I don't know if everybody will. I don't know if after this case, there will still be as much interest, but we'll see. I wanted to see the rest of the interviews too, chat. CC, last comment, super chat, and it's just not pulling up. CC, I'm so sorry this won't pull up. Wait. No, it was there and then it wasn't. Either way, CC said, does anyone else notice each time fentanyl is mentioned in the walk the dog letter, the writing is much teenier, looks squeezed in, like it was added later, maybe not part of the original letter? I don't think so because A, we've seen multiple attorneys argue that letter. None of them have ever argued that. I imagine if there was any indicia of that, it would be the first thing they would be arguing. I think the reason it is written so carefully is because Kouri was not comfortable with the spelling or ran out of room and was trying to squish in the full statement, like erased and tried to put something in. But yeah, the handwriting does change. It's not so loopy, but I think that is Kouri, not anyone else. So that would have come up. It's never been alleged, insinuated. Sky's never said it. It's never come up in pretrial motions. So no, I think Kouri was trying to squeeze things in because I think she probably originally said that Eric told Ronnie he gets pain pills from Mexico. And then she went back and tried to add pain pills and fentanyl to make it better for what she wanted her mom to say. So I think that was also Kouri. Yes, the writing changes, but I think that was also Kouri. So, Law Nerds, it has been a long day. It has been a wild day. I will be back tomorrow afternoon. Why? Because I love watching the arguments over jury instructions. They are illuminating. I expect that will be streamed tomorrow afternoon. I will stream it. We will talk about it together. If you think that jury instructions are boring, nay, nay. As Bailey Sarian would say, nay, nay. There's a lot to be learned in how they argue over the jury instructions. So I'll be here. I hope you'll join me. I'll let you know in the Law Nerd app because that's where we start to see how the instructions are going to come forward and what we're going to see. So I'll see you guys tomorrow while we talk about jury instructions. It's a very, very important part of the case. And we'll have some good conversations about what needs to be proved before the jury. And then you can start thinking about what the elements of each crime are. You'll hear those talked about a bit tomorrow. And where you see the facts kind of filling in on those elements of each charge. And I will see you guys tomorrow. Mods, thank you. Team Baker, thank you. What an unexpected fucking day, y'all. And just like that, court's done, evidence is closed, and closing arguments are Monday. Sure. Great. Why not? Why not? A lot of you are asking for a flight home. Fair enough. Fair enough. Flight home. I'll see you tomorrow afternoon. Thank you for joining. We had multiple flights. It just glitched. Please accept EDB Air's apologies with some extra EDB Air miles. See you tomorrow. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnerd.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Lawnerd.